Few matters that need to be handled before we get started. Mr. Cruz, the court did not hear from you or anyone on your team yesterday, and you had said you were going to keep us posted. I sent out an email not only talking about court, but also needing the information for your WebEx witnesses, and we heard nothing, which was a bit unusual.
I didn't see the email. Please forgive me. My wife was in the hospital. So I came and heard the hiss. I saw the last message I saw from the court was saying that we would be in court at 9 a.m. in the morning.
Right.
That was sent yesterday. But please charge it from my mind and not my heart. It's a lot going on with me this week. My wife was in the hospital with me being here. So just please forgive me. I wasn't on my
I just assumed Mr. Hill would respond since he's attorney of record also, and I don't even see him this morning, but I put him on the email too, so I thought he would communicate with the court.
I can't speak to Mr. Hugh, but I know I didn't provide him any updates, so I take responsibility for that as well.
Okay. All right, thank you. All right, are you ready to proceed, Mr. Cruz?
I like to take and see where our witnesses are.
Well, we got to get into some issues before we do that. So, all right. So the first few things are this. This gentleman sitting right here, I need to know, is this young man an attorney?
No, Wilson is my law clerk.
Okay.
So this is my law clerk. This is my paralegal.
Okay.
They're the this case.
Okay.
These witnesses there.
Well, I understand that, but they are not allowed at the table during trial. So you're going to have to sit back on the benches. The other issue that I want to discuss, you both are going to have to sit on the benches. It is not allowed to have non-attorneys who haven't entered an appearance be at the trial counsel table.
Can't sit here either.
No, sir. They need to be back. The other thing is that one of the issues that I wanted to raise to make sure we're all on the same page, and this gentleman right here, I don't know your name, sir. I'm sorry. What's your last name? Evans? All right. Mr. Evans and Mr. Cruz, I know that you needed some information from Charlene Satterfield, who is our court reporter. You asked her when we were on a break, both of you at different times, for information for her to play back things from the record. That's not appropriate. We are in trial. If you need something from the record, it has to go through the court. And I want both of you to understand that it's definitely not acceptable for a paralegal to make a request like that at all. But it's definitely not appropriate for an attorney to do that without going on the record, either making a motion, asking the court, things of that nature. All right? Thank you. All right. I have the jury coming in later, and so this is the time for us to take up some other matters. We've just gotten the state's charges. Mr. Cruz is sending the charges to Miss Ellis, so she's going to get those compiled. Counsel, what we typically do, and good morning, Mr. Hill.
Good morning, Judge.
What we typically do, and counsel for the state knows this, but counsel for the defense needs to understand this, is we will send you all a copy of the combined charges in one big document online. You'll get that on your email. So hopefully it'll be easy for you to look at it. When we do our charge conference, we'll print the entire thing out. Everybody will have a copy. We go through from front to back. So for Mr. Cruz and Mr. Hill, on jury charges, I always include for the court's charges the standard charges that every superior court uses in every criminal trial. And so all of the definitions, for example, for reasonable doubt, for just as an example, evidence, the burden on the state and things of that nature are always included. You certainly can include those in your charges. If you don't agree with how the court does its typical charges, we'll certainly consider whatever you present. But I just want you to know, if you want to bypass the typical charges that are involved in every criminal trial, you certainly can do so and focus on the charges that are in the indictment. So that's kind of our process. I don't know when we're going to get to that, but I want to make sure you all know that it's going to be a big document for you to look over, and we sort of go through it page by page. All right. Let me ask the state, are there any other issues the state needs to bring up? I want to talk to Mr. Cruz about his timeline in just a second.
Your Honor, we'll have a couple of different motions in limine that we would ask the court to consider this morning prior to witnesses taking the witness.
Okay.
Whenever you would like to do that.
Mr. Cruz, I'll hear from you in terms of your witnesses. We're going to need certainly the information for your WebEx people. And so I'll hear from you in terms of your witnesses, how long you think this is going to take. You may not know. But if you have any idea of where we're going, certainly.
I think we'll be done by noon. I still have to talk with the team to figure out exactly what order we're going to put individuals in.
Okay.
As far as the WebEx information, I can provide that to the Honorable Court now.
Okay. We're gonna get. It's one of the reasons why I have the jury coming in a little bit later this morning is we need to get that set up.
Yes, ma'am.
Because I didn't have that information yesterday. So if you can actually send that by email right now to Miss Ellis, we're going to get that to Miss Craig, who is in the other county. She's in Oconee County, helping to handle court out there, and we will get her to set it up.
And I need to call her. She's not local. I think I advised Honorable Court of that, so I need to call her just to let her know that.
When we're ready to roll. Sure, absolutely. But if you'll send the emails where we need to send the WebEx, I think we'll put both of them on for the same time. Well, I don't know if we should do that. Let me think. Let me ask you this, Mr. Cruz. Do you already know the order of those witnesses? Which one's going to go first?
I don't. I need to speak.
Okay, all right. I'll let you do that. Do that and let me know. I think I'm just sort of thinking out loud. I think that's better for the WebEx, that we'll try to do it in the order that you're going to call them, so they're not both on the same WebEx at the same time.
Okay.
Yeah.
Wait till the motion in limines because that may
Okay. Sure. All right. Very good. Any motions you want to present, Mr. Yelman-Chile?
Yes, Your Honor. Thank you. My understanding is, at least in part, we're not sure who all of the witnesses are going to be that Mr. Cruz calls, but it is my belief that he intends to recall Detective John Newton, as well as call Detective Mike Tyndall and Kashana Armstrong. As it relates to Detective Tyndall, the state would make a motion in limine regarding any testimony about alternative suspects other than Mr. Melton, as has been referenced several times during the trial of this case. In pretrial motions, the state filed a Saudi motion. Mr. Cruz identified only Chris Melton as an alternative suspect that the defense would offer before the jury. Detective Tyndall, I think it's actually Sergeant Tyndall, if I'm recalling correctly, is a law enforcement officer now with the Oglethorpe County Sheriff's Office. At the time, he was with the Athens-Clarke County Police Department. In part, he interviewed individual by the name of, Stephen Barden, who was a law student at the time, and he also interviewed an individual by the name, I believe, of Anthony Little, who was a resident of Athens-Clarke County at the time. These individuals were interviewed as initial persons of interest, but no evidence was ever developed to link them to the crime. And therefore, in addition, Mr. Cruz hasn't provided notice through in response to the state's Saudi motion, so no evidence of anything related to those two individuals would be relevant, and under a 403 analysis would be confusing and misleading to the jury. So we would make that motion in limine. Also, it's our belief, and obviously we do not know this for sure, that Mr. Cruz may be intending to attempt to question Mr. Newton and Sergeant Tyndall regarding certain phone records for which there is no records custodian who has appeared on the witness list in order to testify to authenticate those records, and no notice of intent to introduce the records without a records custodian has been filed. Obviously, we ran into this issue with another witness, which is why the state is making a motion in limine at this time that those records should not these witnesses do not have the ability to authenticate those records in an appropriate way to lay the foundation for their admissibility. And so those records should not be used as a methods of questioning these witnesses or raised as far as their contents in reference to the questioning that Mr. Cruz would do, or, even if they're not admitted into evidence, the information in them cannot then be used in the questioning in an effort to introduce hearsay evidence through questioning of witnesses who aren't able to lay the proper foundation for the admission of those records. So those are the motions in limine that I wanted to present, Your Honor, and I know that the way we've split up the cross-examination of possible witnesses that Mr. Cruz may call, if I could have just a moment to consult with Mr. Bolden.
You can, but you were talking about the phone records with regard to the witness. Mr. Cruz is calling Sergeant Tyndall, is that right?
Sergeant Tyndall and Mr. Newton.
And Mr. Newton, okay.
In the recall, I believe there was an attempt the first time that Mr. Newton testified in order to introduce those business records, and the court made a ruling that there was not a proper foundation laid for their admission, and then they could not subsequently be used in the manner that Mr. Cruz was attempting to use them, basically making a motion in limine to continue to adhere to the court's earlier ruling and prevent that process from playing out in the exact same way again. And then it's a similar argument with Sergeant Tyndall, because I think that those two witnesses are similarly situated as it relates to the phone records and their inability to testify to foundation for admissibility of those records.
All right. Thank you. And you may have a moment, Mr. Bolden, and then I'll hear from you, Mr. Cruz.
Okay. Your Honor, Mr. Bolden will be making a motion in limine as well.
All right.
Good morning, Your Honor.
Good morning.
Yes, Your Honor, just to kind of piggyback on what Mr. Yalamanchili was just discussing, this is specifically as it would relate to John Newton's testimony. One of the things that the state expects that the defense may try to elicit through its direct examination of Mr. Newton is the fact that he had a conversation on January the 25th of 2001 with an individual by the name of Jessica Gann. That's Gann. Miss Gann, I believe, well, what's in the report is that she called and spoke with then Detective Newton on that date, on the 25th of 2001, January the 25th of 2001, that she was at Mexicali Grill over on the east side near Kroger, and she heard some girls in the bathroom talking about law school. They appeared to be drunk. This was at about 9:30, and she thought one of them may have been Miss Baker. I think Mr. Cruz actually referenced that in his opening statement. The state would move to exclude any testimony by Mr. Newton as it relates to his conversation with Ms. Gann. First of all, it would be hearsay. And second of all, even if there were an argument that it is not hearsay, and I think that frankly the analysis should end there, but even if the court were to find that it is not hearsay or it is an exception to hearsay, at this point we would object on grounds under 401 and 403. It's not relevant, and any conceivable relevance is substantially outweighed by the risk of confusing the issues and misleading the jury. And in that regard, I would point out that the uncontroverted evidence at this point in the form of the testimony of Ms. Lonstein last week was that Ms. Baker was in the law school library until at least 9:46 when Ms. Baker called her to make sure she got home safely. And so the idea that she could somehow simultaneously be at a Mexican restaurant on the east side under the influence of alcohol is just not borne out by the facts. So the state would object to any testimony, any attempt to elicit testimony from Mr. Newton regarding that conversation.
All right, thank you. Anything else?
No, Your Honor.
All right, Mr. Cruz, several motions on the table. Go ahead, sir.
The only two that I'll address is first I'll start with, and good morning.
Good morning.
First I'll start with Stephen Barden. I do intend to introduce that evidence, Your Honor, and not for the purposes of showing him as an alternative suspect, but for the purposes of showing that they had Mr. Chris Melton and this evidence leading to Mr. Chris Melton. And instead of executing a search warrant on Mr. Melton, the investigators decided to terrorize Mr. Barton and execute a full-blown search warrant on his house, obviously because he had nothing to do with Ms. Baker's murder, turning up no evidence of her murder. But these same actions were not taken with Mr. Melton. So the sole purpose of that testimony would be simply to, as we stated in opening, as we've maintained this entire trial, just to show that this investigation was not thorough. It was directed away from Mr. Melton at every twist or turn. In regards to Mr. Newton's testimony, in regards to Jessica Gann, as far as hearsay, we're not offering Jessica Gann's statements for the sole purpose of the truth of the matter asserted. Similar to the questions we asked about Ms. Keishana Armstrong, we're offering the information about Ms. Gann, again, to show that the investigation was not thorough, the early investigation. Law enforcement was aware of this information. They did not provide Ms. Gann with a photograph of Ms. Baker. They did not do any type of, I don't want to say a lineup, but they did nothing to follow up on the information with Ms. Gann. They got the information, they just ignored it and moved on. And that information also impeaches the state's position. The state's position is simply that because Mr. Faust's DNA is present, that means he's responsible for every single count in the indictment. One piece of evidence they have not shown, they haven't presented anything showing where Ms. Baker was the night before her death outside of the library. And in regards to the time piece, I think that's more appropriate for cross-examination as opposed to a motion to limine. And the reason why, Your Honor, is the state has defended multiple witnesses on their time discrepancies, even time discrepancies that occurred closer to the crime. I believe Ms. Gann might have been interviewed, I believe it was 7 days after. So if she wanted to give and I believe the state made this argument in regards to a particular witness. I can't remember the witness. But if she wants to make an approximate time, hey, I believe it was 9:30, maybe 10 o'clock. I don't know what she said because we only have the report, but I believe it was around 9:30. That's something they could flesh out with Detective Newton during cross-examination, Your Honor. So those are the only two motion to limines we would seek to address with the Honorable Court. In regards to the phone records, the Honorable Court knows my position with the records. I respect the Honorable Court's ruling. I think you've made it clear that we are not to present any phone records of anybody at any time. So that's an issue that the Honorable Court has already ruled in the state's favor on. So we disagree, but we follow the Honorable Court's ruling.
All right, thank you, Mr. Cruz. I'll start with the phone records. The issue with the phone records was not necessarily a blanket instruction to prohibit testimony of phone records. The ruling was based on the lack of defense counsel's, for whatever reason, lack of providing the proper witnesses to bring those phone records in. And without the proper witnesses subpoenaed by the state, phone records are not allowed under law. And so that's the ruling I made. I want to make it clear for the record that the court's ruling was not a blanket. The defense cannot bring in phone records. Certainly, there might have been, if you had subpoenaed the proper people to bring them in. We could have had another hearing as to whether they were relevant. I mean, I'm not making a comment that they would necessarily be admissible, but just the ability to talk about them is based on the lack of ability to produce the proper foundation. I know we argued that at the bench, but I want to make that clear.
Can I respond to that?
You may.
The state, we had a hearing on this. I asked for out-of-state subpoenas regarding the phone records. I advised the Honorable Court at that hearing that Sprint, and I believe, I can't think of the other company, but the companies were out of business. They sent me emails stating that because the records were so old, they did not have a way to verify those records. The state explained to the Honorable Court that they would I'm looking for the proper word, but I don't have it now, so I'll just say they would agree to that for foundation purposes, the records are admissible. They said they would object on hearsay grounds, things of that nature. But our argument was that the records aren't hearsay because they are computer-generated records as opposed to a statement by a person. Just to put that information on.
Well, let's talk about that because we did have a hearing with regard to those issues. There are a lot of phone records that we were sort of talking about at the time.
Correct.
So let the state respond. We can talk about that. Go ahead.
I'll be happy to respond, Your Honor. That hearing did occur. At that time, we had been in for several weeks, I believe, attempting to discuss and lock down stipulations with Mr. Cruz, and it was the state's belief at that time that we were going to be in a position where Mr. Cruz was agreeing to stipulate as to the foundation for certain crime lab reports, and in exchange the state would be willing to stipulate to certain phone records and also crime lab reports from North Carolina in the form of some mitochondrial DNA analysis. However, Mr. Cruz never gave the state a response despite repeated requests to give us an answer as to whether or not we had stipulations. I drafted a list of proposed stipulations and I gave them to Mr. Cruz in the form of a physical document, I believe on the first day of jury selection. After reviewing that document and consulting with Mr. Faust, Mr. Cruz informed the state that at Mr. Faust's direction, the defense was refusing to stipulate to anything. So an offer was made and denied by the defense. And at that point, there were no stipulations, and the state has endeavored to call the appropriate witnesses to admit the evidence that it intended to admit via stipulation, and was certainly something that was available to the defense as well. But as the court noted, for whatever reason, those witnesses haven't been present in order to lay the foundation. So that's the context in which stipulations were discussed and then refused by the defense.
All right, thank you. Anything further, Mr. Cruz, based on Mr. Yellman-Chili's comment?
No, ma'am, that's accurate.
Okay.
We refused stipulation made by Mr. Yellman-Chili. Correct.
All right. Thank you, sir. So I think based on that, and I do remember certainly the hearing, I can go through and look at my notes. They aren't in front of me at the moment and the order that the court signed. But I would just say, I mean, I'm going to grant your motion with regard to the phone records, Mr. Yellman-Chili. I think that is appropriate legally at this point. If a stipulation is not entered, as was announced in court that you all would be able to work that out, the court would have had to know that in order to specialize or set a special time, I should say, to hear the rest of your motion, Mr. Cruz, to decide whether your motion was appropriate and whether what you were asking for could be granted, and that hasn't been done. I can't do it certainly in the middle of trial. So I'm going to grant your motion with regard to the phone records. With regard to any testimony from Mr. Newton with regard to a witness that you wanted to call, Jessica Gann, let me ask you this so I'm clear on what you're saying. Well, let me just ask you, what is your position on the state's objection about hearsay? Yes. I mean, they've objected on other grounds as well, but what about the hearsay?
It goes to notice. That's my response. It's not hearsay because it goes to notice. That law enforcement was on notice about this information and they didn't follow up on it. We're not offering for the truth of the matter. We're offering it to show law enforcement, which is one of our multiple defenses in this case, I think a big part of the state's case, is that law enforcement had information that they just failed to follow up on that would have resolved this case 20 years ago. So it's just notice. This goes to notice that law enforcement was aware of this fact and they didn't follow up on it.
All right. Thank you, sir. I think at this point, what the law would require, Mr. Cruz, is that if the defense's argument is that these statements that certainly I would say at this point would confuse the jury about anything that may have happened at a Mexican restaurant with a person's statements who have not been elicited in court at all. I certainly would say that under 403 we are talking about confusion of the issues and misleading the jury. I think that's certainly a problem. But I would say that at this point, Mr. Cruz, the defense would have to provide evidence to what you've just stated. I mean, a blanket statement that you're making that if law enforcement had followed up with Jessica Gann, this case would have been over 20 years ago, is a pretty spectacular statement. And in order to ask the court to admit those statements in lieu of that comment, the defense has to provide the court some evidence that that would in fact have been true. And without that evidence, that testimony that you are seeking to elicit certainly, I would say, falls under the category of misleading the jury, of confusion of the issues. And it really does come close to that line that we have been discussing this entire time, which is the order that there are to be no statements by witnesses about other suspects other than Chris Melton, which you properly gave notice to the state for. So, you certainly can respond to what I've said, and then we're going to kind of move on. But go ahead.
So 2 things. My statement, I think I may have said it wrong to take it out of context. So my statement wasn't, or it should not have been, and forgive me if I said it this way, isn't that, hey, if they solely would have talked to Jessica again, this case would have been resolved. I believe I said it the wrong way. What I was saying is if law enforcement would have followed up on all leads, this case would have been resolved. As far as the 403 ruling, Your Honor, the state didn't object on the basis of 403. I understand the court could make any ruling that it deems appropriate, but the state did not object on 403 grounds. The state objected on hearsay grounds, and we provided our response to the hearsay. I would like the opportunity to provide a response to the Honorable Court's objection regarding confusing the issues for the jury.
You certainly can. I thought Mr. Bolden did make a 403 argument, and that's fine. I'll let you respond regardless, but I think he did. But the court has an obligation, regardless of whether the state or the defense talks about 403, the court has an obligation to respond to 403. So you certainly can respond.
Sure. So in regards to 403, as far as confusing the issues, this statement from Detective Newton wouldn't require a mini trial to determine facts of issue. It's simply a building block on the facts in this case that support our position. I don't think that one fact I think we're on the 9th day of evidence, maybe? We're on the 10th day of evidence. We started last Monday, if I'm not mistaken. That one fact out of 10 days of evidence, I don't believe that will confuse the jury where they say, hey, we don't know what the heck is going on in this case. I can't believe Jessica Gann said that she saw Ms. Baker. So that would be my response. I do not believe that one fact would confuse the jury, Your Honor, and I'm not sure. Did you say waste of time also?
I did not.
You said confusion of the issues and one more.
Misleading the jury.
And my argument would be the same. I don't. Out of 10 days of testimony, and of course, the Honorable Court has all the wisdom, I don't believe that one fact would mislead the jury to making a decision in regards to the indicted charge where they say, we have this fact, now we don't know if Mr. Faust is innocent or guilty because of this one fact. So I asked the Honorable Court to reconsider its ruling under 403.
All right, thank you, Mr. Cruz. I think the argument you've just made supports the court's conclusion that any evidence regarding this Jessica Gann person, first of all, it certainly sounds like hearsay. I understand what you're saying, Mr. Cruz, that you're not offering it for the truth of the matter, but I think there's an argument to be made that you are, but I'm not finding that it's relevant. I think at this point, given the comments that both counsel has made, it would be incumbent upon the defense to provide evidence as to why any testimony by Jessica Gann would be relevant. And so I'm going to grant the motion. I'm going to find that it is not relevant. It is hearsay, and there's no exception to overcome the hearsay. Under 403, I certainly do think at this point, bringing in another person to suggest evidence that is not supported is a very significant moment of misleading the jury and confusion of the issues. And so under 403, I'm going to grant the motion as well that Mr. Bolden has made. There will be no testimony allowed to be elicited from Mr. Newton about Jessica Gann. No testimony elicited from Sergeant Tyndall regarding contents of phone records unless you can present a witness that can lay the proper foundation. Let's make this clear, though. I want to talk about this. Is there an objection from the state, let's do this right now, about Mr. Cruz asking Sergeant Tyndall whether he was able to get phone records?
And that's what I was, can I respond before this? He
Sure.
laid the foundation for the phone records.
Sure.
The court order he obtained via recognizing the phone records, via stating that those phone, that they didn't appear to be altered. So he laid the foundation for the records that he received.
I remember that. I have that in my notes. But let's just get this out now so we're not having any, problems later.
I do not believe that there is anything wrong with asking Sergeant Tyndall if he obtained phone records. However, whether the police officer got phone records back as part of his court order is not the proper foundation for admissibility of those phone records.
I understand.
And so that's what our objection is to the contents.
Admissibility in the context.
The fact that he did in fact seek a court order, that the phone records were provided, are things that I think are appropriate questions that can be answered. It's just that any contents of the phone records cannot be asked about without the appropriate foundation witnesses, as the court's already articulated.
All right, thank you. So I want to make sure, Mr. Cruz, do you have anything else you want to say about that or any questions for the court? I mean, I do think that's right. And Sergeant Lieutenant Tyndall has already testified, as you said, about those records. They are in my notes. Again, I don't have it in front of me, but
Newton was the.
was Newton?
Yes, ma'am.
Yes, ma'am. Yes, ma'am.
I'm sorry.
Sure. Got the microphone again.
Newton
All right.
was the.
It was Officer Newton?
I don't believe Tyndale has testified at this moment.
That's right. It was Officer Newton. Okay, so let me just make sure we're clear. And I do recall the testimony. It was Officer Newton. I mean, Mr. Newton, former Officer Newton. Are you intending to ask Sergeant Tyndall about phone records as well, obtaining phone records?
I am only going to ask Sergeant Tyndall about things the Honorable Court permits. From what I understand right now, that is not permitted, so no, ma'am.
Well,
I do not.
that's why we're having this discussion. I mean, I think the question as to whether an officer in his or her investigation received phone records is certainly a permissible question. And I agree with the state's characterization of that as being admissible. I think it's the contents and the admissibility of what's in the records that's at issue. So let's just flesh this out now and make sure we're on the same page.
So the contents, that's what's important to us, because I think it will establish the nature of Mr. Melton and Ms. Baker's relationship up until the day before her death. If the Honorable Court's ruling is that we are not to get into the contents of the phone records, and of course we put our response to the state's hearsay objection in regards to the phone records, so I won't go into that, Your Honor. But if the Honorable Court is saying, hey, my ruling is that you cannot get into the contents, you cannot talk about the phone records with the witness, I won't get into that.
All right. Thank you, sir. All right. So I'm not changing my ruling unless I'm presented with some other piece of information that is appropriate for the court to change its position without the proper foundation to be laid with regard to the contents of the phone records. They're not admissible in terms of the content.
Well, I do want to say this just to make it clear for the record. The foundation was laid by Mr. Newton. I think the disagreement between me and the state is saying it's hearsay, and I'm saying that it's non-hearsay because they're computer-generated records. That's the only disagreement. And of course, the Honorable Court issued its order on that.
Sure.
I just wanted to make that information clear.
All right. Thank you. So it doesn't overcome the hearsay because there does need to be a foundation laid in terms of the contents of the record. And so of the records. I'm not going to change my order on that. A foundation has to be laid. They are hearsay. And unless the witness is a custodian of those business records, can testify to them as would be required under law, I am going to rule that the contents are not admissible. The questions about whether an officer received phone records is an admissible question. Mr. Yelmichilli, did you want to add something before we finish this phone records conversation?
Just briefly, Your Honor, I'm sorry, I should have mentioned this before. We would, although it's perfectly fine as from the state's perspective for Mr. Cruz to ask about whether or not Sergeant Tyndall or Mr. Newton received phone records, we would say that any affidavits that were submitted by the law enforcement officers in order to receive the court orders to get the phone records and the court orders themselves, I don't think are admissible as evidence, as substantive evidence in the case. Just the questions are appropriate, but I don't think those documents, as far as the affidavit, would be admissible and would be able to be submitted to the jury.
Okay, and tell me why you don't think they're admissible. What would be your argument?
Well, Your Honor, those affidavits are within them going to necessarily contain some hearsay information, since they are, the officer's statement and affidavits for purposes of receiving court orders or search warrants are not limited by the rules of hearsay when they're being submitted to the judge. Now, if there were certain portions of them that serve to contradict testimony that the witness gave about things they did or did not do, then they may be admissible for the limited purpose of impeachment on those issues. But just simply tendering a law enforcement officer's affidavit, I do believe would contain hearsay statements within it, and also contain, their opinions on certain things and various other things that wouldn't necessarily be admissible in the context of a trial before a jury, although they would be appropriate for the purpose of having obtained the court order to begin with.
All right, thank you. Mr. Cruz, you care to be heard on that?
No, ma'am.
All right. Then I think that's right. I mean, that's, I think, a correct statement of the law. I would say, however, in the same vein as questions about did you obtain phone records is an admissible question. I think certainly, and I'm not telling you how to do your examination, but if you chose to ask the officer, did you seek a search warrant for phone records, that is an admissible question. And unless you want to be heard on that, Mr. Yalamanchili, I want to make sure sort of we're clear that there are certain things you certainly can ask law enforcement about their investigation, and asking for a search warrant and did they go seek one is an appropriate question. I think the contents of what they received would probably not overcome a hearsay objection. If you feel otherwise at the moment, we can take it up outside the presence of the jury. All right. With regard to Keshana Armstrong, or is it Keyshawn Armstrong? Keshana, all right. There was a motion in limine regarding any comment about another person with a name. Was it Scott? Was that? Hold on just a minute. Let me make sure I've written this down right. Did you make the motion about Ms. Armstrong? Was that you, Mr.?
I don't believe the state has any motion in regards to Ms. Armstrong.
I wrote down Ms. Armstrong. I thought there was something about Mr. Another person who they did not. You didn't bring evidence. Bolden, is that correct? Or Bolton?
I hope not.
I'm sorry. Was it Bolton?
Barden.
Barden. Sorry, Barden. Okay. I'm not sure I wrote it down. And you were expecting that information to come through Ms. Armstrong's testimony?
Well, no, Judge. It was Sergeant Tyndall.
That was Sergeant Tyndall. Okay.
Yeah, it would be Mr.
Right.
Barden, and then also an individual by the name of Anthony Little. Okay. These would be two people that were considered persons of interest at the time. Okay. However, no information was developed to link them to the crime, and it was our belief, or at least we thought it might be a possibility, that Mr. Cruz is attempting to elicit testimony regarding those individuals from Sergeant Tyndall or Mr. Newton. I mean, just our motion in limine has to do with those two individuals just being mentioned in any way, since Mr. Cruz did not identify them as individuals he intended to raise as alternative suspects in response to pretrial motions hearings.
All right, thank you. All right, I don't know why I wrote Ms. Armstrong's name down, and we have to get her WebEx information. That may be why I wrote it down. You have the information. Fantastic. All right. Mr. Cruz, do you care to respond any further with regard to the remainder of the state's motion in limine as it concerns any person by the name of Baden and Little, last names?
Baden and Little?
Baden and Little. They were just referring to two. Barden? I'm not going to get it right. Barden. Sorry. Barden.
I believe I put that information on the record for the Honorable Court, our position, that nothing changes from our position.
Okay. All right. Thank you. I'm going to grant your motion. It does violate the Sadi motion the court has granted in previous hearings and that we have been discussing throughout the course of this trial. And so I'm going to grant your motion. There will be no testimony about anybody by the last name of Barden and Little through Sergeant Tyndall or Mr. Newton. It would violate the court's previous ruling. So, all right.
Your Honor, I hate to jump in on that. There was another piece of this that I think because Mr. Yalamanchili and I are kind of splitting up potential defense witnesses today, Mr. Newton also spoke with an individual at the Clark County Jail back in March of 2001. That person provided some other names of people who were allegedly making admissions or whatever about being involved in this crime. The inmate with whom Detective Newton at the time spoke, her name is Melinda Thomas. The information she provided is secondhand hearsay about what some other people would have told her. these are not as it relates to Mr. Little or Mr. Barden, but under the same theory, the state would ask that any testimony about these other alternate perpetrators or potential alternate perpetrators also be excluded.
All right, thank you. Mr. Cruz.
Just for clarity, Your Honor, and I may have said it wrong or misspoken,
Okay.
but these individuals, I'm not saying they committed a crime. I understand the state's alternative perpetrator ruling. I'm not saying any of these individuals committed a crime. So I may have explained it wrong. The purpose of Steve Barden is to show the investigative steps. It has nothing. Our position is firm. Chris Melton committed this crime. We're not saying anybody else committed it. So if I say something that sounds like I'm saying, Judge, we want to point the finger at this person, we want to point the finger at that person, I'm just misstating. That is not what I'm saying. Anything that we're seeking to bring in at this point in our case in chief is to show the failures of the investigation. They have nothing to do with whether a person committed a crime. They have nothing to do with hearsay. It's just whether, did you have notice of this fact? Did you follow up on this fact? If not, why?
Okay.
That's our entire theory with the witnesses. As far as the witness Mr. Bowden is speaking about, I just want to make sure we're talking about the same witness. May I see because there is one I wanted to discuss with.
All right.
Mr. So I, in fact, do intend to speak about Ms. Thomas. I wasn't going to refer to her by name. I was just going to say, did he speak to an inmate? And the purpose of this testimony is just to show, and I'll put it this way. It would be in sur rebuttal if the state has a rebuttal to our defense. So we wouldn't get into that information with Mr. Newton in our case in chief, but if there's rebuttal, this testimony will become relevant at sur rebuttal, depending on what the state's rebuttal is. So I would ask the Honorable Court not to make a ruling at this time until defense rests and the state lets us know if they are going to have rebuttal evidence in regards to the evidence that we present.
Okay. I'm not really sure I understand what you're asking, Mr. Cruz,
Sure.
about the rebuttal evidence, but I do want to respond to your arguments that relate to the state's. I'm actually looking for the order that I wrote with regard to this whole issue. Your responses to the state's motion in limine with regard to Mr. Barden, Mr. Little, this unknown person at the jail.
We don't have anything from Mr. Little. We didn't intend to elicit any testimony about Mr. Little.
Okay. But I'm going to mention this person in general because they all relate to the same thing. I understand certainly what the defense is saying about their position that the state law enforcement did not investigate this case properly. And I understand what you're saying about notice and that is those positions are the reason that the statements about other persons should be properly admitted. I understand what you're saying. The problem with that legally is this. The defense is asking for the court to allow it to go to admit those statements under that theory. And in doing so, that would bypass the court's order that it has already granted the state, which is that if there were any alternative suspects that were to be discussed at trial properly, the defense had to provide the proper notice, which would then allow the court to set a hearing so that we can determine whether the statements being offered about alternative suspects are admissible for lots of reasons, whether they would be admissible with regard to a hearsay objection, particularly whether they would be admissible because of relevance. And so just by stating, well, we're asking to admit those statements under a different theory, it is not appropriate for the court to allow that because what that does is circumvent the prior order. They have to be done in conjunction. And so if the defense wanted to elicit testimony about other suspects for the purpose that you're asking for them to be elicited, notice under the Saudi motion we've been talking about had to have been done in order for the court to have heard in order for the state to have gotten the required notice, and in order for the state to have, the court to have set a hearing date in order to flesh this out, and that hasn't been done. And so I understand what you're saying, but it is not appropriate to circumvent the order by saying, well, it's just under another theory. That motion was not filed by the defense for whatever reason, and I'm not commenting on that. That may certainly be a strategic moment on the defense's part, but it hasn't been done. And because the proper notice hasn't been done, in order for the court to make a ruling that regardless of the state's feelings about those statements, regardless of any other legal objection that we've discussed in those hearings, those statements would be proper. The court hasn't had that opportunity because notice wasn't filed. So I'm going to grant the state's motion based on those for those reasons. All right, but I wanted to kind of make that clear. All right. Let me start again with the state. Anything else we need to take up before the jury comes back in?
No, Your Honor.
Okay. Mr. Cruz, is there anything else we need to talk about before?
Well, based on the rulings, I would like 10 minutes to talk with everybody because we have to figure out what.
Absolutely. So I think what we're going to do is this. We have your information for WebEx. We're going to go ahead and get that set up. I'm going to give you all till 10:20. All right, so that's about 25 minutes. I'll be back on the bench at 10:20, and then we'll get started. All right, we'll be in recess until then. Thank you.
Your Honor.
Yes.
I need to speak with Mr. Faust too, so he'll need to be a part of that discussion. Can we make that happen? Mr. Faust would need to be a part of that discussion as well.
He can remain here. No problem.
Your Honor, I'm getting this to you in Word format.
I'm sorry?
Getting the jury instructions in Word format. I understand you received it.
Oh, that'd be great. Thank you. All right. Let's go on the record. Mr. Cruz, have you had enough time to have the conversations you said you needed to?
I have, Your Honor.
Okay, very good. Are you ready to proceed?
We're going to close the evidence, Your Honor.
Okay, so you're going to rest.
Yes, ma'am.
All right. Before you bring the jury out, let's talk about a few things. I want to talk about timing, some timing issues. Let me just have counsel at the bench so we can sort of have a more of a free-flowing conversation. Thank you. You all may be seated. Welcome back, ladies and gentlemen. Appreciate you all again being here on time. We are ready to resume State of Georgia versus Edrick Faust. SU 24 CR 0547 is state ready. State ready?
Ready, Your Honor.
Defense ready to proceed?
Yes, ma'am.
All right, ladies and gentlemen, the state has rested. Mr. Cruz?
Defense rests.
The defense rests as well. Ladies and gentlemen, that means the evidence in this case is closed. So now this is what we are going to do, and I want to tell you sort of how the process works. The evidence is closed in this case, and the next step for all of you is to hear closing arguments. There's something that has to happen before that, and it's called a charge conference. And it is a conference, it's a meeting with the court and all the attorneys about what law is to be given to the jury in its charge. That is something that, of course, has to be done outside your presence, as we have done many things outside your presence during the course of this trial, including this morning, which is why I had you come in later, because we were doing things outside your presence, and I just didn't want you sitting in the jury room for, when you could be at home or doing other things. But this charge conference, of course, must happen outside your presence, and it's going to take us a while to do it. I'm going to give you a very long lunch break. I'm going to give you a lunch break until 2:30 this afternoon. And so I'm going to ask you to return back here at 2:30. I know one of the jurors has an appointment. Don't rush to come back. If you're a little bit late, it's fine. We will not start without all of you being present, so don't worry. But if you'll come back at 2:30, we're going to begin closing arguments at that time. The same instructions I have given all of you apply. Right? Don't discuss the case with anyone, of course. Don't do any research independently or on the computer. Please don't go to any of the locations you may have heard about. Enjoy your lunch. It'll be a long one, but we'll see you back here at 2:30. Thank you very much. All right, you all may be seated. Thank you. All right, we're going to be in recess till Ms. Ellis is finished with compiling the charges from the state and the defense, and then we'll be back on the record and we'll have our conference. All right, thank you. Court is adjourned for the moment. right, let's go on the record and start from page 1. So, what I'd like, did we lose Mr. Yalmichel?
I'm handling it.
You're handling it. Okay, very good. Then we'll continue. Yes. Okay, I will. Yeah. Okay, so Mr. Cruz and Mr. Hill, I don't know if Mr. Bolden has been with us in a charge conference or not, but Mr. Bolden as well, I just can't remember. What I ask you all to do is just go page by page. So what we'll do is, and I'm going to pull out the indictment and go through page 1 by myself. What Ms. Ellis has done, of course, is consolidate everybody's charges. And it will, of course, eventually be a document that doesn't have the titles of the charges. Obviously, it'll read like just a regular document, but for our purposes, the titles will be in there. So if you all take a look at page 1, I'm going to look through the indictment and make sure it mimics the indictment exactly. But if you see any, this is the time, the first couple pages, to see if there are any typos. That's, just to make sure we follow. And if there's a typo in the indictment, it goes into the charges as the indictment reads. We don't obviously correct anything. I don't know if there is. I'm just saying that's how we do it. So if you'll take a look at page 1 and let me know if there are any objections to page 1. All right.
No objections to page 1 from the defense.
All right, very good. Let's do the same, obviously, with page 2.
State has no objection to page 2.
All right. You can certainly go on to page 3 and go through the indictment part of it. Just let me know what you, but I'll wait to, of course, hear from both sides.
There is what appears to be a typo on page 3.
Okay. Well, let me hear from this defense about page 2, and then we'll go to page 3. No, I mean, you can continue looking. I want to go in order in terms of any objections, so I'll wait to hear from Mr. Cruz. There's one on page 3. Okay. Okay. Got it. All right, thank you. If you all go to page 3, and Mr. Goldman already has a comment, go ahead.
So, is it okay if I just stay?
Yes, you can all stay seated. Yes, yes, of course.
So in count 7 of 12, for the said accused in County of Clark and State of Georgia, did perform a sex act with the person of Tara Baker involving the sex organ of and
What?
8 in front of.
Okay.
That's all.
All right.
At the bottom of page 3, After Edrick Faust, the word with the offensive rape.
Right. See it? Thank you. Anything else with regard to page 3?
I didn't see it.
All right. Mr. Hill, Mr. Cruz, are you okay with page 3 after the correction?
After what this state mentioned
And the word with. Okay, we'll go on page 4.
Top of page 4, the second line, it says January 2001 did have carnal knowledge of Tara Baker. However, in the indictment, oh no, I'm mixing them up. Please forgive me. I'm mixing them up.
Okay.
Disregard that.
Okay. Page 4, Mr. Bolden, anything from the state about page 4?
No, Your Honor, and I've just gone all the way to
Okay.
the bottom of page 5 to get through
Okay.
our amendment and the indictment, and I didn't see anything.
Okay.
I'm still on page 4. Your Honor.
That's fine, absolutely fine. I just want you all to know, page 6, in the very top, there's a typo. It needs to be his instead of her, but we'll get there. Those are the easy things to correct.
right, no issues with count 4, Your Honor.
All right, page 4. We'll go to page 5.
All right, one issue in count 12 of page 5, just the word on is missing. Word on or about the 19th day of January 2001.
All right, let me just make sure that's what the... Okay, that's exactly right. Let's see. On, we're going to put an on before the or.
Also, count 12, the last line of count 12, well, the third line from last of count 12, where it says laws of said state, the good order, and peach instead of peace.
You got it. Peach does not fit. Okay, excellent. Thank you. And when you get to page 6, the very top should be his as opposed to her. So that's the first thing we need to change. When you're ready, if you all go through page 6, let me know your position. Yeah. Okay, I just want to remind you all, Ms. Ells made a good point. Everybody's requests are in this document. We haven't taken anything out. State and defendant. So it's a big document. Obviously, we'll figure out how to pare it down properly, but just so you know, everything you've submitted is in here.
It's just the titles aren't in the
Yeah, sure.
first part.
Yeah.
The bottom of page 5, just the hyphen in between not guilty.
Well, we typically have it in there. I'm not sure why we do, but if you would like us to take it out, we certainly can. All right, we'll do that. I think it just reads better, but we certainly can take it out.
In the second paragraph of page 6,
Yes.
the fourth line, where it says defendant is guilty of the offense charge, we'll just change that to offenses.
I have to figure out where you are. Hang on just a moment.
Second full paragraph. Well, the first full paragraph. First full paragraph. And the fourth line.
Well, I think we always have it as crime, just because I think it indicates that they have to individually apply this reasoning to every single charge. And so I see what you're saying, but I think we're going to leave it in there just because I don't want them to misconstrue that they have a responsibility that's not individual to each charge. Yep.
Where it says there is no burden of proof upon the defendant, the word whatsoever is missing. And that is the second full paragraph, third line.
All right. Let me look at the pattern. I've taken this from my standard jury instructions, and I'm not sure I have that word in there, so we'll look at the pattern for burden of proof and see what it says. Certainly want to follow the pattern. All right, this is the pattern.
That'll be the fourth paragraph of the pattern if you're using Westlaw.
You're right. It says whatsoever. There's no burden of proof upon the defendant whatsoever.
While you have that pattern, Judge, is also missing
Okay.
language of that same line. And the burden never shifts to the defendant to prove.
Well, it
Excuse
says to prove innocence in the pattern. We have the word his, but we can take his out.
Well, no, that's not.
Okay.
It says, and the burden never shifts to the defendant to introduce evidence or to prove innocence.
All right. Mr. Bolden, any objection to increasing the language of the pattern charge and putting in introduce evidence and what? Introduce evidence or to prove innocence?
That is what the pattern says,
Okay.
Your Honor. And Mr. Cruz wants that. You should get it.
Yeah, no, I agree. And I think I'm going to change my patterns in the future to reflect that, since the pattern says that. They do change a lot of these patterns kind of every 6 months, and it may be that has been changed and I didn't realize it. So we're going to add this to paragraph 2. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove his innocence. And I'm going to keep the word his in there unless you don't want me to, Mr. Cruz.
No, I'm indifferent.
All right.
Can we copy the pattern language when we get into the definition of reasonable doubt?
Tell me what you mean.
Verbatim?
Hang on one second. I just need to send this message to another attorney about a case for Monday, so hang on just a moment. Okay, go ahead, Mr. Cruz.
Pattern language, and it's not a big.
Tell me where you are. Tell me.
I am on the 5th paragraph of the pattern charge, starting with sentence 2.
On what page?
Page 6 of the.
Okay, hold on. All right, you're asking about the reasonable doubt pattern?
And page 6 is the last paragraph. So the pattern charge. I apologize. The pattern charge states a reasonable doubt means just what it says. I believe that matches. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. And I believe Your Honor has the pattern charge up. Yeah, can we just use the exact language of the pattern charge?
Well, we have all of this in here. I guess, is it just because it's in a different order?
Yes, ma'am.
So we need to start with the burden of proof. Well, we have, I mean, it is in here exactly the same. It's just in different paragraphs. I think it's,
So
it is exactly the same.
okay. So we're
So it's, the pattern as written is reflected in the charges. I think maybe the difference is the statement, however, the state is not required to prove the guilt of the accused beyond all doubt or true mathematical certainty is in the paragraph above it.
no, that's fine.
We can move that to the paragraph below as it is in the pattern, but the order in which those phrases are, or those sentences are done is exactly here. It's the same. I think it just looks different, but I can move that sentence, however, to the next paragraph if you'd like.
So the difference I have in mind is the pattern charge, and I think generally it says the same thing, but we're really big on language, and I'm very careful on language. In closing, it says it is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. And it says essentially the same thing, but the pattern charge says a reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth.
Repeat the words "a reasonable doubt." Yep. I think that makes sense.
And I ask this, if it's not too much, can we just copy and paste that paragraph from the pattern charge and stick it into the charges?
Well, it is the same, with the exception of what you just presented, and the fact that however, the state is not required is actually part of that paragraph in the pattern. In our documents, it's part of the paragraph above it.
And that's no issue. That's no issue.
But the rest of it, I think, is exactly the same, except for the words "a reasonable doubt," mentioning it again, which I will do. But I want to just make sure that that's... Put down, again, a reasonable doubt on the second line. Okay, so this is how it's going to read, and this is what the pattern says. However, the state is not required to prove the guilt of the accused beyond all doubt or to mathematical certainty. We can put that down to the next paragraph and just make it one paragraph. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt, and the rest of it is the same. Does that satisfy you, Mr. Cruz?
Yes, ma'am.
Okay, that's exactly what the pattern says. All right, and anything else on page 6?
On the last,
Golden, if you want to jump in there while we're having this conversation, obviously do that.
Of course, Your Honor. State has no position.
Okay, all right.
I'll just write that as a paragraph.
Okay, yep. When you're ready to go to page 7 and let me know what you think about page 7.
I included grave suspicion of guilt.
I'm sorry?
It's a thing.
Yeah, we haven't gotten there yet.
Okay, got you.
Yep. What you all are reading that goes through top of page 10 are the standard patterns that all Superior Courts here at least have in their arsenal. And obviously these are ones you all have asked for, but it's our standard ones, and so we haven't gotten to the specific ones you've.
Grave suspicion comes at the end after.
Yep,
You
yep,
just put that,
yeah. So everything you all have asked for, we haven't kind of gotten to that yet. I mean the specifics.
Yes, ma'am. All right. With the jury instruction, jury judges of law and fact,
Which page are you on, Mr. Cruz?
7.
Okay.
Just the last sentence says, it then becomes your duty and responsibility to apply the law that I give you in this charge to the facts as you find the facts. Okay. It's nothing that needs to be changed. Attention.
Michelle asked for it this morning, didn't I? Yeah. It makes Monday easier. All right, are you all still on page 7, or have we moved on to page 8?
I am, Your Honor. I'm looking.
Okay. Mr. Bolden, are you still on page 7?
No, Your Honor.
Okay. You okay with page 7?
Yes.
Okay.
Sorry.
Nope, that's fine.
All right. No other objections to page 7, if I'm
All right,
making any.
we'll move to page 8.
What's the site? The site for evidence is the means by which any facts which are put into issue is established or disproved. Do you know the site for that one?
You mean the pattern number?
Yes, ma'am.
Well, it's really hard to look them up.
I think I just found it. I think it's 1.3010. I think I just found
Got
it.
it right here. Yes, what about it, Mr. Cruz?
Is that it?
Hold it up.
No, I just wanted to find it. That was it,
Okay.
just to match it up.
Yeah, the instructions that we have, that we use, don't make it easy to, search. You can do it in order, but don't make it easy. This is a crux issue.
Your Honor, as it relates to that, on the top of page 8, pattern does read that evidence includes all of the testimony of the witnesses, parenthetical, and any exhibits submitted during the trial. And then the next parenthetical says stipulations of the attorneys, which I think would be applicable here because we do have the one stipulation as to the photo of Mr. Faust that was that. So the photo was entered into evidence, but then the stipulation was also that it was a photo taken of him on, I think it's February 8th of 2001. Mr. Yalamanchili put that on the record at the time that the photo was tendered.
Okay, so you're saying this is the pattern. Evidence includes all of the testimony of the witnesses, and then parentheses, which I don't think is applicable.
Correct.
The equivalent, such as depositions, so we'll leave that out. And any exhibits admitted during the trial, stipulations of the attorneys, that is any, okay, so do you, I could, well, and I'll hear from you, Mr. Cruz, I could just do it this way. Includes all of the testimony of the witnesses and any exhibits admitting during the trial and any stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, period.
That would be how the state would ask that the court.
Mr. Cruz, how do you feel about?
I have no objection to that, Your
Okay,
Honor.
so we'll do it that way. Oh, no, okay, hold on. I have your computer. How could you have gotten? All right, so what we'll do is input the word "and" any stipulations of the attorneys, put that all in there, and then not matters of which judicial notice.
And then I would also say, I don't know if this was in the requests that I made this morning, and if not, I apologize, but I think that does make the next one in the pattern, which is 1.30.12 applicable, which is the pattern on stipulations.
All right, we're going to look it up in just a minute.
I apologize.
Well, I mean, this is what this is for.
Sure.
We have to. You can also make oral motions for certain charges. I mean, that's obviously why we're here. So let me let her finish 1.30.10, and then we'll.
I might have already added it into the case.
Might have added to this case-specific one. So if it is added in, we should put it there. That would make sense.
1.30.12?
Yes. I apologize.
It was?
It was not.
It was not.
So it would not be in there.
Okay, so I think,
This
okay.
is it.
1 point, okay, so Mr. Cruz, in case you don't have it in front of you, 1.30.12 says, oh. I know it is. Yeah. Okay, I was trying to figure out where it was in here. So there are several, let's all look at 1.30.12. There are several things that could be.
You're on-
Well, I'm just going to throw out what I think, and then I'm going to listen to what both of you want to add. There's only been one stipulation, and I think making providing all this emphasis would be very confusing to the jury. This would be my sense, but I'll hear from both of you, to just put in there, the parties have entered into a stipulation that has been approved by the court about however we decide it is about the picture, and leave it at that. The rest of the statute is pretty convoluted about probably convoluted stipulations, and so that would be sort of my.
And that would also be the state's position and request, Your Honor. So again, under that pattern charge, 1.30.12, just that the parties have entered into a stipulation that has been approved by the court about the following exhibit, whatever exhibit number that would be, and then that was a photograph taken of the defendant on February the 8th of 2001.
I think you both have to come up with the language that suits you both. Before we get into that.
Sure, I apologize.
Sure. No, I mean, you don't I have to apologize. I mean, I just think we need to talk about what the language is. Mr. Cruz, without getting into what language is the exhibit that's been that describes the exhibit that's been stipulated to, do you have any objection to 130.12, which is the parties have entered into a stipulation that has been approved by the court about the following, about the following exhibit?
I do not.
Okay, so let's talk about, so we'll put that in there. Let's talk about how to phrase it. Let me get his. You say again, Mr. Bolden, what you think it should say?
Yes, Your Honor. I would say that, so the parties have entered into a stipulation that has been approved by the court about the following exhibit. And then in the pattern where it says specify, I would suggest something to the effect of that state's exhibit, whatever the number is, and I'll find that out momentarily, was a photograph of the defendant as he existed on February the 8th, 2001.
Okay. Cruz, thoughts on that language?
That's what we agreed to.
That's what I thought. So I hope.
Are you satisfied with that, Mr. Cruz? Okay. Will you say it slowly so Ms. Ellis can take that in?
I will. I probably won't be able to do it exactly the same way, but I will try. That state's exhibit blank, which I can fill in due course, is a photograph of the defendant as he existed on February 8th, 2001.
Okay. Let me just see if I have.
Just see, that's cool.
I have 113. I have that as a stipulation, but I didn't label in my notes what the stipulation was. So we need to double check and make sure it's 113. We can do that when we're finished, but let's make sure we actually get that in there. Okay. Let's keep going on page 8.
I have no objections on page 8.
Okay.
Here's the whole thing.
Okay, I'm going to read this to you all since Ms. Ellis has just redone what you have said. The parties have entered into a stipulation that has been approved by the court about the following state's exhibit, 113, about, I think we should just say about state's exhibit 113. I'm going to just say about the state's exhibit 113, unless you all have, it just sounds better. About state's exhibit 113, colon, a photograph of defendant as he existed on February 8th, 2001, where parties stipulate, let's see. Where parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Where parties stipulate exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. That is the pattern. Mr. Bolden, I'll ask you first. Any thoughts on all of that?
That's acceptable to
Okay.
the state, Your Honor.
Mr.
Thank you.
Cruz? All right. We'll move on to page 9.
Your Honor, on page 9, at the very, not at the very bottom, but towards the bottom, to impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. I see that that's the 1.31.45. I guess the state's concern here is I am not certain that anything has been disproven as to what they testified to. I understand that the defense would maybe disagree with whether or not their credibility, and that's a separate instruction. So the kind of that particular pattern gives an either or. The first part says impeaching a witness is to show that the witness is unworthy of belief. Then there's the or. The credibility of a witness may be attacked by disproving the facts to which the witness testified. I mean, it's my position, it's the state's position that that second part would actually be more tailored to this case.
Hang on just a minute. The whole okay, so you want to go to page 21.
My page.
Okay, hold on. Let's fast forward to the
Requested it.
okay, the
Defense number 11.
defense number 11. Let's go to defense number 11 and look at the whole pattern in total, and then we'll discuss it. Since what we did was we included everybody's requests and didn't take them out, even if they touched on something ahead of time. So on page 21 in the middle is defense request 11, which is the pattern. All right, Mr. Cruz, do you care to be heard? Which of those portions of the pattern you think we need to have?
I believe the first one. I think a big, 21 is large. So let me start there. Well, where are we starting on page 21?
It's the one right in the middle, 131.45.
Okay.
You're 11.
So I would say to impeach a witness is to show what Mr. Bowden read into the record.
Yep.
Witnesses impeached each other during this trial. We use certain witnesses to impeach other witnesses. I think a big one that sticks out vividly is, I believe, Ricketts was extremely adamant that Chris Melton's alibi had been confirmed. And we went through with other witnesses establishing that it had not, in fact, been confirmed. And I think a big part of our cross was locking Ricketts deeper and deeper into his statement that we confirmed it. And I even think a little bit with Ricketts, we started going with him through some of the places that were unconfirmed that he ended up admitting. So and that's just one example here. And I think a second example was Mr. Melton, who refused to acknowledge that he was living in his parents' basement at the time. And obviously because we showed him the photos with the doors showing how he could get out. However, Josh McCourty was the witness that came in right behind him and said, oh, Chris was staying in his parents' basement. So we would ask for that instruction. We intended to use it in closing.
How would you both feel if the court included both of them in the manner in which it is in the pattern, which is disproving the facts to which the witness testified, or let's see. I don't know, including both of them. I'll have to think about how to do that.
I don't have any objection to including
I don't want it to be confusing, but Mr. Bolden?
I mean, I guess it gives, but my point is still that I don't know that that's actually disproving anything that another witness testified to. I understand Mr. Cruz's position, but I think Agent Ricketts' opinion that Mr. Melton's alibi was confirmed is like that's getting into kind of a subjective nature of his assessment of the alibi, and you can't disprove something that is a subjective belief in someone's mind. If it was an objective fact, I think that's really more what the impeachment statute and the impeachment pattern is designed to cover. again, I think that it will all be covered in, credibility and stuff like that. And that's the only reason I bring that up.
Well, I'm not going to make any comment on the evidence.
Sure.
The strength of the evidence. That's for the jury to decide if they choose to about these particular moments we've been discussing. So I think it would be appropriate to include the entire pattern as written. And I think I'm going to do that. I'm going to grant your request, Mr. Cruz, and have, let's see, I think we need to put it, defense's request 11 in, on page 9.
Question for you. On the bottom of page 9, your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony. Where is that located? The pattern number.
I don't know exactly. I mean, those are our standard charges that we have from pattern, and I always read those, and I'm going to continue to read those. But I will find this. I will find the pattern for you. But let's just jump on top.
I don't see that one.
Let's jump to the impeachment first and get that squared away.
Yes, ma'am.
So we're going to keep in defendant's 11, defense's 11, and it's going to read, let's see, exactly how it is. It's going to read exactly how it is. As you've requested, it's already in the instructions. But let's talk about credibility of witness. Let's see. I'm just going to put in there, and I'm doing this over objection by the state. This is how it's going to read. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The credibility of a witness may be attacked by disproving the facts to which the witness testified. I'm just going to put both of them in there. I know the pattern says or. I don't think it'll be confusing. I don't want to comment on the evidence. I'm just going to put the whole thing in there. So we'll put it in that area on page 9 where it starts with to impeach a witness. Does that make sense? Okay. All right, let's go to then the next paragraph. You had a question about that, Mr. Cruz?
I did not. I found it. I was just trying to match it up.
Anything else about page 9 from the state of the defense?
No, ma'am.
Let's go to page 10. And then page 10, right after the very first paragraph, is where we start to put in the requested charges. Yes, and Ms. Ellis wanted me to make sure everyone knows we obviously pull the titles out. I don't put the pattern number in there. I don't know if some courts do that, but we don't. It just reads like a document. The whole thing reads smoothly like a document.
Yes, ma'am.
And Mr. Bolton, I wanted to ask you on page 10, after 1, 2, and 3, where there are 3 phrases in parentheses, are you asking for all 3 phrases to be in there?
I'm sorry, can you say that one more time?
Yeah, you have to be looking at the page to understand what I'm saying. It didn't make sense. Sorry.
No, that's all right.
Okay, so after 2, 10, 10,
Yes.
we put in your request 1, defense's request 35. Oh, I should ask you this too, Mr. Cruz. I actually just saw that it was also your request. All right, both counsel. With regard to 2, 10, 10, after where it says for malice murder, the state must prove the defendant 1, 2, and 3. The next paragraph, at the end of that paragraph, has 3 parentheses. Without justification, another one without excuse, another one without mitigation. I'm asking both counsel, do you want all 3 parentheses in there?
We can. I don't think it's applicable to this case. I think we may have filed a motion, I believe, letting the jury know that identity is the issue. We may even say it in closing that the sole issue is identity. But it's up to the honorable court. I have no position whether the honorable court includes it or.
Right.
Well, I guess it does, Nick, because it is the law. I think that is in the statute, if I'm not mistaken. So, yeah, I think it would need to be included unless a particular one applies. And in this case, no one's arguing a particular one applies.
Yes, and I would ask that there be a period after the word kill. I'm not asking for any of the parentheticals. I don't think any of them are applicable.
So you're just asking rather it is the unlawful intent to kill, period, without the parentheticals. That's what you're saying?
Yes.
Okay. Mr. Cruz, any objection to that?
For purposes of the record, I would say yes.
Okay.
I would just say to keep it with the statutory language. I don't disagree with Mr. Bowden in substance, but I do have to be aware of the appellate record here. So I would say
Okay.
without justification, without excuse, without mitigation. But I'll leave it to the honorable court's discretion.
I think I'm gonna take it out, and the reason I'm gonna do it is this: there hasn't been any evidence regarding justification, excuse, or mitigation, and so I think it would be confusing to the jury, and obviously that's one of the most important things to look at when you're dealing with charges. It also doesn't fit the evidence, and so I'm just gonna put a period after the word kill. All right. And then the next two paragraphs is part of that pattern, of course. You both have asked for it, but if there's something you're thinking about you want differently, let me know.
And the honorable court's ruling is supported by the pattern charge. It says charge only the appropriate language, adapt parentheticals to the indictment and the evidence. So.
Your Honor, I've moved on to page 11.
Me as well.
All right, very good.
So I don't have any issue with premeditation, which we both requested. As far as motive goes, I requested it and we just copied straight from the pattern. State does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining if the defendant's state of mind at the time of the killing. The state hasn't offered any evidence of motive, so I don't know that the second sentence is applicable here.
Let's talk about, before we do that, the 21011 that you both asked for, premeditation. Any objection to how it's written in the charges?
And I'm matching it up there. If you give me 30 seconds, Your Honor.
Sure. Oh, you're off. Okay.
It's better if you just.
Say the number, 21011. Okay, we're on 21011. Premeditation.
Okay. And what's the state objection to premeditation?
Objection was to the
I
next.
have none to
We're
premeditation.
going to start on, we'll kind of go chart.
One at a time. I got you.
So motive.
So we're on premeditation, the 21011. Do you have any objection? You both requested it. Any objection to how it's written?
No, ma'am.
Okay, so we'll move on then to 21012, motive. The state has, you've both requested it. The state has asked to get rid of the second sentence. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Any comment on that, Mr. Cruz?
Well, I intended to use motive in our closing. And that sentence, although it says defendant, I was going to switch it to fit our evidence in this case. I would ask that it's included if any change is made. Defendant is fine with me, but if the honorable court wants to make any change, just defendant is fine. Defendant is fine with me.
I'm not making any comment on your closing at all, but I am going to get rid of that sentence because I don't think it fits the evidence with regard to the state's position of evidence of motive for the defendant.
Yes, ma'am.
But certainly, you've made it clear you've talked about motive for other things, and you're certainly not prohibited from talking about that in your closing. So that it'll just read 21012 will read the state does not have to prove motive to prove murder. All right. The next one that you have both requested is felony murder. And we need to talk about how to articulate that. There are 4 counts, I believe, of that in the indictment. Count 2, 3, 4, and 5. So let's just talk about 21020. Any objection to how it is written? It's obviously the problem.
No, not how it's written, Your Honor.
I'm sorry?
No.
Okay. Mr. Bolden, any objection to how it's written?
No, Your Honor.
All right. Let's talk about how to talk about blank is a felony, which I will define for you shortly. Yes. We're going to take the parentheses off where it says the state does not have to show that the defendant acted with malice to prove felony murder. Just leave it as a sentence. The next one is blank is a felony, which I will define for you shortly.
Can we? Oh, I'm sorry.
Yeah, go ahead. No, go ahead.
In regards to that, can we state all? I think it's 4 felonies. Can we state all 4 felonies? So, rape, just state them back to back, and then when we move to 21030, we can say the same thing with the first blank with all of them, regardless of whether he or she. And then when we get into the definitions, if the state doesn't disagree, just to keep it from being confusing, we discuss each charge just back to back to back. So that way we note all 4 felony murders, we note all 4 underlying charges, and then we also note or give the definitions following. So we at least signal to the jury, there's 4, and here are the 4, and the definition of the 4. And it may kill 2 birds with one stone because it also gives them the definition of the underlying crimes as well that we're charged with.
I think there may be some agreement, Judge. What?
Tell me what you mean. I mean, whatever way it needs to read where it doesn't confuse people is fine with me. I just want to...
What in the way that I submitted it in the state's requests is where there's the blank at the bottom of page 11
Okay.
would just be burglary, aggravated sodomy, rape, and aggravated assault are felonies,
Okay.
which I will define for you shortly. I think that's
Okay.
what Mr. Cruz is saying as well done.
Is that what you're saying? Just
It is.
all in one are felonies, which I
Right.
will define for you shortly.
Right.
Okay? Okay, so it's burglary. Do you want it to say burglary to a dwelling or just burglary?
Burglary would be.
The indictment says burglary to a dwelling.
So we'll use the indictment language.
All right, so we'll do burglary to a dwelling, comma, and we're on 21020. Burglary to a dwelling, comma, aggravated sodomy, comma, rape, comma, and aggravated assault, are felonies, which I will define for you shortly. Counsel, are we in agreement on that?
Yes, Your Honor.
Okay. Let's go to the next. Yeah, of course. You're the one doing this.
In the very beginning, the grand jury has indicted the defendant with malice murder, felony murder, felony murder. I had just written burglary. Should I put burglary to a dwelling there?
Well, I guess the difference is that count 2 says burglary to a dwelling in reference to felony murder, but the count 6 says the offense of burglary. So I think it probably reads, that's accurate, yeah. Okay, let's do 21030, causation in felony murder. Both parties have requested this one, and it goes from 11 to 12.
I have no objections to that one, Your Honor.
And so again, kind of just like a minute ago, I think what the state would request is that you may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of burglary, aggravated sodomy, burglary to a dwelling, aggravated sodomy, rape, or aggravated assault. Kind of to track the language that we just talked about.
Any objection to the way that that's been articulated, Mr. Cruz?
No, ma'am.
Okay, we'll use the word or, regardless of whether he, not she. Okay. Any other comments about the top of page 12, which for our purposes is 21030? Any more comments on that?
No, Your Honor.
Okay, Mr. Cruz, are you satisfied with 21030?
Yes, ma'am.
Okay, let's go to 26221, burglary in the first degree. Both parties have requested it. Mr. Bolton, let me ask you first, since it's your burden. Number one, did you want both entered and remained in? One.
I was just looking at that, Your Honor. I think that's the way. Where are you? I would ask that it have both entered and remained in, because those are both included in the charging language of count 6.
I would have, because you all's theory, I guess, that he entered the house and.
Okay, it does, count 6 does say enter into and remain. That does track the indictment. I think it needs to say entered into and remained to track the language of the indictment. Mr. Cruz, do you have any objection to that change on the number 1? Okay, so we'll do that and get rid of the parentheses. Do you have that, Manny? We good? Okay. The intent to commit a felony. All right, let's go to count 2. And then we put in here okay. Mr. Bolden, what are you asking the court to put in the blank?
In the blank, I would say aggravated sodomy and rape are felonies, which I will define for you shortly, because those are the specific felonies that are referenced in count 6.
Okay. Any objection to that language?
No, ma'am.
Okay. Let's go to the bottom of that pattern that you both have requested, and let me know what you think.
Well, I guess we'll wait till we get to it.
I'm good through the bottom of page 12.
I am too.
Okay. All right, so we're going to start on the next one. I'm going to just make sure Ms. Ellis can follow with us. It's 26223, intent to commit a felony. All right, this is State's Request 7.
Yes, Your Honor.
All right, what is your request?
Your Honor, bear with me just a second.
Okay. Okay. All right.
And on our copies that you provide us, it will have the title on our copies. Oh, it won't have any title.
No, this is the only version where you'll have the titles. So what we're going to do is Ms. Ellis is the master at all this. She's taking down all of our changes. She's going to incorporate it in the master document and delete, of course, all of the titles. And then what I do is I make a copy for every juror and every attorney and Mr. Faust. So everybody will have their own copy, and it'll be the same that the jury is holding.
Okay.
I would, Your Honor, I think I would withdraw State's Request number 7.
Okay. We're going to withdraw 26223. Yes. Okay. All right. We could email it to all of you when we're finished. Sure. All right. So let's, we'll we'll get rid of that. All right, 26231, this is state's request 8.
We would ask that that be given.
All right, we're going to have to,
But I would, my suggestion as it relates to state's request number 8, 26231, would be to move that to until after the court defines burglary, which I think is later.
can we just do this? We just defined burglary in 2.
Okay, I'm sorry. Okay, I'm sorry.
Yep.
Yes.
Okay, so I guess my question is, how did you want 1, 2, and 3 of your request to read before we get to Mr. Cruz's response? Or do you want it to read like that?
I would say just number 1
Okay.
would be the most
All right,
narrowly tailored to the case.
okay. Mr. Cruz, any objection to 26231 reading? To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This, quote, breaking of the plane, end quote, must be done by the defendant. Any objection to that charge?
No, that's the pattern language, Your Honor.
It is, okay, and we'll cross out 2 and 3, and we're going to cross out the number 1. We're just going to put in, must be done by the defendant, okay. The state does not have to show that there was an actual break-in to prove burglary.
Hold on, say that. What are we doing now?
So we're on 26231, so on your copy, it's the middle of page 13.
Mm-hmm.
And what the state has requested is this. To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This, quote, breaking of the plane, end quote, must be done by the defendant. The state does not have to show there was an actual break-in to prove burglary. That's the request.
I understood. So we're taking out 2 and 3.
Yes.
Would the court consider giving the kind of not the parenthetical, the example that is given in the pattern? I'm kidding. I'm sorry. So about breaking the plane, football breaking the plane. I'm not requesting that. I'm sorry. I'm just kidding.
I'm not looking at the pattern. I'm looking at your.
Sorry.
All right. Any further objection, Mr. Cruz, or any comment?
Not at this moment, Your Honor.
All right, 23010, which is requested by both counsel. And of course, we're going into page 14. It'll be a different page, obviously, when we're finished. Mr. Bolden, any other changes to that request from the state?
No, Your Honor.
All right, Mr. Cruz, your request is to 41. Any changes to your request?
No, ma'am.
All right, so it will be given as requested by both parties. We'll go to the next page, towards the bottom of page 14 for us. It's 23210 for Ms. Ellis. This has been requested by both parties. I'll ask Mr. Bolden first, any changes about how you want this charge to be? I mean, this is the pattern, so.
So, I mean, this is where it gets a little confusing because there are the 2 different aggravated sodomy counts. I don't know if the court's preference would be to charge separately on each of those counts, or if the court thinks giving the definition of the crime once and then kind of incorporating, as alleged in count, bear with me.
Okay.
As alleged in count 7 to include the sex organ of the accused and the mouth of the victim. And then in count 10, the sex organ of the accused and the anus of the victim, or if you just want to define it twice. Does that make sense? What I'm trying to get at?
It does.
I mean, I don't know which way is less confusing. So I think that's why we requested it be given twice. I think that might be the easiest way. So, for state's request 10, for aggravated sodomy as alleged in count 7, the state must prove that the defendant and then I'm looking at the top of page 15, only use mouth, and then give the rest. And then I realize I'm jumping ahead here, but then for state's request 11, that it read for aggravated sodomy as charged in count 10, the state must prove, and then use anus instead of mouth.
Okay, so you're asking some additional language, which is for aggravated sodomy as charged in count 7. That's what you're asking for. Count 7 of the indictment. The state must prove that the defendant, okay, and you want the word mouth, and then you want it read again in the same way as charged in count 10. End of the indictment. State must prove, and then the word anus. Okay. So you're asking then, with those additional words, to read it twice.
Yes, I think my personal opinion is that would be the least confusing way to explain.
Mr. Cruz, I'll hear from you about your thoughts. You had asked also for 23210. You had asked the same, you have the same request, but the state is the only one that asked for it twice, just given the 2 different counts in the indictment. So, thoughts?
I'm fine with it twice,
Okay.
so I don't oppose that. I do have a question for you going back up to
Sure.
rape.
Hang on, just let me make sure Ms. Ellis got that. You got it? Okay. Go ahead.
All right, so, and if it's not appropriate now, I can
No,
add.
go ahead. We're doing it.
With the rape instruction, one of the elements is against her will. We did intend to argue that the state has to show that it's against her will, which I think is appropriate for their burden. I just want to make sure the Honorable Court is okay with that, where it doesn't violate anything.
Well, that is the state's burden, and that is the statute.
Yes, I think I understand what Mr. Cruz is asking, and I think that against her will is an element that the state is required to prove beyond a reasonable doubt.
Okay. Are you asking, Mr. Cruz, I want to make sure I understand what you're referring to. I mean, I do understand what you're referring to, but in the larger context of this trial and the motions that we've had and things of that nature, are you implying that because that is part of their burden, that you are going to argue anything about consent?
Absolutely not. Now, I will say this, Judge. I may disagree with your rulings,
Sure.
but I respect the court. I always have to respect the court.
And I wasn't insinuating you weren't. I'm just making sure I understand what
But instead of arguing consent, we're just going to put the burden where it belongs, which is on the state. And we are going to argue that they do have to prove that it was against her will without consent.
All right. Thank you. Anything further? Okay.
Understood, Your
All
Honor.
right. And are we then finished with 23210? Let's go back to page 15. Anything else from the state on 23210?
No, Your Honor.
All right, Mr. Cruz, are we finished with 23210 or anything else we need to talk about?
Court's indulgence, Your Honor. It's- But no, so we're going to do it twice, one for anus, one for oral?
That's correct.
Okay, let's go.
I mean, that's what you said you were fine with.
Correct.
Okay. All right, let's go to the next page then. and to the state's request 23015, and of course then 23017. And the state has only requested these.
Yes, Your Honor. And what I would request is the way that what we submitted was a little bit more tailored, and I would just say that sexual battery, aggravated sexual battery not be included, that the state must prove that the alleged victim did not consent to sexual intercourse or aggravated sodomy.
Are you asking for the rest of it to be there too? If you find that the victim was not mentally or physically capable of consenting?
I mean, I don't necessarily know that that is applicable here.
Let me ask Mr. Cruz about his position on State's Request 12, which is 23015.
Court's indulgence, Your Honor. Yeah, I don't believe this applies to the facts of this case. Incapacity to consent. There's no.
Let's back up. I understood Mr. Bolden's comment that you are not asking for that language. Am I right about that? If you find the victim was not mentally or physically capable of consenting, you'd be authorized. Are you asking to take that out in your request? That's what I thought you meant.
You know, and
I agree with the first sentence, but just the following language, it doesn't fit the evidence in this case.
I mean, I would, the court doesn't want to
I'm
get.
not sure 23015 fits this case at all.
And I don't necessarily disagree, Your Honor. I think if the court were to incline not to give that.
I agree. Yeah, I don't think it fits, but I think that first sentence is also in lack of consent.
Sure. Hang on just a minute. I'm sorry. All right. Is there any objection to the court not giving 23015? All right, Mr. Cruz.
No objection to not giving 23015.
Okay, we're going to cross that out then, and then we're going to go to 23017.
I would withdraw that.
Okay.
Can I look at the statute really quick, Your Honor? Not the statute, I'm sorry, the language.
I mean, the state is withdrawing it. If you wanted to request it, we can talk about it, but they're going to withdraw their request. But I'll certainly let you look at the statute and decide what you want to do.
Yeah, I believe 203017 fits the language because of the aggravated sodomy piece. And the particularly the oral charge of aggravated sodomy.
So tell me what you're asking, Mr. Cruz.
I'm asking for 203017 to be included in the charges.
Okay.
Thank you.
Mr. Bolton, any comment?
I leave it up to the court.
Sorry?
Whatever the court thinks is appropriate.
All right. If you have no objection and the defense has asked for it, then I will leave it in. I was going to eliminate it based on our elimination of 23015, but if you all are basically in agreement, we will keep it in. And I think it just needs to read to the words of aggravated sodomy. I'll just take out the rest of it,
I agree with that.
obviously. Okay. Let's go to, did you get that? 23017? Okay. 22021. Both parties have requested this. I think number 2 needs to be deadly weapon, would fit the evidence.
Yes, that's the way that it's
All right,
indicted.
let's see. Yes, it is indicted that way. So we'll cross out with an offensive weapon, put in with a deadly weapon. Okay, so with that change, both parties have requested it. Anything else, Mr. Cruz?
I'm matching up the language, Your Honor. Please forgive me.
Okay, that's all right. We'll go to page 17 also. In the top of page 17, we have to finish the pattern. I knew there had to be more to that pattern than just those 2 sentences. All right, when you're finished, go to the top of page 17 to finish discussing charge 22021.
And so at the top of page 17, Your Honor, I would ask that the sentence beginning with the word however read as follows. The state must prove that the defendant attempted to cause a violent injury to the person, period, and that second parenthetical not be included. I think that would be based on the way the charging language in the indictment. I think that would be the correct way the correct way for the court to charge the jury based on the way the state has brought that aggravated assault charge.
Okay. Any objection to what Mr. Bolden has just stated, Mr. Cruz?
No objection, Your Honor.
Let's talk about the next line, though, and make sure we're all comfortable with that. An offensive weapon is any object is likely to cause. That's okay. That looks right. Any objection to that last sentence? An offensive weapon.
No, I would ask that not be given. I think that's just probably part of the pattern that comes in if you use the object which when used offensively language. But since here the state has alleged a deadly weapon,
Got it. Yeah,
I don't think that
that makes sense. Right. Of course. Mr. Cruz, any objection to eliminating that line, an offensive weapon is any object, et cetera, et cetera?
No objection, Your Honor.
Cross that out. Let's go to 22023, deadly weapon. And in deciding whether, let's see what this indictment says, a knife, deciding whether a knife is a deadly weapon. This is 22023.
Can we, I believe it's undisputed that the knife was a deadly weapon. If the Honorable Court wants and if the state is willing to agree to it, I am fine with an instruction if the court wants to tell the jury a knife is a deadly weapon. But I'll leave it up to the state and the Honorable Court.
You're agreeing to the statement, a knife is a deadly weapon.
Instead of this one, because I don't think either party disputes whether or not the knife was a deadly weapon.
Okay. Mr. Bolden, any comment on the offer by the defense?
I mean, I think that's perfectly fair.
Okay, so we'll just say, period, a knife is a deadly weapon.
Correct. I was going to say the parties have stipulated the knife is deadly weapon, but you can say it that way too. I think it gets the same message across, so we're fine with that.
Okay.
The exact statute without the other part.
Say that again. Sorry.
The first part of 16.
Okay, so the next one, 26810, the state has asked for just A1, but the defense has asked for it too. What the defense asked for?
Let me read the statute, Your Honor. I'm trying to find it now.
Oh, I see. Okay, A1. So there's no pattern. Is there a pattern? Oh, there's no pattern in this. Got it. Okay. I'm sorry, I wasn't following you.
Under the pattern, it just says OCG.
Got it, okay. I think A1 is the only one that fits. But you let me know, Mr. Cruz, when you're ready.
Okay. Yeah, I agree with A1, Your Honor.
I'm sorry?
I agree with A1.
Okay, all right, so we will.
I'm sorry, I've gotten lost. Where are we?
We're on 26810 arson, but of course it's just the statute.
Okay.
And the defense agrees that what the state has asked for, A, and then 1 is what's appropriate.
Can I ask?
Well, oh, go ahead.
You want me to take out the letter A and then number 1 and put it as a
See. Yes, I think we should take out the letter A and the number 1. Sure, let me just read it again. First one. He or she knowingly damages.
And if I could be heard,
Yes.
I think what the state would ask, if the pattern only says to look to the statute, and I think that's what I understand, then I think the state's request would be that this charge read: a person commits the offense of arson in the first degree when, by means of fire, there's no evidence of explosive here,
Okay.
he knowingly damages any dwelling house of another without his or her consent, period.
I agree with that.
Okay.
No
He,
objection to that.
okay, so he knowingly damages, I'm sorry, he knowingly damages,
any dwelling
And instead of he, can we use the defendant? Oh, I guess it's the same.
I think it's probably more appropriate to say he as opposed to defendant. Yeah, I think more general in nature makes more sense. By means of fire, he knowingly damages any dwelling or house of another without
His or her consent,
his or her consent,
period.
period. Okay, and Mr. Cruz, you don't have an objection to that?
I do not.
Okay, so that's how we'll give it. Let's do the next one, arson, presumption of accidental cause, state's request 17, 26816. Let's see what the... Damage by means of fire is what's in the indictment. Damage by fire, so we're going to cross out the word burned, just for starters. And I think we cross out or as a party to it. There's no evidence about that.
Yes.
Thank you.
All right. Mr. Bolden, anything further we need to change from your request before I ask Mr. Cruz?
No, I think it's an appropriate statement of the law, especially when arson is charged, that they're all presumed accidental. So,
Mr. Cruz, any objection to the state's request 17, which it would read, the burden rests upon the state to prove beyond a reasonable doubt that the building described in the indictment was damaged by fire. Number 1, the building in the indictment was damaged by fire. 2, the burning was caused by a criminal act. And 3, the accused was the person doing the burning. Any objection to that?
No.
Okay, and then the paragraph below that about the law presumes every fire to be accidental or naturally caused until the state shall prove beyond a reasonable doubt that such fire is the result, etc. Any objection to that language?
No, ma'am.
Okay, we'll give it as requested with the changes that we just made. All right, let's look at 24040. State and defense have both requested this one. Let's see. We'll put on his person as opposed to his, her, or within arm's reach of his person. We can talk about what you all want. All right, let me ask the state first, and then I'll ask the defense what you want. Mr. Bolden, what do you think 24040 should read?
Yes, Your Honor. I think that it should read that for the possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with the blade at least 3 inches long on his person while committing malice murder. Because that's the way that it. Because that's the way that
Okay, that's
it-
indicted.
it is indicted,
I understand.
which is a crime involving another person.
Okay. Not which is one of the following, which is a crime against another person.
Yes, Your Honor.
Okay. Mr. Cruz, any comment on how the state has asked for that charge to be given?
None of that matter, Your Honor.
Okay. So it'll read this way. For 24040, it'll read this way. For possession of a knife during the commission of a felony, the state must prove that the defendant, 1, had a knife, 2, with the blade at least 3 inches long, 3, on his person, 4, while committing malice murder, a felony which is a crime against another person.
Yes.
Anything? State satisfied? Is the defense satisfied with that?
Yes, ma'am.
All right, thank you. Let's go then to the next page. We'll cross out the controlled substance, obviously, information at the bottom. 130, 130. Both parties have requested this. Mr. Bolden, what part of 130, 130 are you asking for? I'm not inclined to put in the 11th Circuit information. I mean, I'm inclined to just stick with the statute. The pattern. But I'll hear from both of you about including the extra language. I think the extra language is taken care of in the pattern. But.
Yeah, I would agree with the court to give that the first 2 paragraphs and then not the pattern jury charge from the 11th Circuit. I have no problem with that, Your Honor.
Mr. Cruz?
I believe it's the same, so.
Okay. All right, I'll cross out the 11th Circuit opining because it's really taken care of in 130, 130. Okay, 130, 140. And this was requested by both parties.
So can I go through this one with you, Your Honor? Kind of save the court some time. So I don't think anything came out for character and truthfulness. I was on cross, so I didn't bring in any reputation, evidence of opinion or other witnesses regarding a person's character for untruthfulness. Bias towards a party. Now, I believe I elicited it, but I will at least say I attempt to elicit it through Detective Ricketts when I asked him specifically, why are you defending Chris Melton? And the purpose of that question was to support that charge, Your Honor.
All right, so let's do this in pieces.
Okay.
You are offering that the component of 130, 140 that applies to character for untruthfulness is not applicable.
Correct. That is not applicable.
Let me ask Mr. Bolden, any comment on that?
I don't believe there's any character for untruthfulness.
I agree with both of you. Okay. Mr. Cruz has made an argument to keep in bias toward a party. We've got to read how to do that. In general, do you have a comment on Mr. Cruz's request?
And I'll pull up the statute just in case.
There's nothing about criminal convictions. We're going to get rid of that.
So I guess my position as to bias is I don't think that this is the pattern charge that would relate towards bias in the way that has been shown in this trial. I think it would go to the credibility, the general credibility charge, which I can't even remember at this point if we've discussed or if we will discuss, but that charge has the language about how they may consider their, manner in testifying, the facts about which they testified, and any bias. And I'm paraphrasing because I can't think of it right this second, but that would be.
And I could fully flesh out that argument, John, in regards to bias. I think that was just one component of it. A bigger piece of it was once the investigation started in regards to Mr. Faust and our examination with Ms. Bigham. And the larger piece of that argument, without going into all the other components, the larger piece of that argument was, if I can remember the statement, and I'll paraphrase the statement, when we had the discussion during the examination regarding the statements made to Chris Melton regarding the actions he should take moving forward. So I do believe we brought in different pieces of evidence through testimony supporting that charge.
Okay.
And the status departed, just to make it clear, the
I understand
status,
what you're
the
saying.
status would be.
I want to just see if we've kind of given it in another way.
Sure.
And
The statute. Yeah, go ahead.
what I was referring to is 1.31.10, where it says that credibility of witnesses, the jury may.
I keep doing that to you. All right, hold on. We only have one computer. Let me pull up 131.10 before you get started, and I don't want to lose what Miss Ellis is doing on the computer. But thank you. All right, go ahead, Mr. Bolden.
Yes, Your Honor. So that again, like I think we've already gone over that particular charge, but if not, I know that we will. But
It's in the beginning of the charge. We have gone over it.
and so the jury will have been charged on general credibility, and part of that is their interest or lack of interest in the case. So I think that's the type of. I think that's what Mr. Cruz is getting at. I don't think that bias towards a party shown by bad acts, being specific instances of the conduct of the witness, which is in 131.40, is what is contemplated here. So I would ask that it not be given. I know that was part of our requests, but that was anticipating what some of the potential evidence today may have been.
All right, thank you. Mr. Cruz, anything further?
I would just stand by my argument, but I'll leave it to honorable court's discretion.
So I think I agree with the state in terms of this particular pattern, and I don't disagree with your assessment that the issues concerning whether you want to call it bias or interest or lack of interest has been brought up by the evidence. I mean, I think certainly both arguments support that, but we're talking about the pattern, and the pattern, I think it actually would be very confusing to give this charge in the manner in which it is patterned, because it does talk about bias and bad acts, and that doesn't comport with the evidence. So I'm not going to give it in this manner. I do think the issue of whether you call it bias or interest or lack of interest in the case has already been given at the beginning of the charges, and so I'm just not going to give 131.40. I think it would be very confusing. It doesn't really comport with the evidence in the manner the pattern provides. So, all right. So we'll move on to 131.45, and I think we've already talked about this. We already have this in our, we've already given this earlier. Let me just make sure. You moved to 131.45. Okay, we're good. All right, let's move on then to 131.47. The defense has requested prior statements.
I don't have any objection, Your Honor.
All right, and let me just read it. Anything further, Mr. Cruz, you want to say in your request?
No, ma'am.
Just as this, all right. All right, I thought that, don't we already give this? I mean, I don't have any problem giving it, but I want to say we already, I feel like this is in our,
It is. It is.
Yeah, okay. I'm not going to give it twice. So
So
let me
just
just find it, what page we're on, but we already give
I'm
this.
I'm at the bottom of page 9.
Okay. Yes, it is. It's the bottom of page 9. Yeah, okay. So we're not going to give it again. We've already given it. But your request is granted. Okay. 13190. Is that not also in the? Okay, that's not typically in there. I give it all the time. That's why I'm sort of thinking. Okay, 13190. Both parties have asked for 13190. Mr. Bolden, anything else?
No, Your Honor.
Okay. About that. Mr. Cruz, 13190, single witness. Anything else you want to offer with regard to that?
No, ma'am.
Parties have requested it.
No, ma'am.
I will give it. 13216, statement of defendant. You both have requested it. All right, I think at least the while in custody is appropriate.
Was it shown that he was in custody in that video?
Yes. The evidence was presented that they asked to remove the handcuffs, and that was shown. Yeah. What's 134.50? Okay, we're going to pull up 134.50. You both have asked for this. Mr. Bolden, anything further you would ask for?
No, Your Honor. I think that both of the parentheticals would be applicable here.
So how are you asking it for it to be read? Obviously, we're going to get rid of OCGA 24.
Sure. Just exactly as it reads.
Statement was voluntary, comma, if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. Is that correct?
Yes.
Without the parentheses.
Yes.
All right, Mr. Cruz?
I'm reading it, Your Honor.
Okay.
1 second.
Set up a WebEx for Kindle Green Monday? Wow. Well, I just asked both of them how long it would be. This would take a long time to get it. So I guess I haven't heard that. I mean, I don't know the way to get to it. Okay. Oh, okay.
All right, no objection. Obviously, we're removing the limiting instruction conditional admissibility language.
I was just reading that 134.50. I don't think it applies, but I mean, I'll hear from you if you think otherwise.
No, it doesn't apply to that.
Okay, so are you satisfied with the way you both have asked for 132.16? Are you satisfied with how it's written there without the parentheses?
Correct.
Okay, we will give it 132.17. Both parties have asked for it. I think I'm going to, as you go through 132.17, next page, 23, the top, I'm going to get rid of the statement in determining voluntariness because we basically said that twice, and I don't want it to be confusing. I don't think we need that, but I'll hear from both of you. Mr. Bolden, do you have any objection to just 132.17 as
No, Your Honor.
on 22? Okay, Mr. Cruz?
I'm reading it, Your Honor.
All right. This is a request by both of you.
Okay, you're saying on page 23 at the top, you're taking out.
Yeah, it's been said several times, and I just think it's.
Okay. But otherwise, I have no objections to the vote.
Okay. All right, let's do 132.18, next page, page 23. The defense has requested this one.
And Your Honor, understanding that Mr. Cruz and I might disagree over the legality of the detention based on our motions back in the fall, I would object to this. I don't think this is the type of situation that charge is designed for. If the court were to give it, I would ask that it read as follows. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made, but not give what's in the parenthetical.
Right, thank you. Mr. Cruz? You offered this.
I just double check it, please, Your Honor. I would request it, but I would leave it to the honorable court's discretion.
I don't think it fits the evidence. And, you know, I think it would be confusing. There's been no evidence concerning this particular kind of a charge, so I'm not going to give that charge. 132.19, burden of proof as to voluntariness. Both parties have requested it.
I don't have anything to add, Your Honor.
Anything further, Mr. Cruz?
Just checking the language, Your Honor.
All right.
And I know I request, I just always double check the.
I know I'm going fast. I want to make sure you get a break before 2:30, so.
Okay. I'm fine with it.
All right, let's go to the next one, constitutional rights. Both parties have requested that. We'll cross out her, just for starters, the word her. Cross out she. We're going to want, well, first of all, any comments on 132.21?
No, Your Honor.
All right, what about, you both requested topic 24 where it says anything, and I'll cross out she, he said, wrote, signed.
I mean, I think, if I remember correctly, when Agent Bigham read Mr. Faust's rights, she used the word said. And so I don't think wrote or signed are necessarily applicable.
I have no objections to the language, Your Honor.
We'll just cross out the words wrote and signed, and obviously the word she. Okay, the next one, 132.40, the defense has asked for this.
I think that's a.
We've given that in 132.19.
We did give that in 132.19?
Well, it's basically the same thing.
I think 132.19 is specifically to voluntariness. 132.40 is in regards to just the Miranda rights as a whole. Because I think with waiving a right is intelligently, voluntarily, and I believe I'm missing one. I want to say freely, but I don't think that's appropriate.
I would say that the state does not have an objection to 132.40.
All right. I mean, it is a bit redundant, was really my hesitation. And I'll just, this is why. 132.19 and 132.21 deal with all of the things that are in 132.40. But
whatever the honorable court's rule.
well, you've requested it. And even though it's redundant, that was really only my concern. But if the state is not objecting, I'm not going to make a big deal about the redundancy. It's not overwhelming, but that was only my concern, not that it isn't the proper law. So we'll give it. 132.50, both parties have asked for this.
And so, yes, my only comment, Your Honor, is to just get rid of the parentheticals at the end.
I have no objection to that, Your Honor. And 13270, I would ask to be removed. I don't know how.
You're going to withdraw that?
I am.
Okay. Okay. So I guess my only concern, even though you both have asked for 13250, is, again, the issue of redundancy. I mean, we're sort of saying it over and over again, and in just slightly different ways, and so that's my only concern. But I'll hear from the state first and then Mr. Cruz about that issue.
I mean, I would agree with the court that it is redundant. I just know that in every trial that I can recall in which a defendant's statement was played, I think there is just that extra caution to make sure a jury, and so I don't disagree with the court's the court's concerns about it being redundant, but given that it is all part of the pattern, I don't object.
All right, Mr. Cruz?
I would agree with the state.
All right, I'll give it. Let's go then to 25. We've crossed out 13270. We're on 134, limiting instructions. I don't think we had any of those.
Well,
Did we?
there could have been that 413 evidence, Your Honor. The state opted not to introduce that evidence, so I don't think it's applicable in this case.
I think we do have it in regards to Ms. Sims. You told me we could take it up at the charge conference in regards to her statement that what she tested was sperm, and we went through cross-examination, and then she said, well, we didn't, I didn't test it for sperm. I didn't know about the report that it was sperm. At the time, you told me to address it now. I would ask for a limiting instruction to the jury in regards to that statement that she made. And if the court is willing to give that limited instruction, I would ask for this pattern charge. But if the court is not inclined to give a limiting instruction, obviously this would not apply.
So describe for me, Mr. Gray, and I remember the conversation, but
Yes, ma'am.
describe for me why you think you can certainly talk about the limits of her testimony if you want to do that, certainly, regardless of whether she was tendered as an expert. I mean, you can certainly go there if you want to. But in terms of the charge, tell me how it applies to the request for charge.
Sure. The charge only applies if the Honorable Court is inclined to give a limiting instruction in regards to the testimony. If the Honorable Court is not inclined to give a limiting instruction in regards to the testimony,
Right.
the charge is not it's inapplicable.
Sure, but I guess
applicable to this
what
case.
limiting instruction would you be referring to? I guess that's what I'm
The
asking.
only thing I would ask, because there is no evidence of semen in this case. Outside of Detective Bigham saying that Chris Melton's semen was found, every other test, everything looked at it in the testimony, no testimony came out in this case that semen was involved. When Ms. Sims, who just did the differential extraction, she started saying, and I may say the wrong, I think she said either semen or sperm, but she said one of the two. She started using that language. And that's when I objected and discussed saying with the Honorable Court. I would just ask the Honorable Court to give a limiting instruction to disregard, and she corrected it after I made the objection. She stopped referring to it as that. But just to give the jury an instruction to disregard Ms. Sims' characterization as the DNA evidence as sperm.
Okay, thank you.
Yes, ma'am.
Mr. Bolden, would you like to respond?
Yes, Your Honor. I don't believe that's what this pattern jury instruction is designed to address. The issue with Ms. Sims the other day, I don't want to, no need to get back into the evidence, but I think if Mr. Cruz had requested a limiting instruction at that time, I could see it. But this is designed for extrinsic acts and the court telling them that they can only consider that for a specific purpose. That's where it falls in the pattern. It's not applicable.
I agree with you there. I agree with him in that position, looking at it.
Thank you. Yes. Okay, so before we get to the next page, both parties are agreeing that 134 does not apply right now. We're not going to give 134.
That I
You agree with that? Is that right?
Submitted for limited purposes or against some parties and not others, or for some counts and not others. Such evidence may be considered by the jury for the sole issue of purpose against. Or it wouldn't apply to what I'm asking for.
Okay.
But I would still ask for that limited instruction if the honorable court is inclined. But this wouldn't apply. I agree with the statement.
Okay, so I'm going to get rid of 134. I'm going to say with regard to the limiting instruction, based on how both parties have described the moment, particularly Mr. Cruz, your comment that it is the characterization of the evidence. I think if the court got involved at this point with doing what you're requesting, the court would be inserting itself into characterizing the evidence, which would be improper. So you can certainly argue and bring up however you choose to the jury. It's not limiting for you. But I think in terms of the court charging the jury, it would be improperly inserting the court's opinion, which it doesn't have, of course, but sort of suggesting the court had an opinion on the characterization of the evidence, and that's not proper. I'm just going to do it in that way. But I'm not limiting you in describing however you choose to how the evidence played out. So I'm not going to give 134. Both parties have agreed to that. Let's talk about 134.10, which does require 134.
I would withdraw that, Your Honor.
Okay, I don't think it fits the evidence. Right. All right, so the state is withdrawing that next one. All right. So now we're going to the next page, the middle of the next page, which is 134.20. And this was defense request. So I'll ask Mr. Bolden first. Any comment on 134.20?
I don't think there's any of that in the evidence in this trial. I'd ask that it not be given.
All right, Mr.
I could withdraw it. I withdraw the report.
All right, we're going to withdraw 134.20. 134.30 needs to be withdrawn.
Yes, Your Honor. Say we withdraw that.
All right. And the top of 28, of course, as well, is withdrawn. 135.30. And this is the state's request.
I would just ask that it be given as charged.
Do you want the words "or believability," which are in parentheses, to also be included?
Yes. Oh, I'm sorry.
You can offer your opinion. Go ahead.
Yes.
Okay. All right.
I don't have any issue with that.
Mr. Cruz, do you have any objection to how the state has requested 37?
I'm reading this statute.
Okay.
I'm in
All
the pattern charge now, Your Honor.
I'm going to get rid of the words admissibility, maybe ruled on, et cetera, because that's not.
Sure.
Just that little part.
Well, I think this is the issue here because I'm just now seeing this wasn't DNA comparison. This was actually, and maybe I'm reading too deeply into it. From what I understand from true allele and DNA comparison, one type is where a human does it and they compare it. And correct me if I say anything wrong. True allele is like a computer program that just says, hey, this is the likelihood ratio that this DNA or this pattern of DNA compared to this person would show. I'm trying to use correct language. Would pop up among a random member of the population, if that makes sense. So, but we could give it. I have no objection to it.
All right. I think it fits the evidence, so I will give it as charged then. All right, the next one is defense's request, 14010, definition of crime. That should have been given earlier.
It was.
Okay, so I'm not going to do twice, but I'll grant your request, but it's already been given. 14015, state's request.
And Your Honor, the only thing that pops into my head with this request is the burglary count, where we've alleged enter and remain within the dwelling house of another.
Okay.
I know sometimes it's almost maybe it's almost better to wait and see if they have a question about like the and or conjunctive versus disjunctive. And so I would be okay with the court not giving it, withdrawing that request at this time. But again, that I know that does happen from time to time, and then we have to give additional instructions. So that, I think that was the rationale behind that.
Okay, so you're going to withdraw it, but that does come up from time to time. Yeah.
Well, I would object to the instruction as a whole, because from what I understand from the indictment, everything is charged straightforward. And with the entering and remaining inside, I believe that's the state's theory of the case, that not only did Mr. Faust enter, but for a period of time, he remained inside and did these acts.
Okay. Any response?
Yeah, I mean, the state charges in the conjunctive can prove in the disjunctive, and I think that's very well established. But I think given all the other confusing aspects of the law, I don't necessarily want to interject another one unless they specifically ask. So I guess that's kind of the dueling concerns that I have.
Well, I think that it's probably best to address that issue this way, to not give it as charged. I do think it is probably confusing, and I agree with you, Mr. Cruz, in the concern about giving 140.15, but it is an accurate statement of the law. And so I will just say this: if it comes up in a question, we're going to have to talk about how the court needs to respond to the question. And it may be that the court has to respond to the question this way, because this is the law, but I'm not going to give it as a charge. All right. 141.12 is requested by the state.
I would withdraw that, Your Honor.
I think it fits the evidence. So that is withdrawn. 150.10, statute of limitations. There hasn't been any evidence about statute of limitations.
Well, and again, this came up when we were talking about CODIS the other day, Your Honor. So on some of the counts would have statute of limitations issues, but that statute was told based on the date that law enforcement received the CODIS hit, and that is alleged in the indictment in multiple counts. I believe beginning with count 6.
Okay. All right.
On, and so I think that's a material element that the state does have to prove. Now the question is, I don't know what the statute is on some of these crimes, or at least what it would have been.
It's 4 years for felonies. I think murder, and I could be wrong on the murder one, so double check. I think it's 7 years if the person is known. If the person is unknown, it's an unlimited statute of limitations.
Well, and that's not, there's no tolling language alleged in the counts alleging murder or felony murder. It's the predicates.
So for the underlying felonies, 4 years is what I believe the window would be. But double check me. I'm never too certain.
I guess my concern, I understand exactly what you're saying. I think we have to figure out how to do this right, because there has been no discussion at all, and no evidence, I should say, no evidence at all about the phrase statute of limitations. And so this would be the first time, right, the jury would be hearing that. And so
I think it applies to the indictment, because they will have the indictment and will have that language on it. And the state, that is something the state does have to. Oh crap! We didn't get into that intro.
I guess in the problem is the language of this indictment doesn't talk about the statute of limitations in that sense. It talks about it in a different way. Perpetrator,
Yes.
the crime alleged was unknown to the state of Georgia. So, I understand exactly what you're saying. I just think we have to tailor this so it makes sense. And maybe we do it this way. I don't know.
Can I have a second, Your Honor?
Of course.
I may have a motion. I just want to look up something really quickly.
So, Mr. Bolden, I would imagine on page 30, you would want me to put all the charges, the accused is on trial for the offenses of, and list all the charges, right?
Yes.
Okay.
And then I think it would, what I would then ask, under Georgia law, prosecution for the offenses of,
And then list them all. 1 through 8, okay?
and then,
Prosecutions for these offenses.
well, so this is confusing. I agree with the court. So I would say that laws of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for, and I would ask that the court read all of them, and then say that under Georgia law, prosecution for the offenses of, and then start with count 6, burglary, count 7, aggravated sodomy, count 8, rape, count 9, aggravated assault, count 10, aggravated sodomy, count 11, arson, count 12, possession of a knife during the commission of a felony. I don't necessarily know that you have, I'm asking the court to read those count numbers, but say that under Georgia law, prosecution for the offenses of, and then list those 6 or 7 offenses. Those offenses must begin within 4 years after the offense has been committed. And then I think maybe the court could see where I'm going from there as to how to tailor it on 150.11 and 150.12.
Right, and I'll hear from you, Mr. Cruz, in just a minute. I'm trying to figure out how to do this. So you go from under Georgia law, prosecution for the offenses of what's in count 6, 7, 8, 9, 10, 11, and 12 within 4 years after the offense has been committed. In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that B, the person committing the crime was unknown.
Exactly.
Get rid of everything else. And then we can talk about whether the language, if you find from the evidence that this case was not filed, blah, 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 we can talk about where that goes. When the statute of limitations is raised. I think we just say the burden is on the state. Get rid of when the statute of limitations is raised, because it hasn't been raised.
No, and I think of it as like a venue issue. You know, the court's always going to charge on venue as a jurisdictional fact. I think that the statute of limitations is a jurisdictional fact as well. And so that's why I think it's, even though it hasn't been raised, that it's important to put that out there.
What is your position on the language? If you find from the evidence that the indictment or accusation in this case was not filed within 4 years after the offense was committed, it would be your duty to acquit the defendant.
So I don't think that that is tailored to this case. I would say that, again, going back to 150.10, under Georgia law, prosecution for the offenses of, listing those offenses, must begin within 4 years after the offense has been committed. I would ask the court not to give that last sentence. And then say that in calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that the person committing the crime was unknown. And I think that that would be tailored the case and to the way that the indictment, has been drafted.
All right. Mr. Cruz, sir, any comment on what the state is asking for?
Where's that language, Your Honor? I'm looking for the language that you mentioned.
Okay, so we jumped around a bit. Let's go to page in your documents. Bottom of page 29 is the state's request 43, which is 15010. And this is what the state is offering. Now I'm at the top of page 30. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for the offenses of, and it would list 1 through 12. Next sentence. Under Georgia law, prosecution for the offenses of what's in count 6, 7, 8, 9, 10, 11, and 12, and of course the court would read those offenses, must begin within 4 years after the offense has been committed. And skip down. In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that the person committing the crime was unknown.
Question. I believe did you say the paragraph where it says if you find from the evidence that the indictment or accusation in this case was not filed within blank number of years after? Yes, the state has asked to eliminate those sentences. And I think that's proper to eliminate that sentence. The only thing I would say is because the state has that burden, I think the follow-up sentence, the person committing the crime was unknown. We're not going to argue statute of limitations, but in regards to the jury's understanding of the case and having the indictment, I would just ask for it to be present. But I don't think that's anything we're going to argue. But I think it kind of flows into 15011B.
Okay. I'm not going to give that portion of it. I do think it's confusing because on the one hand, we're talking about sort of the tolling and then reinserting back in language, well, if you find it hasn't been accused or indicted within a certain period. I think it's very confusing, so I'm not going to give it. But let me ask you, Mr. Cruz, before we get to kind of the rest of it, top of page 31, the state requested 45. I have eliminated the front part of that where it says when statute of limitations is raised and just put in there the burden is on the state to prove that the offense occurred within the statute of limitations or occurred within an exception beyond a reasonable doubt.
I would ask for the statutory language, Your Honor. So I would object to that portion being removed. Not statutory, I'm sorry, the pattern language.
Okay, let me look at the pattern. Can you pull up 15012? Okay.
What you have is.
That is the pattern? Okay. That is good. All right, this is the pattern. Okay.
And my response, Your Honor, would just be that because the statute of limitations has not been raised,
Right.
that telling them that it has is going to be confusing. So I agree with the court to just start that charge 15012 with the word the. The burden is on the state to prove that this offense.
I think that makes sense. I think we need to start with the burden is on the state. That is the pattern with the exception of when statute of limitations is raised. All right, the next one is grave suspicion. Does the defense, the defense ask, I don't know if the defense asked for that or not. I always have it in there.
I did ask for that, but I don't see it on.
It's right below, it's next. Yeah, it doesn't have a title. Where it says facts and
Understood.
circumstances. Yes. Do you see it, Mr. Cruz? So do you see 15012 on page 31?
I do.
Okay, right below the very first.
I see it.
We just didn't label it. Mr. Bolden, any objection to the court giving grave suspicion?
I mean, I always do. I would object if the court were inclined to give it. I would ask that it go up with all the other information about reasonable doubt. The state's position is that, there are cases that hold that it is unnecessary, that it is adequately covered by the court's charge on reasonable doubt, burden of proof, things like that. So I would object.
Okay.
But if the court were to give it, again, I would ask that it be related to those patterns.
I think that makes sense. I've always felt that we've always had it at the end, and it feels a little bit weird reading it out of context. So I am going to give it. I'm going to grant your request, Mr. Cruz, and we'll put it in where all the other issues of the state's burden of proof is, I should say. We'll put it there. All right. The rest of this is, I'll let you all look at it, but page 31, and I'm rushing through because I want to give you all a little bit of a break. 31, 32, and 33 are the basically the new instructions. They're not really new, that the Council of Superior Court Judges has issued about how to talk about the indictment and going in the jury room and things of that nature. This does not vary, I would say, amongst the superior courts. This is the standard, appropriate comments the court makes about these things. And so I'll ask you to look at them, but I always give these, every superior court gives these. This is the modern, new version. The newest version is really at the bottom of 32, where it says these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. That actually was added in by the council. And so unless there's any comments you all want to make on those, we're going to keep those in there.
The only thing I would say on 31, where it says as to the 12 counts of this indictment,
Okay.
if the court might consider putting as to each of the 12 counts of this indictment, and that's really splitting hairs, I realize that, but just the idea that it's not.
I mean, I think that makes sense.
Thank you.
Any comment on that, Mr. Cruz?
No, ma'am.
Okay. All right, and unless you all have anything further you want to add for the deliberation charge, again, I don't really want to add anything to the deliberation charge. I think and the Supreme Court, of course, approves the charges that are changed. I think they've come up with the language that is best. I don't really want to add or subtract the Supreme Court's direction about how to speak to the jury about deliberations. I think it needs to be uniform across the board. And so unless there's something we need to talk about, I want to keep it as is. Anything else?
No, ma'am.
Okay, all right. We'll be in recess till 2:30. We'll see you all then. We're going to get this written up. Thank you. Okay, we're going to email it. Counsel at the bench for a moment, please. The case of the state of Georgia versus Edrick Faust, SU 24CR0547. And I am just making a comment to the audience that is here before the jury comes out. The audience is packed. I would ask all of you, first of all, if you have a cell phone on you, to make sure that it's off and either in a purse or your pocket or a coat jacket or something of that nature. For those of you who have been here for a long time, you know I've said this several times. It is impermissible for anyone to record anything going on in the courtroom, to take any pictures or anything of that nature. The only persons that are allowed, of course, are media, and they all have badges. And so I'm not speaking to all of you. You all have been incredibly cooperative, and I really appreciate it very much. So thank you to all of you. But for everyone else who has not been granted, of course, a Rule 22 permission, make sure your cell phone is away. And if it is in use, the deputies are going to escort you out. And so that's kind of where we are. I'm going to ask everybody to remember that this is a moment for the attorneys to speak to the jury and to please refrain from any talking, any comments, any audible noises of any kind. It would be very distracting, particularly for the attorneys who are trying to concentrate. So I ask for your cooperation in that regard. All right. Is the state ready to bring the jury out?
Judge, I think Agent Bigham was on her way up.
Okay.
This has the state's
Okay.
closing PowerPoint.
Okay. We'll wait for her to get here. She's in the building.
She is.
Okay.
She was literally just on our third floor office space. So I think she'll be here in just a moment.
Okay. Other than that, state ready.
Yes, Judge.
All right. Mr. Cruz.
I have one question.
Sure.
The state introduced Mr. Faust's video as an exhibit. We have different timestamps. Is it okay if I use, because it's in evidence, but I have a version where the timestamps are different. I can just go to the portion they played. Can I use that portion for closing? It's the exact same video.
Sure. I mean, I would say as long as it's the portion that everyone, you both stipulated to was admissible. I mean, doesn't matter to me what number it is on your computer, as long as we're clear on the portions that have been admitted. So, sure. Anything you want to respond to that? Okay.
No, I mean, as long as it's only the portions that were published to the jury,
Right.
I don't have any issue.
I mean, that's what I mean. Right.
Wilson start working on getting the items that we'll need for closing out of discovery. Is that okay?
Yes. Let's go ahead and get that taken care of. And we're waiting for Agent Bigham also. So. I guess while I'm thinking about it also, this is not for the attorneys. This, again, for the audience, I'm going to ask that you all remain seated until we take a break. It may be that somebody does need to leave, and I certainly understand that. But if you can limit, please, your entering and leaving and coming back into the courtroom, it would be very much appreciated. It's really distracting for the attorneys, quite frankly, and I certainly want to give them all the most opportunity they can to concentrate. So I thank you in advance for your cooperation.
I'm going to go briefly to begin with, and then I'll conclude. Yeah.
Yes, ma'am. Please don't tell me the computer went down. Counsel at the bench for a moment, please. The case of the state of Georgia versus Edrick Faust, SU 24CR0547. And I am just making a comment to the audience that is here before the jury comes out. The audience is packed. I would ask all of you, first of all, if you have a cell phone on you, to make sure that it's off and either in a purse or your pocket or a coat jacket or something of that nature. For those of you who have been here for a long time, you know I've said this several times. It is impermissible for anyone to record anything going on in the courtroom, to take any pictures or anything of that nature. The only persons that are allowed, of course, are media, and they all have badges. And so I'm not speaking to all of you. You all have been incredibly cooperative, and I really appreciate it very much. So thank you to all of you. But for everyone else who has not been granted, of course, a Rule 22 permission, make sure your cell phone is away. And if it is in use, the deputies are going to escort you out. And so that's kind of where we are. I'm going to ask everybody to remember that this is a moment for the attorneys to speak to the jury and to please refrain from any talking, any comments, any audible noises of any kind. It would be very distracting, particularly for the attorneys who are trying to concentrate. So I ask for your cooperation in that regard. All right. Is the state ready to bring the jury out?
Judge, I think Agent Bigham was on her way up.
Okay.
That has the state's
Okay.
closing PowerPoint.
Okay. We'll wait for her to get here. She's in the building.
She is.
Okay.
She was literally just on our third floor office space. So I think she'll be here in just a moment.
Okay. Other than that, state ready.
Yes, Judge.
All right. Mr. Cruz.
I have one question.
Sure.
The state introduced Mr. Faust's video as an exhibit. We have different timestamps. Is it okay if I use, because it's in evidence, but I have a version where the timestamps are different. I can just go to the portion they played. Can I use that portion for closing? It's the exact same video.
Sure. I mean, I would say as long as it's the portion that everyone, you both stipulated to was admissible. I mean, doesn't matter to me what number it is on your computer, as long as we're clear on the portions that have been admitted. So, sure. Anything you want to respond to that? Okay.
No, I mean, as long as it's only the portions that were published to the jury,
Right.
I don't have any issue.
I mean, that's what I mean. Right.
Wilson start working on getting the items that we'll need for closing out of discovery. Is that okay?
Yes. Let's go ahead and get that taken care of. And we're waiting for Agent Bigham also. So. I guess while I'm thinking about it also, this is not for the attorneys. This, again, for the audience, I'm going to ask that you all remain seated until we take a break. It may be that somebody does need to leave, and I certainly understand that. But if you can limit, please, your entering and leaving and coming back into the courtroom, it would be very much appreciated. It's really distracting for the attorneys, quite frankly, and I certainly want to give them all the most opportunity they can to concentrate. So I thank you in advance for your cooperation.
I'm going to go briefly to begin with, and then I'll conclude. Yeah.
Yes, ma'am. Please don't tell me the computer went down. Ready? All right, very good. I'm going to bring the jury out. Once again, counsel, we all ready for the jury?
Yes, ma'am.
Mr. Almachili?
Yes, Your
All
Honor.
right, very good. You may bring the jury out. Thank you. All right, you all may be seated. Welcome back, ladies and gentlemen. Thank you again for being on time. You have always, this entire time, you have really been on time, and I appreciate it. We are now ready to do closing arguments. This is the State of Georgia versus Edrick Faust, SU 24 CR 0547. Is the state ready for closing arguments?
Yes, Your Honor.
Is the defense ready for closing arguments?
Yes, ma'am.
All right, thank you. Ladies and gentlemen, I want to tell you a few things. The first is kind of our timing. We are going to hear closing arguments, and then the court, of course, charges the jury, as I mentioned to you all earlier. I'm going to then have you go into the jury room and elect a foreperson. I'm going to then ask the foreperson to discuss with all of you whether you want to deliberate tonight, starting tonight, or whether you want to go home for the weekend and come back on Monday and begin your deliberations. So I'm going to give you that choice. So I just want to let you know sort of the plan. We are doing closing arguments now, ladies and gentlemen, and I want to also tell you, as I told you at the beginning of the trial, that any statements made by the attorneys are not to be considered as evidence. Mr. Yalamachili.
Thank you, Your Honor. Court bears with me for just a moment. I'm going to reposition the podium. On January 19th of 2021, Tara Baker was taken out of this world. Her life extinguished by the defendant in this case, Edrick Faust. Mr. Faust entered Tara's home and caught her as she was going through her morning routine. He stabbed her, brutally bashed her head, and strangled her as he forcibly raped her, sodomized her orally, and sodomized her anally. When she was discovered by firefighters and police, her hair still smelled like shampoo. Ladies and gentlemen, you've heard the evidence in this case for 2 weeks and went through about a week of jury selection before that. And we're here at the closing argument after a family has waited 25 years for justice for their daughter. And it's time for you to write the last chapter of this story. The state, in closing argument, is afforded the opportunity to go both first and last in the summation. The reason for that is that we bear the burden of proof in this case. And that burden is guilt beyond a reasonable doubt. It's a burden that I accept readily. The burden never shifts, and the defendant is not required to present any evidence ever. And it's a burden that I accept readily on behalf of the state of Georgia because it is a burden that we meet by bringing you the truth, the facts, and the evidence in the case. Not conjecture, not unsupported speculation, not statements about the evidence that end up being false after you actually hear it, but the truth and the facts of this particular case. You have a 12-count indictment that you will consider. And during this initial portion of our closing argument, we are not intending to tell you the same things that we're going to tell you at the end. I respect your time. I'm going to try my best not to repeat myself. As it relates to count one is malice murder. And the law in this case will come from Judge Lott, and you should look to her jury charge in order to determine the law that applies to this case. But I expect that Judge Lott will instruct you that in count one, malice murder, it requires that the state prove that Mr. Faust did unlawfully and with malice aforethought on January 19th of 2001 caused the death of Tara Baker, a human being, by strangling her with a cord and stabbing her. And in count 2 through count 5, I believe Judge Lott will instruct you that Mr. Faust is charged with felony murder as it relates to the felony offenses of burglary, aggravated sodomy, and rape. And I believe that what she will instruct you as it relates to those offenses will come in the charge, and we will discuss that. After those offenses of burglary, aggravated sodomy, 2 counts, rape, as well as possession of a knife during the commission of a felony, you will receive further instructions. And one of those instructions that Judge Lott is going to give you is about what we just discussed, the issue of reasonable doubt. And I think what the judge will instruct you in part is a reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based on common sense and reason. And I know sometimes it can be difficult as a juror to understand how you should weigh the evidence, but I think that the end of that second sentence is maybe the most instructive as to what a juror's role is. And a juror's role is to seek out the truth in the evidence that is presented before you. Your job is not to seek out doubt. It is to seek out truth. And the truth in this case is that Mr. Faust is guilty of each of the offenses for which he is charged in the indictment. I think it's important when we discuss malice murder to talk about what is required of the state in order to prove that. The state does not have to prove premeditation. The state does not have to prove motive. Malice aforethought in the state of Georgia does not mean premeditation. The state has to prove that Mr. Faust caused the death of another person, Miss Baker. He did so unlawfully, meaning without any type of justification, and he did so with malice aforethought. And malice, as the term is used here, is not necessarily ill will or hatred. It is rather an unlawful intent to kill. This, as I stated before, the state does not have to prove premeditation in order to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. The malice in this case is clear. I'm not going to display in front of you now those images from both the autopsy and the crime scene that you've been subjected to. I know that they are not pleasant images to look at, but if you are looking for evidence of malice in this case, the manner in which Miss Baker's life was taken was all the evidence of malice that's necessary to support a conviction under the laws of the state of Georgia. I think that the judge is also going to instruct you on felony murder. And although she will give you an instruction at the end, I think it's worth bringing up for you as you consider the evidence as argued to you by the attorneys in these closing arguments. And I think what the judge is going to instruct you is that for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. In causation, as it relates to felony murder, I'd expect the judge will instruct you that you may find the defendant guilty of felony murder if you believe that he or she caused the death of another person by committing the felony of, and in each count it will have the predicate felony or the underlying felony that's the basis for those felony murder counts. By committing the felony of whichever felony is the predicate, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. And so when we're talking about burglary as a predicate act for felony murder, what we're talking about is the commission of that burglary, the entry into the home in order to commit the sexual offenses that are relayed in the burglary being a substantial and necessary part of causing the death. The evidence in this case establishes that. It also establishes the predicate felony of aggravated sodomy being, again, a substantial and necessary part in causing the death in this case. It also establishes the evidence in the case that the rape and then the aggravated assault of strangulation and stabbing Miss Baker as predicate acts of the felony murder also played a substantial step in causing her, substantial and necessary part in causing her death. So that's what felony murder means. It means committing a felony that plays a substantial and necessary part in causing the death of Miss Baker in this case. I know that's not something that jurors typically know of necessarily as it relates to the way that the law is applied to those circumstances, so I felt like it was important to go over those things with you. The possession of a knife during commission of a felony, I think the arson in the first degree is pretty clearly self-explanatory. It's clearly from when Mr. Faust takes the blanket out of the living room, lights it on fire, and goes to start the fire in Miss Baker's bedroom. Possession of a knife during commission of a felony. Obviously, the knife used in this matter is longer than 3 inches in length. I think that's been clearly established by the evidence in the case. And then that knife was used in a felony involving another person, that being Miss Baker's murder as alleged in the indictment. So as you're listening to the evidence, those are the things that you are listening for. As it relates to the rape charge, that is carnal knowledge, meaning that Mr. Faust penetrated Miss Baker's vagina with his penis forcibly and against her will. The evidence of force and against her will is very clear from the images from the crime scene. As it relates to the offense of aggravated assault in count 5, I think that the aggravated assault being the strangulation with a cord and the stabbing. As it relates to the 2 counts of aggravated sodomy, one is for the oral sodomy forcibly and against her will that was performed by Mr. Faust on Miss Baker, and then the other one is the anal sodomy forcibly and against her will performed by Mr. Faust on Miss Baker. Ladies and gentlemen, the next thing that I want to talk to you about is what is evidence and what is not evidence. Evidence is what you hear from the witness stand and the exhibits that are emitted, the videos that were played for you, and the things that will go back with you into the jury room. What I say is not evidence, whether it was an opening statement, whether it was in questions that I asked witnesses or anything else that I've said to you. This closing argument is not evidence. It is my argument to you about what the evidence shows. The same thing goes for the defense in this case. Nothing that Mr. Cruz says is evidence. No questions that Mr. Cruz asked are evidence. When there is a conflict between what you've heard on the witness stand and what it is that Mr. Cruz says or what I say, remember what we say is not evidence. So when Mr. Cruz says to you that the hairs that were found in Miss Baker's hands were going to be proven to be Mr. Melton's hairs, that
Excuse me. May I see counsel at the bench, please?
Ladies and gentlemen, you may remain.
Another outburst like that, those of you who have made the outburst are going to be asked to leave and you will not be able to return. I don't know if everyone who made a comment heard me say this when I first got started, but this is well, I'll just leave it at that. If there are any other comments like that by anyone in the audience, I'm going to stop the proceedings. You will be escorted out by the deputy, and you will not be able to return. And that goes for everybody that's in the audience. And I hope that I've made myself clear about that. Thank you very much. All right, your objection is?
Mr. Cruz demonstrated to you about Miss Baker fighting off her assailant while his hands were around her throat, clawing at his hands, and then reaching up and ripping his hair out. Remember what the evidence actually was. The evidence that actually came from the hair analysis told you that the hairs in Miss Baker's hands were her own hairs. Okay, so remember that when we're talking about what the attorneys say versus what the evidence is. When things have been said or claimed that were not supported by testimony from the witness stand, whatever they may be, those are not facts for you to consider because they are not facts that are established by any evidence in the case.
I want you to pay close attention to Mr. Cruz as he makes his closing argument to you. And when he gets done, I'll come back to talk to you about the actual facts and evidence in this case that prove beyond a reasonable doubt that the defendant, Mr. Edrick Faust, is guilty of each and every offense in this indictment.
Mr. Cruz, closing argument.
Hey, Your Honor. Tom started.
It has.
I want to thank you all. In regards to the state's comments regarding what we say, I agree. Okay, so if you heard things in opening that didn't come out during the trial, I agree. You cannot consider that. One thing you will learn is, or as Mr. Yalomachili said, the state has the burden. So typically we decide what we're going to present based on what we feel is the strength of the state's case. The case presented to you these last 3 weeks, including jury selection, is what can only be described as a story of negligence, a carelessness for the life and the death of Ms. Baker that extends far past indifference. As you've heard through this trial, we have brought you more facts about Ms. Baker than the state. We've brought you information regarding how Ms. Baker was, that she believed in justice, that she believed in fairness, and that she believed in listening to everything before making a decision. She's similar to a jury. The state is bringing Mr. Faust before you today to accuse him of crimes that he did not commit. And of course, you don't just take my words for it, you look at the evidence. The state presented no evidence that Mr. Faust, if it's his DNA, you have to decide if it's his DNA, and we'll get into that. But the state presented no evidence that Mr. Faust's DNA means murder. The state presented no evidence that Mr. Faust's DNA means rape. The state presented no evidence that Mr. Faust's DNA means burglary. The state presented no evidence that Mr. Faust's DNA means arson or any of the other charges that they charged him with in this indictment. Mr. Faust and everyone involved in this case would like to thank you for your time, your dedication, and your willingness to put 100% of your attention into this case. And put aside your very, we understand how important it is, but your very important personal and business matters. But most of all, I want to thank you all for your courage. Because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. And that's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, not anybody in this courtroom, You folks are the last line of defense between an innocent man and a system that has tried to break him. They falsely accused him, and that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases. It was corrupted by political pressure and a need to avoid admitting a mistake was made or mistakes were made in the initial investigation that you all heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to bottom. In our opening statement last week, we told you what questions to ask. We gave you a list of questions in our opening statement that the state would need to answer. And we warned you about the questions. We told you that the state will not be able to answer these questions with the evidence that they presented. And we begged you to try to answer those questions with the evidence that the state had presented. Those questions were, how does Mr. Faust's DNA simply being present in Ms. Baker's body, and again, you have to determine what the facts are. You may say it's not his DNA, but we're going to say worst case scenario if you say it is. How does Mr. Faust's DNA simply being present in Ms. Baker's body, along with 2 other DNA profiles, establish that he is the person that killed Ms. Baker? The next question, when did Mr. Faust's DNA get in Ms. Baker's body? Where's that evidence? If Mr. Faust killed Ms. Baker, how did Mr. Faust get into Ms. Baker's home? How did Mr. Faust get away from Ms. Baker's home unseen? If he committed the crime in the morning hours, I believe they said between 8 and 8:30 from the testimony in the stand when the individuals were seen walking in the neighborhood. If Mr. Faust killed Ms. Baker, why was the hair that was found in her hand, around her body, and on her body that did not belong to her, why was it of Caucasian origin? What evidence does the state have placing Mr. Faust in Ms. Baker's home? How does the evidence that the state has presented to you support that Mr. Faust broke into Ms. Baker's home, sodomized Ms. Baker, viciously beat Ms. Baker, raped Ms. Baker, strangled Ms. Baker, stabbed Ms. Baker in the neck, and set her apartment on fire while Ms. Baker lay dying? If Tara Baker was Chris Melton's future fiance, why would he forget whether she told him she would be alone the night before her death? You have to decide if that's something an individual that's been with somebody for 2 years would forget. Is that something a boyfriend or a husband or a fiance would forget if their loved one was killed due to being home alone? You have to ask yourself, how did Mr. Melton respond to Ms. Baker's death? And you heard the testimony on that, and we'll talk about that. But what I ask you to do is pay attention to the physical evidence. We're going to talk about the physical evidence. Pay attention to the science. The science is the most important thing in this case. The state wants you to believe that the DNA is everything. The science is going to be the most important thing in this case, and we're going to talk to you about the science. Pay attention to the medical facts that were given to you. But also pay attention to the integrity, which is the very essence, the integrity of this investigation. But you also saw something during the course of the trial that none of us might have expected. Something that should sadden us all. Something that maybe would anger us. On full display, you saw the lengths to which some, and only some, police officers will go to avoid admitting there were mistakes made in the investigation of Ms. Baker's case, to protect their own at the expense of the rest of us, at the expense of Mr. Faust, who is an innocent man. Before we examine the evidence in this case, which we absolutely will do, we need to understand the very foundation of the entire system of justice in which we operate. It is the bedrock on which this entire system is built. Reasonable doubt. And that term, you all have heard it before, but this term isn't just legal jargon. It isn't just a technicality, and it's not a slogan. It is a constitutional shield that protects the innocent and prevents the government from punishing without proof. The state has the high burden to prove every single element of every single offense that they've charged Mr. Faust with. And they have to prove that beyond a reasonable doubt, which simply means a doubt for which a reason can be given. Not a vague or arbitrary doubt, but a doubt based upon common sense and reasoning, as the state advised you. But I want to emphasize this because it sounds complicated, but it's very simple. It's a doubt for which a reason can be given. This doubt can be, and the judge will tell you this. What I'm about to tell you, you're going to hear the judge say the exact same thing. This doubt can be based upon a consideration of the state's evidence as a whole, a lack of evidence, or a conflict in the evidence. And those powerful words are not just some legal jargon. They're a mandate. They're your obligation. They're your community's protection against injustice. In our system of justice, Edrick Faust sits here today, presumed innocent. He's cloaked in the presumption of innocence, and it protects him like a suit of armor from the top of his head to the bottom of his feet. And that presumption is not fragile. It doesn't just disappear because there's a charge that comes about, or because somebody has a badge, or because the state has a theory. That presumption stands firm unless and until the state clears that high burden. The highest bar the law provides, proof beyond a reasonable doubt. That means at the end of this case, at the end of this trial, you think about one or more of the charges. You think, you know what? Maybe that's true. It might be true what the state is saying. Then, if that's your feeling, you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you think it's likely true or even very likely to be true, your vote is not guilty. Because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meet the extraordinary burden of proof beyond a reasonable doubt. Now, guilt beyond a reasonable doubt has best been explained two ways, in two different ways. One is pretty simple. We've already discussed the first way. It's a doubt for which you can state a reason. That's the simple. If you can state a reason for your doubt, that is the first definition of reasonable doubt. But that reason has to be based upon common sense and reason, right? We can't say an alien came down, committed this crime, and left evidence of Mr. Faust being there. That's fanciful. That isn't a reasonable doubt. A reasonable doubt is based upon common sense and reason. So don't violate your oath and say, well, hey, I think it's a conspiracy theory. Some other people did it, and they're just snatching up Mr. Faust. Let me make that clear. Some other people that have not been mentioned in this case, some other people in another country, aliens, animals, whatever. That is not a reasonable doubt, because that wouldn't be based upon common sense and reason. But if you could state one reason, a reason to doubt the state's case, your verdict must be not guilty. Now, as a jury, you have rules and principles just like we have them in our homes and in our businesses. We also have them in court. So you find a truthful verdict within the confines of the law that is given to you by the honorable court. So if you want to say the state never presented evidence showing how Mr. Faust's DNA means rape, there's no physical evidence or witnesses connecting Mr. Faust to Ms. Baker's home. And also add the fact that Dr. Falzone, who testified here, told us based on the injuries to Ms. Baker's anus, she was sexually assaulted anally. Dr. Falzone told us that. And before I follow up with the evidence, I want to mention one thing that is very important. The judge will tell you that you cannot presume that Mr. Faust in any manner acted with criminal intent. The state has to present evidence of that. You can't just say, well, his DNA is present, that's enough for me. It's his DNA. Well, he didn't explain the DNA, so he's guilty. The state has to explain Mr. Faust's DNA. The state charged Mr. Faust with rape. So the state has to show you, how does his DNA mean rape? Otherwise, that presumes criminal intent, and it violates the oath you've taken to follow the law given by the honorable court. The judge will also tell you to convict Mr. Faust. Not only must the facts be consistent with Mr. Faust committing all of the acts in the indictment, but they also must exclude every other reasonable theory other than Mr. Faust's guilt. Chris Melton killing Ms. Baker is not only a reasonable theory, it is supported by the evidence. And I'll start with Ms. Ashley Hinkle. She was the last witness you heard from. If you'll go to the last page on that. And again, no evidence came in about anybody running off, so I don't want you to consider that. You can't consider that. But this is what led us to say our case is where it needs to be. Ms. Hinkle, the states, this wasn't our DNA expert. This isn't somebody we hired. This isn't somebody we paid. This is somebody they brought in to support their case. Ms. Hinkle testified that DNA doesn't last in the anus for 5 days. And you may remember me asking her about the test where they had 5 swabs, and they tested the 5 swabs, and all 5 anal swabs came back negative. But at most, as we have, 3 days. And that's best case scenario. One of the journals said 2 days, but we'll give them the benefit of the doubt. We'll say 3 days. And the state came before you and said, well, it's a drainage theory. It's a drainage theory. You even had Chris Melton, and you have to decide how he knows this. I don't know where he got it from, but, well, I think I know where he got it from, but you have to decide where he got it from. He took the stand under oath and said, well, my DNA was there probably because of drainage. But this is the issue with the state's drainage theory. If we concede, I don't agree with it, but you have to decide what's truthful and what's not truthful. But if we concede that Mr. Melton was with Ms. Baker on Sunday and DNA only lasts 3 days, his DNA would have been gone by Wednesday. So for Ms. Baker to be killed on Friday and Mr. Melton's DNA to show up, it doesn't fit the physical evidence. It doesn't fit the science. And you may have heard the state ask a question, well, does the clock reset? And you heard Ms. Hinkle say, yeah, but it will require penetration. So if it number one, it wouldn't be there, but let's say hypothetically, it requires penetration. Whose DNA profile was the only identifiable DNA profile in Ms. Baker's anus? It was Chris Melton's. So even if you take Mr. Melton's theory, even if you try to give him the benefit of the doubt, it doesn't match the science. And you actually heard Elizabeth Bigham say that. We have to explain your DNA. It doesn't make sense. The issue is Ms. Bigham went to a lab way out in California. You heard the young lady come in, Ms. Lacone. She was very honest. She said, well, I've never been asked to testify about this. This is a presumptive test. Both of these tests are presumptive tests. This is her first time coming into court. Based on what she said, she has not been called in court to testify about this science at no other time. But what Ms. Bigham does, when Mr. Melton wouldn't change his timeline, she changed it for him. And this is the significance of the DNA in the mouth. If you'll go to the paper before it. I don't know if I wrote this down, but let's see. This is the significance of the DNA in the mouth. So what Ms. Hinkle told us is that DNA in the mouth at longest lasts 24 hours. At longest. So when Ms. Bigham was meeting with Chris Melton saying, hey, we need to explain this because we need to put it on bad guy, we need to explain it because we need to go after the one we want, she knew when Chris Melton was saying, hey, I didn't see her the day before, hey, I didn't see her 2 days prior, hey, I didn't see her that week, that was a problem for their theory. It was a big problem. Because she wants Mr. Faust, whose DNA was at one time was only in the mouth. But she has a problem because Mr. Melton's DNA is in the mouth at that time and the anus. So she doesn't go to a lab in Georgia, Tennessee, Alabama, North Carolina, South Carolina. We're on the East Coast. And we don't know how many labs she went to. We don't know how many times she tried to get this stuff tested and tried to get the opinion she wanted. Maybe she was expert shopping. That evidence didn't come in. We don't know. But we do know they flew someone all the way from California on taxpayer dollars to testify about these tests where this young lady says it's presumptive. This is a presumptive test. This is the evidence they brought you. And the reason they brought you that evidence is because they had to take Chris Melton out of the mouth. But they forgot about the anus. They forgot about the anus. In fact, the state didn't even ask about the anus. If you notice, when they presented their case, they just said mouth and vagina. Is that searching for the truth? The elected district attorney came up here and said, our job is to find the truth. I've given you good and bad facts on our side. Is that searching for the truth? Where you only ask questions in the same manner that Elizabeth Bigham asked questions, whereas to put everything on Mr. Faust. The science does not support that Mr. Faust killed Ms. Baker. The science, the timeline supports Chris Melton. He's continuously lied. Even Elizabeth Bigham had to admit, yeah, I told him it wasn't consistent with what he said 23 years ago, or for the last 23 years. When have you ever in your life, whether it's on television or any experience you've ever had, known law enforcement to tell someone, look, it's not consistent with what you've been telling us, but let me offer a suggestion of what you should say. You've never heard of that. You've never heard of that. If you weren't in this courtroom, you wouldn't believe it. If somebody told you outside that, hey, I heard about this case, you know, the lead detective is telling the individual to lie so they could put it on somebody else, you'll say, no way. This guy's nuts. He doesn't know what he's talking about because it sounds so unbelievable. But what doesn't lie is the science and the physical evidence. You heard their expert, not my expert, their expert talk to you about the timelines. I also want to talk about this, the anus as well. How is it possible that Mr. Faust is charged with aggravated sodomy? He doesn't leave his DNA, but he leaves Chris Melton's DNA. How does that make sense? Mr. Faust is charged with aggravated sodomy. for anally sexually assaulting Miss Baker, but somehow, some way, he doesn't leave his DNA. He leaves Chris Melton's DNA. That was supposed to be gone because, according to Chris Melton, he hadn't seen her since Sunday. That's the question that you all, as jurors, have to answer. Let's talk about Mr. Melton's actions. Okay? Mr. Melton came in here, he testified, you know, we had this relationship, we were close, I loved her, and he even came to you all and started trying to cry. He couldn't get the tears out, but he wanted to get you all emotionally riled up. And I told you all, be careful about the emotions in this case because they do want you to get emotionally riled up. However, when I started questioning him, what did he tell us? Yeah, we already went over these questions. Mr. Melton got on this stand, took an oath, gave you a performance, something that he had already started doing with the state before he came in this courtroom.
Hang on a second, Mr. Cruz. Let's wait. Whoever phone that is, that person is going to need to leave the courtroom. Ms. Cruz, just hang on a second, sir, if you would, please.
Does it pause my time?
Your time has stopped. Don't worry. Don't worry. I got you. All right. You may continue.
But he gave you a performance. And I'm sure before cross-examination started, you probably said, oh, my God, this terrible guy, this poor guy. He's so hurt by this. He's finally had opportunity to tell his story until I had opportunity to start asking him questions. And I appreciate him admitting that he met with the state. I appreciate him admitting that he went through these questions with the state. But you have to judge his credibility on the witness stand. Now, let's talk about his actions. We don't even have to talk about his actions in court because this is 25 years later. Let's talk about his actions the weekend of Miss Baker's death. So Friday, he goes to the police department. They didn't tell him to come. He voluntarily goes. The state wants to paint that as, oh, he's such a good guy. We didn't have to call him. He just came up here because he just wanted to be a good person. You lose the love of your life. Whose first thought is to run to the police department in a whole nother city? Not to comfort the family, not to call Mrs. Virginia Baker and say, oh, my God, what's going on? His job or his decision is, let me go to the police department. And then Saturday, what did Mr. Bill Teeter tell us? And again, this is evidence. Bill Teeter says he comes to pick up his truck. If I lost somebody when I was dating my wife 2-3 years and something like this happened, this tragic, I'm not thinking about a truck. I'm not going to pick up a car. I could care less about a car. The family wasn't picking up cars, I'm sure. They were trying to put their life back together and figure out what was going on with this shop. But Chris Melton, he's picking up cars. Sunday, well, we don't even have to go to Sunday. Let's go to Monday. Because police tried to emphasize over and over and over and over and over again. He didn't have a lawyer. He didn't have a lawyer. He didn't have a lawyer. What did, I believe her name was Miss Christie. Her old name was Christie Search. I cannot remember her new name. She has a new last name, though. But she worked at the bank. Monday, he's at the bank requesting a loan. That's evidence in this case. Monday, she dies Friday. Monday, he's at the bank requesting a loan. What would you need a loan for on a Monday? Probably legal fees, right? You call a lawyer. Hey, police are questioning me about this death of my girlfriend. What's your fee going to be? I don't know. We don't know what he went to the bank for, but that's something you need to consider. Chris Melton went to the bank on a Monday to get a loan. What does he do within a week of Miss Baker's death? On Thursday, he's at Mrs. Ashley P.V. Hall's house. She testifies to that. On Friday, he goes on 2 dates. Miss Ashley P.V. Hall told us on one of the dates, and she tried to explain it away, well, he's just a flirty guy. He just has a flirty personality. But he's flirting with the girl and he's rubbing her back. Your girlfriend just brutally died a week earlier. Chris, and I misstate things. I'm human. I am not perfect. I believe your notes, trust your notes. You're the jury. You decide the facts. I believe Chris even admitted to calling Ms. Hufford 10 o'clock past 10 p.m. And I believe he said that everybody was hurting, if I remember correctly. And that was the reason he was reaching out to her. But actually, if your girlfriend dies a week prior, why are you calling other women at 10 o'clock at night within a week of her death saying, well, you know, if you're out in the town, give me a call? Chris's actions support that he was angry with Ms. Baker after her death. Her death supports Chris Melton was angry with Ms. Baker. He told us she didn't engage in anal sex. What other way could you humiliate a person? If that's something she doesn't do, you do it anyway. He's living his life. He's not hurt. He's going on dates. She has a candlelight visual. He skips it. He didn't love Ms. Baker. He hated Ms. Baker. We don't know why. The evidence didn't come in. But he knows Ms. Baker has a candlelight visual. He's this great, dedicated boyfriend. He's just the perfect guy, just the nice guy. But she has this candlelight visual, and what Mr. Melton decides to do is, you know what, it's a country concert in Atlanta. Let me go see, give me a country guy. Who? Let's go see Garth Brooks. My girlfriend just died. Let's do a triple date to see Garth Brooks. And, you know, I'm going to blame it on her pretty much saying, you know, Chris, you don't need to be there. And I think somebody even came in here and tried to explain, well, you know, it was people they worked with. Chris had no need to be there. It is your significant other. Pay your respects if you care. He didn't care. He hated Ms. Baker. And the manner of her death supports the exact same thing. You don't have a stranger breaking your house. A stranger, never been there before, just picks your house out of any house in the neighborhood, breaking your house, and kill in this type of manner. This is a overkill. This is a overkill. This isn't a random stranger killing. Somebody wants to steal your car, they shoot you in the head, they take the car. They don't shoot you and keep shooting you and keep shooting you and keep shooting you and keep shooting you. Nothing was stolen out of the house but a laptop. What does a laptop signify? It's personal. It's information on the laptop. This isn't she had diamond earrings in her ear. She had jury in her room. Roommates, jury in their room, money in the room. Nothing's taken. The person that went into Ms. Baker's house was either led into Ms. Baker's house or they had a key. Now, I asked Elizabeth Bigham about the keys. I said, hey, do you have Ms. Baker's keys? What did she say? Yeah, I think so, but I don't know where they are. Or we may have them or they may be downstairs. I asked about the lock. Exact same answer. Now, the significance of those keys is twofold. One was Ms. Baker's house key on the key. And I asked Mr. Melton, did you see Ms. Baker enter her house? Because Mr. Melton would know what her house key looks like. A stranger wouldn't. A stranger wouldn't break into a house. A stranger wouldn't break into a house, take the keys, and say, let me see if this one fits. Nope. Let me try this one. Nope. Oh, this one works. And then run off. That's not something a stranger does. But a person that knows what your keys look like, or who has a key, they know, okay, I can get in and out quick. A stranger doesn't. Stay around and clean up your house. And Dr. Valerie Lowe said it best. She said, it's like somebody knew we weren't going to be at home. How would a stranger just, out of 6 people possibly being in the home, how would a stranger just pick the right time and then have the nerve to stay there and clean the place up? That's not a stranger. That's somebody that knew Ms. Baker. That's somebody that was angry with Ms. Baker. Ms. Baker didn't have a towel near her. She didn't have clothes near her. This was somebody she was comfortable with. And again, whose DNA was present? According to the state, Mr. Melton's DNA is in her vagina and her anus. But for the last 23 years, before Elizabeth Bigham got involved, his DNA was in her mouth and her anus. Whatever you think right, or whatever you think is right, you have to decide. You're the judges of the facts in this case. Now, you know that Chris Melton is a liar. It's been, Ms. Bigham said it. You heard the recording. You heard me ask her questions about the statement she made to him. This is inconsistent with what you said over the past 23 years, and that interview was in 2024. Mr. Faust is a truthful person. During his interview, he was asked about white women that he dated. He named the white woman that he dated, but he also said that he's had plenty of women in his day. And he told the investigators, I don't discriminate. I'm not a discriminatory person. Color doesn't matter to me. Dating, and you got to listen to the questions they ask because they want you to make assumptions. They want you to hear things one time and then start making assumptions. Dating signifies a commitment. They asked him about dating. Chris Melton claimed to date Ms. Baker. Mr. Faust didn't. They asked Mr. Faust, why was his DNA found in the house? Now, at this point, you know Mr. Faust's DNA was not found in Ms. Baker's house outside of it being in her body. They were asking him trick questions to see what he would say. And what did he say? What? My DNA? My DNA? I've never been in a house in Deer Park. I've never been over there. And again, the physical evidence does not lie. The science does not lie. The physical evidence tells you that Mr. Faust is telling the truth. Every single witness in this case that we talked about, what was found in the house, including the microscope, I think he was, I can't think of his name, but the expert who did the microscope with the hairs, he admitted, and I think it's bad science, but you have to decide, he admitted that there were no African American hairs found on, around, or anywhere near Ms. Baker's body. The physical evidence supports that Mr. Faust was telling the truth. The physical evidence supports that Chris Melton is a liar. After telling Mr. Faust that they had warrants for his arrest, they told him it was for murder. And mind you, let me not skip this point. They had already told him twice. So when you see him talking, he's already been told they have warrants for his arrest. He just isn't to the point where the warrants are for. But after telling him that they had warrants for his arrest for murder and aggravated sodomy, something significant happened. And the state doesn't want you to think about this. Just imagine you're at Walmart or you're just out and about living your lives. Police come and pick you up. They're talking to you and they say, you know what? We have warrants for your arrest. We already have the warrants. There's no getting out of it. For murder and aggravated sodomy. Something significant happens and police are aware of this. You panic because you're scrambling trying to figure out, oh my goodness, what the heck is going on? But they tell him this and then they ask him, and it's very important that you listen to what they say because you have to remember Elizabeth Bigham is biased. She's already told Chris Melton before she's met with Mr. Faust, we have to put it on this guy. You have to keep all this stuff into context. The interview with Chris Melton happened, I believe, on May 5th. I believe May 5th or 6th came in on the testimony. May 9th was Mr. Faust's interview. So she's already told Chris Melton, we're trying to get this guy. We have to go after this guy. So it's very important that you listen to the language of the questions that are asked. She asked Mr. Faust if he knew a girl, and this is a paraphrase, from a cold case from 2001. They didn't show Mr. Faust a photo. They have him freaking out. It's a murder warrant, the most serious charge in the state of Georgia. They don't show him a photo. They don't even give him the decency of telling Mr. Faust the young lady's name. So when he says, they say, do you remember him? He says, I seen a paper. I believe he says, I seen a paper when it first happened. And we have a photo we admitted into evidence. But I'll show you the media shot of Ms. Baker. Now, mind you, this is 24, 23 years before his interview. So it's been a while since he's seen this, as he said in an interview. But this is the media shot of Ms. Baker. We introduced a photograph, and Mr. Melton testified to it. Yeah, this is how Ms. Baker looked on a day-to-day. But they don't give Mr. Faust the decency because they don't care. They want him to say something so bad that's inconsistent so they could come before you and say, look what he said, look what he said, look what he said. But no, you need to look at what they did. Because it could happen to anybody in this courtroom. Look at what they did. And as soon as he said, man, I don't know that girl, all right, we got him. And now, let me make this clear. They already had the warrants. So I don't want you to think for a minute that they were giving him a chance to explain anything. The warrants were secured before they arrested Mr. Faust. But they could have just showed him this photo. Mr. Faust, do you know this young lady? Have you ever seen this young lady in your life? They didn't even do that. They didn't give him the decency, but they didn't want him to say he knew her. And Mr. Faust could have lied. He could have said, oh, yeah, the girl you're talking about from Deer Park, yeah, we talked, we dated. He didn't do any of that. He didn't do any of that. They never gave him an opportunity to understand who they were referring to, but now they want to use the evidence against him. You want to perform a shock and awe type of presentation on somebody, arrest them, tell them they're charged with murder and aggravated sodomy, and then have a gotcha moment. They didn't give Mr. Faust the chances or the grace that they gave Chris Melton. Elizabeth Bigham testified that Chris Melton said 7 times that he last saw Ms. Baker 10 days prior to her death. We went through it together. 1, 2, this is the 3rd time, this is the 4th time, this is the 5th time. 7 times Chris Melton said 10 days. But she comes in here to defend the 5 days because it fits the narrative. What you witness in this courtroom is a tragedy. It's heartbreaking. It's terrifying because this could happen to anybody. I have one. So in this little discussion that we just had, I've given you many reasons to doubt. We probably just discussed about 15 to 20 reasons to doubt the state case. You agree with one, you're done. If you agree with one reason to doubt, you're done. That is a truthful verdict. You must follow the law because that's what you took an oath to do. The second best way to explain guilt beyond a reasonable doubt is you compare it to making the most important decision of your life. And I hope that no one ever has this situation, but I'm sure you're all aware, or you may not be aware, so I won't mention it, but just imagine you have somebody in the hospital, somebody you love, somebody you care about, and they're on life support. And you're the person in the hospital waiting room, and the doctor comes to you, and the doctor says, pull the plug. If you could look at that doctor and say, doctor, go ahead and pull the plug. You've answered all of my questions. I believe, or I know Chris Melton's alibi was confirmed. I know that because I trust Chris Melton, just like law enforcement trusted Mr. Melton, or Chris Melton, excuse me. They said it did not have to be confirmed, so doctor, I believe the exact same thing. I'm going to ignore that the FBI told ACCPD, and that was from that testimony came in through Mr. What was the gentleman's name? With the report. I cannot think of the gentleman's name. That testimony came in through Griffith. I asked Griffith about the FBI asking him to search Mr. Melton's hard drive. And what did Mr. Griffith tell us? Despite FBI saying, hey, this guy hasn't been ruled out, he's saying, well, you know what, ladies and gentlemen of the jury, I know best. His alibi is confirmed. Don't worry about it. The FBI didn't clear him. But you may say, doctor, I trust Mr. Griffith. I trust what he said. although scientifically his DNA says that, although science says that his DNA should not be present 5 days in Miss Baker's anus, I'm going to ignore that. I believe the state's drainage theory, doctor. I believe what they said. I don't know how, but somehow it drained from Sunday to Friday, and it stayed there, doctor. And I also believe that Miss Baker and Chris Melton were in a loving, caring relationship, and he was destroyed by the fact that she passed away. I believe that, doctor, so pull that plug. I'm satisfied. My mind is set. And when your mind is satisfied, and you hear the judge talk about reasonable doubt and the mind being satisfied, if your mind is satisfied, you have enough information. And what that means is your mind is not wavering. Well, maybe it did happen this way, maybe it didn't happen this way. When your mind is satisfied, it said you have all the information that you need to make a decision. It is not unsettled. And at that point, you know what to do. We've all had those type of decisions. Do I want a McMuffin in the morning? Do I want hash browns? You know what? I'm going to go with the McMuffin. My mind is not wavering. It is settled. When your mind is satisfied beyond a reasonable doubt, you don't have any reason to doubt. And remember what we talked about. It's one reason. When your mind is satisfied beyond a reasonable doubt, you have no reason to doubt. You have to ignore Ms. Baker's roommates. And although on the state's examination, and I don't know the relationship they have with Mr. Melton now. I know it's a tough situation to come in this courtroom and talk about it. But they said, hey, they admitted when they were talking to police outside of this courtroom that Tara's relationship with, Ms. Baker's relationship with Chris, and I believe it was and I'll start with Ms. Valerie Lowe. Ms. Valerie Lowe told us that Tara herself said that her relationship with Chris was a distraction. And the day Ms. Baker was killed, like I stated, Ms. Lowe said it was almost like someone knew we weren't going to be home. Ms. Ashley P.V. Hall told us something inconsistent with what Chris Melton said. She had to admit when we were asking her questions that before Ms. Baker died, watching Ms. Baker's relationship with Chris Melton was just like watching the normal ending of a relationship. But you heard every law enforcement witness 24 years later, oh, it was a great relationship, it was a great relationship, it was a great relationship. But when we asked, who did you confirm that with? Oh, Chris. Mr. Faust didn't get that benefit. You'd also have to ignore that Chris failed to tell the police that him and Tara had a fight the week before her death. Right? And he came in here and he said, oh, well, yeah, it was a fight about a porno I had. It was an orange tape. He gave you this elaborate story about this porn to say we had a fight about a porn. Right? But I want you to consider that. I think that's a significant fact considering what occurred to Miss Baker when she passed away. Now, I don't trust Chris Melton. I think everything he says is not to be trusted, but you may. Miss Baker was sexually assaulted in multiple ways. If Chris Melton is telling the truth, the last fight they had was over pornography. And it was serious enough to cause a rift in the relationship. Now, with the laptop piece, we don't know if Miss Baker wrote Mr. Melton a letter, typed it up, so he needed to take the laptop. We don't know. That didn't come in. But that is something for you to consider. Their last fight, according to Chris, was over porn. Her death was sexual in nature. You would also have to ignore Chris's statement about punching this wall 30 times, I believe was his testimony. So Chris Melton's testimony was that he punched the wall 30 times, and that's what caused the injuries to his hands. But this is a question I have for you. When you look at Mr. Melton's hands, because he said it was concrete that he punched, where were the bruises on his hands outside of the scratches? Mr. Melton said it was concrete that was punched, but at what point did he seek medical attention? He didn't. Mr. Melton came in here and said, well, this is my story. I punched the concrete wall 30 times because I was so distraught. And law enforcement even came in to back up that story. But the question I have for you, if his hands weren't a big deal and you knew on Friday that he didn't have these injuries, why take the pictures? Why go to the house and check if you say Chris Melton didn't have these injuries? Their actions are inconsistent with their statements. But I'm going to tell you why, and you have to judge witness credibility. Law enforcement has allowed this community to live in fear for the last 25 years, maybe 23. They've allowed it. When people heard about this case or thought about this case, it was because of law enforcement failures. The questions that the family had, they ignored for 23 years. And I tell you, my position, you have to decide, you're the jury. They weren't here defending Chris Melton. They were here defending themselves. They were here to say, hey, all this stuff we missed, forget about it. Don't worry about that. Because we didn't actually miss anything. There were, Detective Ricketts, there were law enforcement officers coming in here. And I admire law enforcement. I think they are heroes. When I'm running out of a building, they are running in. They are heroes. But you also have to understand, we have Detective Ricketts coming in saying, Chris Melton's alibi is confirmed. And if you could show the alibi chart that we did with Detective Ricketts. Chris Melton's alibi is confirmed. But when I started going through, well, Detective, did you confirm this? Were you able to speak to Nash Plumbing? No. Testimony even came in that they couldn't find Nash Plumbing in information. Chris Melton couldn't provide them an address to Nash Plumbing. They couldn't find Nash Plumbing. He couldn't even give them a phone number to Nash Plumbing. That is evidence in this case. But instead of admitting for the sake of justice, for the sake of Miss Baker and her memory that, hey, we may have made some mistakes, and if these mistakes get us closer to getting the right person in that chair, as opposed to the wrong person, we'll admit it. Because that's the right thing to do. Instead, they come in here and they double down on inconsistencies that don't make sense. Ricketts tells us Nash Plumbing for Chris, unconfirmed. Nash Plumbing for Josh, unconfirmed. Chris says he goes to the bank. Josh says he went to Chick-fil-A, unconfirmed. As you know, the bank is at 9:08 a.m. And I told you all, the most important time is before 9 a.m. for Chris Melton. The most important time is before 9 a.m. because at this point, Ms. Baker is gone. Truck Customs, he says 9:30 or earlier, and we know from Bill Teeter, it was after 9:30, it was 10. I believe Mr. Teeter said around 10. Grayson, Georgia, unconfirmed. But look at Josh, and this is from Ricketts. The same person who sat in here and said, it's nothing, these inconsistencies are nothing. Josh says they're in Grayson at 8 a.m. Chris would have to be in Grayson after 9:30 a.m. Chris says they've known each other for 1 month. Josh says they've known each other for a year. And when I asked him about it, he said, well, and this is Detective Ricketts, well, the way I just took it that he meant a year. Even on small mistakes, we all have children, grandchildren, siblings, parents. We're human. Nobody's perfect. But when you have a person or organization or entity trying to get you to believe that they made no mistakes when the mistakes are apparent, you have to judge their credibility. You have to take that into account when you're determining what your verdict is going to be, if you could trust this person or not trust this person. Now, I don't know if you caught this, but it blew my mind when I heard it. And I didn't ask him about it again because I didn't want him to try to change his answer. Chris Melton, on this stand during direct examination, they asked him, why didn't you want to go into the house when they asked you to identify the body? And we all, the entire team, we jotted this down in court. Chris Melton stated, He didn't want to go into Miss Baker's apartment because he did not want to see the devastation he had caused. I don't know if you all caught that, but I absolutely caught it. Chris Melton came in here and pretty much confessed to what he did. But you're the jurors, you heard the testimony, you have to decide. You would also, to pull that plug, you would also have to ignore what Karen Williams told us. Now, Karen Williams did a sketch. This is a sketch. And I tell you, based on this trial, I don't trust anything in this case, but this is a sketch. And the questions I went over with Ms. Williams, formerly Carol Bryant, how much did the person weigh? We got her to admit that he had a full face. She said that he was not thin, he had a full face, probably around 220. We got her to admit, I asked her, he had a heavy looking face. We got her to admit, yeah, he had a heavy looking face. We asked her about the weight, again, 220, and she stated that he was big bone, kind of husky. But this is the person they give you. Now, I don't know, and I think we went over the mustache with it. They didn't even have the right type of facial hair on the person. But to me, what I believe, and you're the jury, you have to decide, they have made so many mistakes in this case, I wouldn't be shocked if they started changing evidence, just to be completely honest with you. And I hate to even say that. But when you introduce hair evidence in this case, you deceive the jury and say, hey, in these bags, and I asked, I said, can we open these? No, we're not going to open them. I asked, can we open this to make sure the evidence is what the evidence is? They brought you empty bags of evidence to get you to believe something that was not true. And then when we got the bags open, all of a sudden they found all the hairs and say, oh, this is with the GBI. And with these broken, I don't even know what to call them, but these broken slides or screens or whatever they may be. But also, and I'm going to go back to this, I'm going to go to this a lot. Not only do they present you empty evidence, they present junk science. Science that has never been presented in a court before to protect either themselves, which I think is more so protecting themselves, and to protect Chris Melton. Now, when we talk about the sketches, remember what everybody said, and this was consistent, because I asked the same question for every sketch witness. The person is walking. The person isn't trying to hide themselves. The person's just minding their business. And I also asked, is there a Walmart? Some people said, I don't know. But we did have Ms. Riker say, yeah, I assumed the person was going to Walmart. And if you think about the direction everybody was walking, if this is the every single person that saw somebody said they were walking down this way. Nobody ever said, oh, well, I saw a person walking up towards Miss Baker's house. They were all walking this way. And during the evidence, what is this way? The Walmart. You'll have that photo with you in evidence. On the other side, down here, past this subdivision, it's the Walmart. But what they did was, okay, let's get all these sketches of these people. They're walking. They aren't doing anything suspicious. Something that's important, they mentioned a laptop being stolen. That came in during the case. Not one of these sketch individuals said, oh, they were carrying a laptop. They were carrying anything. They were acting suspicious. It was just, they were walking. And the state is going to come to you and say, hey, we can't prove that Mr. Faust broke into her house, but we want you to pick one of the people that we have these sketches of and just say it was Mr. Faust. And we want you to assume, we want you to speculate. We want you to say that Mr. Faust is the person in the house. And I'll tell you this, if there's no evidence in the house of Mr. Faust's presence, this is something simple you can remember. No house, no Faust. If there's no evidence of Mr. Faust in the house, no house, no Faust. Tell them to present the evidence. If you can't present the evidence that Mr. Faust was in the house, we have to vote not guilty. We have to. We have to. You're saying this crime happened in the house, you charged him with burglary, we have to. That's the simplest way to remember it. So when they make up, hey, the guy was walking and he disappeared, So that meant he broke into Miss Baker's house. You say no house, no foul. Show me the hairs. Show me the blood. Show me the skin. Show me the DNA in her house, outside of her body, on her skin. Show me something. We presented a photo of Mr. Faust. He does have an afro. And they say, well, the hair in her hands, you know, we just want to show you that it's not Mr. Melton's hair. That's all we want to show you. It's not Mr. Melton's hair. It was Caucasian hair. Now, I don't understand, and you're the jury, you have to decide. How would Miss Baker get a handful of her own hair? How is that possible? Your hand is outward away from your body, but it's your own hair? But in this case, it doesn't matter because what you're here to decide is if the state presented enough evidence that Mr. Faust is responsible for Miss Baker's death. And they haven't. But what they are going to argue, they're going to say, hey, it was just one person walking down the street and he disappeared, so we want you to say this was the person that committed this crime. And they harp on, oh, he stayed 585 feet away from her house. He stayed 585 feet away from her house. Well, that means there's an issue with the investigation, because if the person that you say killed Miss Baker stayed that close, why didn't nobody go to the house and speak to him? He did say his grandmother stayed there. You heard the recording. It's my stepmother's house. But now, 24 years later, 25 years later, they want to say, oh, that's evidence of guilt. And I ask you, listen to the recordings. Listen to the pieces played in the recordings. Mr. Faust says multiple times, yeah, I go over there to check on my stepmother. I'll go over there to visit my stepmother. And I don't know about all of you, but we all have permanent addresses. Mr. Faust said he stayed in that house for 40 years, but he also said, yeah, I have different women I stay with here or there. My permanent address, if somebody asks me how long I stayed at my permanent address, even if I'm not physically staying there, I am going to say 30 years. I've been at this address for 30 years. Even if I don't physically stay there, because that's my permanent address. That's where I may want to send taxes. That's if I get a ticket, I may want to send a ticket there. This is my permanent address. The state wants you to take his permanent address and say, well, this is his address. He said he stayed there. So that means he committed this crime. So why not move? If you've caused this much destruction in this community, why not move? If Mr. Faust committed this crime, how would he know that no one saw him? Why even tell police that you stayed there? But you know who did move out of Athens and who admitted they moved out of Athens? Chris Melton. He got the heck out of town. Never to come back. And where did Mr. Melton say he stayed when Miss Baker died? His parents' home. Where does he currently stay? Miss Baker's home. Excuse me, not Miss Baker. I'm sorry. His parents' home. Where does he currently stay? Still in his parents' home. And I want to show you something. And this is the reason Mr. Melton stated that he stayed on the second floor. He is a liar. Because Josh McCurdy came in and said he stayed in the basement. But I'm going to show you why he lied. And this is a ball that was dropped by law enforcement. The reason Mr. Melton lied is because the basement to his house has its own door. So he wanted to separate himself from that door because obviously I had to show him the pictures first. He didn't want you to know that he had an entrance and an exit he could go in that his parents would know nothing about. This is the door right here. Crime of opportunity. Mr. Melton had the opportunity. Think about what Mr. Teeter told us with him dropping his truck off. He dropped his truck off and went to see the police in Josh's truck. Why would he do that? Maybe he didn't want law enforcement to search it. But you all have to decide. But if you say, I'm going to ignore all of that, I believe Mr. Faust was the person walking in orange in the neighborhood. I know the state can't present any evidence that he was in the house, but I just believe it was Mr. Faust. That is my belief. I think it was Mr. Faust. You pull that plug because your mind is settled, is satisfied, and it is not wavering. And you then find Mr. Faust guilty because your mind is satisfied beyond a reasonable doubt. But if you want to say to that doctor, hold on, doctor. Hold on 1 second. If Mr. Faust committed this crime, why would Elizabeth Bingham need to tell Chris Melton we need to explain your DNA? I have questions about that, doctor. That doesn't make sense. Doc, you're telling me to pull the plug, but Miss Baker was sexually assaulted anally, but Chris Melton's DNA is the only DNA present? I don't know, doctor. Also, Chris Melton's hair was found on the murder weapon. And let me clear this up for you, because I think there was a lot of confusion with that. Can you get the picture of Miss Baker and the charger block next to her head? It'll be in the state's exhibit. And I'll show you that picture. But I'll describe it to you. When you see Miss Baker's body as it was found in the home, you're going to see a charger block next to her head. It was connected to the cord used to strangle her. When they tested this cord for hairs, or they tried to find hairs on this charger block next to her head, I'm going to tell you this. Don't look at the sketch. The sketch has it way far away from her head. Look at the picture. It's right next to her head. You're going to hear that Chris Melton's hair is on the murder weapon. Not Mr. Faust's, Chris Melton's. There was a pubic hair found on Miss Baker's butt. Now, the state brought in this microscopic expert to say, oh, it's Ashley P.V. Hall's hair, and anything is possible, right? But we went with Miss Ashley P.V. Hall. We said, do you have your own bathroom? Or did you have your own bathroom? She said, yes. Did you have your own shower, tub? Yes. Did you have your own toilet? Yes. The mitochondria DNA test, the only DNA test conducted that referred to Chris Melton, determined that he could not be excluded as a contributor of the hair. Miss P.V. Hall could not also be excluded. There's a fact. So Detective Ricketts said it, asked for the evidence. But when the doctor says pull that plug, you say, doctor, one of my gravest concerns is that law enforcement seemed just much more so focused not on justice for Ms. Baker, not on resolving this, answering these questions for the Baker family. They seem more focused on protecting themselves. And maybe Chris Melton. Doctor, I'm not sure. Doc, you're asking me to pull the plug, but where was Chris Melton before 9 a.m.? All these witnesses came in, every law enforcement officer, they fought me. They fought me when it came to confirming Chris's alibi. It was confirmed. It was confirmed. It was confirmed. All right, well, let's break it down piece by piece. Did you confirm this? No, but it was still confirmed. Okay. Talk to me about Nash Plumbing. Did you get documents? No, but it was still confirmed. All right. Josh McCourty, did you get any proof that they ever worked together? No, but it was still confirmed. And then they'll try to jump to the bank. And the reason I emphasize the bank is because the bank is irrelevant. The bank is at 9:08. Ms. Baker was killed in the morning time. According to the state, it was somebody walking around at 8 a.m., 8:30. According to the state. 9 a.m. is irrelevant. So don't let the state come up here and tell you, oh, his alibi was confirmed. You ask them, well, where's the evidence related to Nash Plumbing? They didn't call one witness from Nash Plumbing. And we told them for, I believe, months, Mr. Faust didn't commit this crime. Weeks before this trial, we told the state because we wanted them to disprove it. Chris Melton killed Tara Baker. And that was with the hope that they'll look at their case and say, oh, maybe we got a problem. But instead, what they do, they meet with all their witnesses and they prep them. And they say, you know what? Chris Melton didn't do anything. You don't give any answers that the defense attorney wants. We're going to prep you. We're going to talk to you about it. Anything they say that Chris Melton did, you say the opposite. They knew this stuff. This isn't new. Everything you heard, they knew. This is their evidence. I didn't make any of this evidence. The only evidence that I brought to you is the picture of Chris Melton's house because they didn't want you to know that. But everything else you've seen and you've heard in this case, I didn't go find it on my own. They knew this, and they chose to ignore it to focus on him. And I'll tell you this, way to evidence Chris Melton, Edrick Faust. The evidence related to Chris Melton substantially outweighs the evidence related to Edrick Faust. Could you imagine me in this courtroom trying to defend the hands that Mr. Melton had? And my argument as well, 2 days after her death, he was punching the wall. You all would look at me and say, this guy's crazy. What is he in here talking about? Or if I was trying to defend Mr. Melton and I said, well, my client, you know, he went to pick up his truck on Saturday, he went to get a bank loan on Monday, and then he went out on 2 dates within a week of her death. You would say, this guy's, what is he talking about? Why are we here? Think about the evidence you heard about Chris Melton. Think about how he was on the stand. You had a killer in here talking to you that has gotten away for 23 years. He didn't shed one tear. I showed him a picture of Miss Baker. He didn't shed one tear. Think about that. Edrick Faust did not harm Miss Baker. But you don't have to take my word for it. You can look at the evidence. You can look at the evidence. So you say, doctor, the state has to explain how Mr. Faust's DNA alone means rape. How does his proximity, if you say he stayed there, how does his proximity mean murder, rape, arson, aggravated sodomy, 2 counts, 4 counts of felony murder, burglary? You need the evidence. So, doctor, you don't pull that plug. Hold on, my mind is wavering. It is not satisfied. It is not settled. I have questions. Doc, don't pull that plug. When Mr. Faust chose you all to decide his case, he gave you all awesome power. You may have noticed that each and every time the Honorable Judge Lott entered and exited this courtroom, we'd stand in her presence. And the reason we stand in the Honorable Judge Lott's presence is to show respect for her awesome power as the giver of laws in this courtroom. You may have also noticed each and every time you, ladies and gentlemen, entered and exited this courtroom, we stand in your presence. Because just like Judge Lott, you all are the judges of the facts in this case. In our standing, that is symbolic to show our respect to your power. The first thing you did as a body when you entered this courtroom, or excuse me, when you entered this jury box, you stood up, you raised your right hand, and you took an oath. And by that oath, each of you, you promised, you swore to decide this case based on 2 things. 1, the facts, only as they came out in this courtroom. And 2, the law as given to you by the Honorable Judge Lott. Because you need to understand the law and the facts, I would like to discuss them both with you at this time. Starting with the law. The first principle of law that I like to discuss with you is the Bill of Indictment. Okay? Don't be afraid of this document. This is a very important document. Embrace it and read it. Because in this document contains the charges that you will decide against Mr. Faust. During your deliberations, and this is very important, use this document because this will tell you what evidence you're looking for. The indictment was returned by the grand jury, and you've heard this term before, of Clark County. And what the grand jury is 16 to 23 people. They meet with the district attorney's office, and you've heard Agent Bigham's testimony, but they meet with a summary witness, okay? A summary witness is a witness that just comes in and tells the group about the case. I can't be there. Mr. Faust can't be there. He can't defend himself. He can't hear anything that you all heard. The judge isn't there. It's simply the district attorney's office and their witness. And they tell the room whatever they want to tell them. And they return an indictment. And the judge will tell you that this indictment is not evidence of guilt whatsoever, in any way whatsoever. And the reason why is because it is only a one-sided story. That's it. It's a one-sided story. That's how you get this indictment. Give you a short story. If anybody's ever dealt with a lawsuit in here, similar to a lawsuit, right? Let's say you're at home, you go to your neighbor's house, you say, neighbor, I want to build a fence on my property, okay? I am going to build a fence 5 feet inside of my property line because I don't want to encroach on your property, all right? Do you have any problems with that? Do you want to go get your own surveyor? Do you want to have somebody come out and look at it? I don't want any problems with you, so I'm going to make sure I build it 5 inches inside of my property line. Your neighbor says, no, don't worry about it. You build your fence. One night, you're at home eating dinner with your family, and you receive a knock on the door. You go to the door, you open it, and it's the Clark County Sheriff's Office. Might be that gentleman over there. He's serving you with a summons and complaint. And he says, sir, ma'am, you're being sued by your neighbor for the fence you built on their property. And you say, what? That's absurd. I talked to my neighbor. They didn't want to discuss it. I built it 5 feet inside of my property line. He's going to tell you that's not for me. But what you all could do, which all of us could do, you could go, you could hire your own lawyer, you could pick a jury, and you could let the jury decide what occurred. Because what you didn't know, your neighbor, when he got his lawyer, they typed up a summons and complaint, and you got sued. It doesn't mean you did anything wrong. Doesn't mean your neighbor's right. Doesn't mean your neighbor's telling the truth. But that's the way a civil case gets started. The same thing with the bill of indictment. It's just the way a criminal case gets started. The next principle of law I'd like to discuss with you are the 12 counts in the indictment. The sole issue in this case, it may make deliberations very simple for you all. The sole issue, everything that is charged in this indictment we believe occurred. The sole issue where we are on opposite ends of the earth is whether or not Mr. Faust committed these crimes. That's the sole issue you have to decide. Has the state presented enough evidence that Mr. Faust committed these offenses? Malice murder. It's the first count in the indictment. And you're going to have these jury charges. The first element of malice murder, and this is the only question you have to answer in regards to malice murder, the first element is that the defendant, in this case Mr. Faust, caused the death of another person. That's the only question you have to answer in regards to malice murder. Did Mr. Faust, let me change that, did the state, because it's their burden, did the state present enough evidence to you to prove beyond a reasonable doubt that Mr. Faust, and I hate to use this language, but murdered Miss Baker? I'll tell you they didn't, and we've discussed it. No house, no Faust. They didn't present any evidence placing Mr. Faust in the home. That's first and foremost. None. They admitted in opening statements they can't even tell you how he got into the home. Right? And I'm telling you what their argument is going to be. It's going to be choose anybody that was walking in the neighborhood. We want you to say that's Mr. Faust. That's what they're going to tell you. They're going to say, Jay Anderson saw a guy walking that fit Mr. Faust's description, and he disappeared when Mr. Anderson went away from the window. So that means this guy ran around the house and broke in the house. Ask them for evidence. The person that killed Miss Baker knew Miss Baker. That has always been our position. Look at the photos of the crime. The person that killed her knew her. They were angry. Why they were angry, we don't know. It didn't come in this case. But they were enraged. It was an overkill. Counts 2 through 5 are felony murder. They charged Mr. Faust with 4 counts of felony murder. To convict of felony murder, the state must prove, and again, it's only one issue that you have to decide with all these counts, that Mr. Faust is the individual that engaged in these acts. And they have to prove that beyond a reasonable doubt. We've addressed counts 1 through 5. Count 6, burglary. The state must prove that Mr. Faust, and again, it's every count, they have to prove Mr. Faust did this, that Mr. Faust entered the home. And we can stop there. We don't even have to go through every other element. They have to prove that Mr. Faust is the person that entered Ms. Baker's home. And the state has admitted that although, and I repeat this because it's so mind-blowing to me, that although they can't prove how Mr. Faust got in the home or that Mr. Faust was in the home, this gentleman is sitting over here. That has been shocking to me since day one. They can't prove, or matter of fact, we all know now that the science says Chris Melton is the only identifiable DNA profile in Ms. Baker's anus, but they have this gentleman sitting over here charged with aggravated sodomy. That's why juries protect the community. That's why we have juries. Because the first thing any totalitarian governmental system does, they get rid of the jury. They say we decide who's guilty or who's innocent. This right here, and a lot of you may not know what this is, okay? But this right here is the strongest symbol in any democratic society that uses jurors. And I could kick it, I could probably rip it off the ground. But the reason this is so powerful, and the reason you see this in every single courthouse, is because when they were putting the Constitution together, when they were founding this great country, this is in place to symbolize the separation between the people and the government. This is the strongest symbol, this partition, and that's why their table is closer, because they want to make it clear this is a separation of the people from the government. Oral sodomy. The state must prove that Mr. Faust forcibly and against Ms. Baker's will, and they presented no evidence of that. And I think this is significant. And I may say this wrong, but I'm going to say it, so please forgive me. And if I stumble over my words, please forgive me. Elizabeth Bingham was the person that decided who raped Ms. Baker and who didn't. She had two options. She had Chris Melton, she had Mr. Faust. She was the one that had to make the call. She was the lead investigator on this case. So it wasn't Ms. Baker saying, hey, this is who did it to me. Ms. Baker had Caucasian hair everywhere. She tried to leave him something. But Elizabeth Bingham is the person that made the call. And despite all the evidence in this case, and she told you that she reviewed her entire case, for everything in this case that I've seen, she's seen. Instead of saying, hey, you know what, let me follow the evidence, she sets a meeting with Chris Melton and tells Mr. Melton, look, this is what we need to do. She hasn't talked to Mr. Faust. She doesn't know Mr. Faust at this point. It's just, this is what we need to do. I'm going to go after this other guy. So when you think about these charges, I want you to think about them in the context of why we are here. There isn't a person saying that Mr. Faust did all these terrible things outside of the person who had to make the decision on who to pursue. And they chose Mr. Faust. So they have to present evidence supporting that Mr. Faust was engaged with Ms. Baker without consent. And the court is going to tell you that. You're going to hear it in jury instructions. They have to prove that any contact was without consent. And Mr. Faust can't answer that question for you. They snatch him up 24 years later. Chris Melton has been answering the question for 23 years, or 26 at this, 25 at this point. And his answers, lies, 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 lies. A person lied to me one time, I'm done with him forever. If somebody could take an oath before God and get on this witness stand before God and lie, is that somebody you could trust? He's shown police multiple times he's willing to lie. He said 7 times he saw her 10 days and switched it for him. And then he came here and said the same thing. Oh, I was mistaken on the 10 days. You know, Liz, he called her by her first name. He actually has a nickname for her. He calls her Liz. You know, Liz reminded me that it was actually 5 days when I saw her. He's a liar. He's not truthful. Mr. Yalamachili told you the purpose of a case, any trial, is to find out the truth. You don't build a case to find the truth based on liars and lies. And this is what this case has been. This is very important for you to consider in deliberations. There is no evidence of sperm in this case. I want to make that very clear. You heard a GBI person come up. They talked about sperm for a little bit. We made our objection. And you notice that she never mentioned sperm again. But she also admitted when we were doing examinations that she didn't test it for sperm. In evidence, you will have a sperm test that says there is no spermatozoa. So when the state tells you this is a rape case, his DNA is in her mouth, okay, how? How? This is a rape case, it's in her vagina, okay, there's no sperm. We don't know, it's 24 years later. But they have to prove that. And I want to make it 100% clear. If they say it's rape, they have to prove it is rape with evidence, not speculation, and I told you this during opening. Not with because we say so. It requires evidence. Count 8, rape, as I just mentioned, I want to make it clear. No assumptions, no stereotypes. You make your decision based on evidence. The state wants you to rely on assumptions. They want you to make leaps. Not inferences, they want you to make leaps. They want you to assume things. They want you to have stereotypes. Base it on the evidence. And when we chose you as jurors, when Mr. Faust chose you as jurors, we chose people that we felt followed procedure, respected the law, and will require evidence to be presented. Aggravated assault, same thing. They have to prove that it's Mr. Faust. And finishing up, I thank you all for your patience. Just want to make sure I cover all bases. I believe I addressed the whole drainage theory. It is not possible. And don't take my word for it. Take it, Miss Hinkle's word for it. It's not possible. 3 days is the max. Ms. Baker was killed on a Friday. Chris lied and said he saw her on Sunday. It was really 10 days, but we'll say 5 days to be nice. It's not possible. And they probably knew it. That's why they didn't ask Ms. Hinkle about anal, because they knew she would have said, well, it's only 3 days. The theory doesn't make sense. And again, they did ask her, and she said, well, for it to reset in the anus, it requires penetration. Drainage is not an option anymore. They told you in opening, that's how it got there. It's not an option anymore. The science says otherwise. Trust the science. You don't have to trust us. Trust the science. They brought in evidence that Ms. Baker showered daily. That's something that you need to keep in mind. Mr. Faust, or Dr. Falzone, he was the medical examiner in this case. I just want to make it clear. He has made clear there was an anal sexual assault. State can't dance around that. He made it clear the injuries were consistent with sexual assault to her anus. Count 11, arson in the first degree. Again, they have to prove that Mr. Faust committed that offense. Possession of a knife during the commission of the crime. Again, they have to prove Mr. Faust. That's the only question. Has the state presented enough evidence to you to say that this was Mr. Faust? Judge is going to give you instruction on credibility of witnesses. Remember who was honest in this case. John Newton, he was honest. Bill Teeter, he was honest. The physical evidence, it is honest. the science, it is honest. In all of those, and I'll say two, the physical evidence and the science supports Mr. Faust's innocence. The physical evidence and the science supports, not even the physical evidence and science, the physical evidence, the science, and his statements support Chris Melton's guilt. But I made this clear in opening. You're not here to decide whether or not Chris Melton committed this crime. So in deliberations, don't say, well, do we think Chris Melton did it, or do we think Mr. Faust did it? Your only focus is, does the evidence support beyond a reasonable doubt? If you say maybe Mr. Melton did it, maybe Mr. Faust did it, the vote is not guilty. We discussed that. Now I want to talk about something that I think is significant in this case, and I'm sure you're all aware of this because we talked about it in jury selection. And we also talked about it in opening. One of the biggest pieces, there is a bill that was passed in this a bill that was passed in this case, and Ms. Bigham talked about it. I told you in opening that it was the fame, the lights, being the superstar police officer that closed this case that led them to say, hey, this is somebody we could put as the face of Ms. Baker's death. But I want you to consider Mr. Faust is put on the news as the bad guy. This case, he hasn't been the bad guy once in this case. Right? The worst you've heard about Mr. Faust in this case is the indictment. They spent, and listen, I took to heart when people said, hey, we got stuff to do. We got to get out of here. We can't stay here 6 weeks. We can't stay here 8 weeks. We can't stay here 4 weeks. They spent 7 days defending Chris Melton. Think about how long you've been here. They spent 7 days on Chris Melton and 2 days on Mr. Faust, maybe 3. I'll tell you in this case, the reason this case is the way it is because the state didn't expect anyone to care about Mr. Faust. They didn't expect anyone to do the work for Mr. Faust. They did not expect anybody to take Mr. Faust's case seriously. Once they showed, hey, this is the person that committed this terrible act, what they expected was probably a 2-day trial. Expected some guy to just come in here and say, oh, this client is terrible, we don't care. They expected you all to come in here, and they truly, they expected you all to come in here and say, hey, his DNA is enough, I'm done. That's what they expected. That's the only reason they would bring you a case so weak. And that's why we said in opening, speculations aren't allowed here, right? We have to follow the law. We have to look at the evidence because they wanted you as jurors to just say his DNA is enough. He did it. He did it. That's it. That's our case. And that's why they spend so much time in opening talking about these numbers. Oh, it's so big. It's this, it's that. Because they want you to say, we don't care about the evidence. His DNA is enough. The state could do that. You are the protectors of this community. We don't do that. If we put people away, we put them away with evidence. It's rules to the law. They have to follow the law. And you tell them, bring us the evidence because we're going to do our jobs. We're going to abide by our oaths. They want you to convict on emotion, speculation, assumptions. They want you to believe Mr. Faust has to explain his DNA. The judge is going to tell you he absolutely does not. And the way she's going to frame it is Mr. Faust doesn't have to present any evidence. They have the burden of proof. And thank you for your patience. I am wrapping up. I asked you for a few more minutes. 16. The next principle I'd like to discuss with you is the presumption of innocence. That is a very, very, very powerful principle. In America, every person that has to be charged with a crime is presumed innocent. And we do that for humanitarian reasons. It would be terrible for someone who didn't know anything about a case to presume that someone is guilty, to presume that someone committed something just because they are charged with the offense. That would be considered inhumane because not only would that happen to me, that would happen to everyone. So when we became a country in our Constitution, it was written that every single person charged with a crime is to be presumed innocent. And again, I told you, it covers him from the top of his head to the bottom of his feet. So the state's evidence could rip off the chest plate of that armor of Mr. Faust. It could rip off an arm. It could rip off a leg. It could rip off the helmet of that armor. But if there's a piece on the elbow, if there's a piece of armor left on the knee, just as Mr. Faust walked in here and met you all 3 weeks ago, that presumption is not guilty. So how much evidence does it take to rip off that suit of armor? And who has to present that evidence to rip off that suit of armor? And we've already discussed that the state has the burden of proof. And the next principle I would like to discuss with you is the burden of proof. The state has all the resources, okay? Mr. Faust is a single individual. All of us are single individuals. The state, they have the power of the state. They have the money of the state. So when it comes to bringing cases, they have the power. They have the resources. That's why they have the burden of proof. So where's all the evidence that they have to marshal in with so much power to say that this person committed this crime? It's not a flip of the coin. It's not a maybe I believe he did it. Maybe he did it. He might have did it. They have to bring in so much evidence that it rips off that entire suit of armor. And that standard is known as proof beyond a reasonable doubt. And we discussed what proof beyond a reasonable doubt means. The judge is going to tell you the lack of evidence. The lack of evidence. If there's some evidence you want to see that you don't see, the lack of evidence is a reason to doubt. And you tell the prosecutor, you didn't prove your case. Don't ask me to convict someone when you don't present the evidence. Ladies and gentlemen, it is your verdict. This is your courtroom. It is your decision as a body. And I told you in opening, I was going to ask you individually and as a body to render a not guilty verdict for Mr. Faust. You're going to get a verdict form, and I believe but you're going to receive a verdict form, and I'll show you the verdict form once we get it. And it's going to have a line. And it's going to say, we the jury find Mr. Faust, and it may say defendant, it may have a generic term, not guilty or guilty. And you, individuals, will write in, not guilty or guilty. All 12 of you on the jury panel have to agree to a verdict. Don't surrender your verdict. If you feel that your position is truthful, whatever it may be, don't surrender your verdict. Don't say, okay, it's 4:45 on a Friday, I'm ready to go home. Thank you. Let's just go ahead and check this off because I want to go. Don't do that, because once you render your verdict, that's it. You can't come back and fix it. You cannot come back and fix it. So you took an oath. Follow that oath. I know each and every one of you will, because otherwise Mr. Faust would not have chosen you to sit on the jury. He would not have chosen you to decide his fate. I took an oath as well, and I didn't stand up to take my oath, but I also took an oath. And I'm going to have things to tell you. The prosecution is going to get up. They're going to make their argument. But due to the rules, I cannot say another word to you. This is my last time. This is Mr. Faust's last time having an opportunity to say anything to you. So they're going to say things that I am going to disagree with, but I won't have another opportunity to speak with any of you. I may think of something later that I forgot to say. But Mr. Faust trusts you. He trusts you with his life. We trust you. I want to thank you for your time and your devotion to this community, the United States of America, as well as the state of Georgia. In regards to malice murder, which is count 1, we ask you to vote not guilty. In regards to felony murder, count 2, we ask that you vote not guilty. In regards to felony murder, count 3, we ask that you vote not guilty. In regards to felony murder, count 5, we ask that you vote not guilty. In regards to burglary, count 6, we ask that you vote not guilty. In regards to aggravated sodomy, count 7, we ask that you vote not guilty. In regards to rape, count 8, we ask that you vote not guilty. In regards to aggravated assault, count 9, we ask that you vote not guilty. In regards to aggravated sodomy, count 10, we ask that you vote not guilty. In regards to arson in the first degree, count 11, we ask that you all vote not guilty. In regards to possession of a knife during the commission of a felony, we ask that you vote not guilty. Court's indulgence. And forgive me, I skipped count 4. Count 4, felony murder, it's the exact same thing. We're asking that you all vote not guilty. There was something that I didn't mention. I was trying to be considerate of you all's time and kind of get through the argument. But there was something said by Agent Bigham, and I'll end on this note. She stated that Chris Melton's DNA was supposed to be there. There was her statement to you all when we asked about the DNA. Something that isn't appropriate in this case is to assume that because someone is a boyfriend and the timeline doesn't fit, that they are entitled to someone's body. Ms. Baker could tell Mr. Melton no. His DNA being there doesn't automatically mean he has access to her. And I would tell you all to reject that statement from Ms. Bigham, but also use that to judge her credibility. She would rather tell you that Mr. Melton's DNA is supposed to be there despite it being in a place he said that it shouldn't be, right? They're saying, hey, this guy may not have committed this crime. She chose Mr. Faust's DNA as the DNA that shouldn't be there versus the guy that told her, yeah, my DNA shouldn't be there. That isn't anything that she did. But I submit this case to you all. I want to thank you all for your time, your attention, and your patience with me throughout this trial. On an ending note, if I have done anything to offend anybody, please forgive me. Hold it against me. Don't hold it against my client. I truly apologize. I promise you it was not intentional. But again, I want to thank you for your time. I want to thank you for leaving your lives to hear this case. We trust you. We ask that you find Mr. Faust not guilty.
All right, thank you, counsel. Ladies and gentlemen, we are going to take a 15-minute recess. It'll be a good time for a restroom break. There are refreshments in the jury room for all of you. Ladies and gentlemen, we will be adjourned for 15 minutes. You may rise and go into the jury room. Don't deliberate on the case. Thank you. You okay?
Probably not the best.
Okay. It's the same? Okay, just felt warm. All right, very good. All right, y'all ready for the jury to come back?
Yes, Judge.
All right, very good. You can bring the jury in. Thank you.
Two in line, yeah. I see.
Not ready? All right, be at ease, everyone. They're not quite ready. Please be seated, everyone. All right, ladies and gentlemen, we are ready to resume with concluding arguments. Mr. Yalamanchili.
Thank you, Your Honor. If it pleases the court. On January 19th of 2021, Tara Baker was going through her morning routine. What we know about Tara is that she was a very detail-oriented person, a very routine-oriented person, and she liked to get up around 6:30 in the morning, and she'd take a shower. She'd eat her breakfast of cheese grits, good Southern staple, and then she'd go to her room to blow dry her hair, and that's something that would take her a while because she had so much hair. And there's no way that she could have known that she would have never gotten through that. At that point, the defendant, Edrick Faust, entered her home and attacked her from behind with a knife. You heard from Dr. Falzon, who talked to you about the mechanism of that injury and the fact that it would have pierced her jugular vein and would have come from behind in this manner, which is consistent with the defensive wound that she has to her left hand. After he then bashed her head and strangled her and sexually assaulted her, Mr. Faust tried to cover his tracks. He tried to clean up as much as he could. He took the stove knobs off the stove where he had turned them on in order to light a blanket on fire and then light her bedroom on fire. And he exited the residence. He lived just under 2 football fields away, 585 feet. And he was likely very surprised that the home did not catch on fire the way that he expected it to. And he circled the neighborhood, wondering when this blaze would actually reach its full peak, and worried that it was not. And what you heard from Brian Grove, the ATF fire engineer in this case, is that under the environment that Mr. Faust had created, this would be a slow developing fire. It would be a fire that would be fed through the cycling on and cycling off of the HVAC system until the temperature reached such a level that it would cause a breakout in that top pane, which you have seen from the pictures, which then would create a ventilation increase that would let the fire reach its full level. This was all done in an effort to conceal his crime. Mr. Faust, when he committed this crime, did not take a weapon with him. He did not take elements to clean up after himself with him, the way that someone, if they had planned a crime over the course of several days to arrive in the middle of the night, would have done. The fire department arrived not knowing that they would find what they found inside. They entered the home. It was a home that was filled with smoke. They identified by looking around the home that the source of origin had to be in bedroom 3, Miss Baker's bedroom. They forced entry into Miss Baker's bedroom, and when they did, what they found was something that they were not ready for. They backed out. They called the police department. The police arrived on scene to find the badly burned and beaten, stabbed and strangled body of Miss Tara Baker. As it related to her murder, the evidence was always there. The world and technology just needed time to catch up to be able to deliver justice for her, and that's why we're here. That's why we've taken the time and asked you to take the time out of your lives to present the evidence that we have presented over the last 2 weeks that shows that Mr. Faust murdered Tara Baker. The police thoroughly processed the scene when they arrived. Although now Mr. Cruz wants to claim that this is a case about indifference, he wants to claim that this is a case about the ball being dropped and carelessness. In his opening statement, he called this one of the most thorough investigations in the history of the state of Georgia. What's changed is that the evidence against his client has been laid out, nothing else. It's one thing to pay lip service to law enforcement and first responders. It's another thing to actually recognize what the work they do, what kind of toll it takes on them. Where's the indifference in Lieutenant Liedall telling you he can still smell the shampoo in her hair? Where's the indifference in Bill Ricketts telling you that unlike a Super Bowl or a World Series, things like this are things that you never forget? Not only did the police use all of the tools and technologies that were available to them, you've heard from Agent Howe that they used innovative techniques, like trying to get fingerprints off Miss Baker's body using a negative lift technique. You've heard from both Lieutenant Liedall, who's well recognized in his field, as well as Agent Howe, who's well recognized in his field, that this is possibly the worst type of evidence or worst type of environment that you could have for trace evidence collection. But they still attempted to do so. The water, the smoke, the fire, the ceiling debris that fell on them led to a situation where the only trace evidence hairs that they could find would be hairs that you would normally expect in the home in abundance, as was testified to, because these are people who were regularly in and out of the areas of the house. The transformer box is not the murder weapon. The ligature, which was tested for DNA and only had Miss Baker's DNA on it, the knife that was used to stab her, likely the footboard where her head were bashed against were the murder weapons in this case. Not a power transformer box that was connected to a printer. But Mr. Melton's hair was found there. It absolutely was found there. But as both of the detectives who work forensics in this case, Agent Howe as well as Lieutenant Liedall, told you, you would fully expect to find hairs of individuals who are regularly in and out of the home in those areas. Also, Mr. Cruz wants to talk to you about why Miss Baker's own hairs were in her hand. Well, as you heard from Mr. Peterson, a well-renowned expert in hair analysis, that is very common. And I think if we take just a moment to consider what happens as soon as any of us gets hit in the head, it makes perfect sense. The first thing that happens when you get struck with something in the head is that your hand goes up to your head. And so when someone has bashed your head against something, causing a serious injury that is testified to as a medical examiner as a contributing factor, it makes perfect sense that your hand would go to where you were hurt. And it's perfectly consistent with the experience of experts who do hair analysis. As part of the processing the scene, the entire scene was processed for fingerprints. There were no usable prints found. The screen, which was tampered with in a manner that was consistent with removing it, was processed, but unfortunately no usable prints were found on that item as well. And as the case languished for over 20 years while the police were looking for new leads, that screen was lost. We didn't try to hide that from you. We owned it from the very beginning. All this happened before I could drive a car. If I could go back and make sure that screen stayed in evidence, I absolutely would, but we can't. We have the case that we have. And I think it's important to talk about evidence, right? Mr. Cruz has access to the same physical evidence that the state has access to. And the defense has no obligation whatsoever to present any evidence. But he has access to that same evidence log that Agent Bigham made part of her case file. So if Mr. Cruz wanted you to see the keys, the defense has the opportunity to present that. It's in evidence, as Agent Bigham testified to. If Mr. Cruz wanted you to see the lock, he could present that. It's in evidence. But that's not what he wants because they're irrelevant, and he knows that. What he wants is to create the type of conspiracy theory that he's just told you in his closing argument you shouldn't follow as being reasonable doubt. And so I'm going to ask you in your deliberations to hold him to that. The police knew from early in the investigation. The autopsy happens the next day, and even when they arrive on the scene, it seems very likely to them that Miss Baker had been sexually assaulted while she was in the process of dying. As part of the autopsy conducted by Dr. Faust, he photographed and described injuries that indicated that Miss Baker was stabbed from behind, strangled, and beaten, as well as sexually assaulted with forcible injuries, not just to her anus, but also her vagina. A fact that for some reason the defense regularly ignores and doesn't want you to think about. Dr. Faust, due to the fact that there were injuries and indications of sexual assault, did what he always does, which is to take oral swabbings, vaginal swabbings, and anal swabbings. Unfortunately, when the envelope was injuries and indications of sexual assault, did what he always does, which is to take oral swabbings, vaginal swabbings, and anal swabbings. Unfortunately, when the envelope was Labeled, two things got labeled as oral swabbings, but we know that we have a vaginal smear as part of the evidence in this case. And there can be no vaginal smear without a vaginal swabbing. That's impossible. And so that's how everyone knows that one of those oral swabbings was a vaginal swabbing. In his opening statement, Mr. Cruz tried to tell you that the injuries to Mr. Melton's hands are from when he is strangling Miss Baker and she is clawing at his hands, and that the hairs in her hand are from in that fight against her attacker reaching up and pulling his hair out. He physically demonstrated that to you during your opening statement, during his opening statement. How does that comport with what the actual evidence in the case is? It doesn't. Okay? And I don't want you to take any of this as some kind of attack by me on Mr. Cruz. Mr. Cruz has an incredibly important and constitutionally mandated job in this case. And that's to make sure, regardless of what the evidence is, that he does everything he possibly can to walk Mr. Faust out that door, even though he murdered Tara Baker. And that should be his job.
You may.
That is his job as mandated by the Constitution, and he is doing it as he should. But you have a different job, and I have a different job. My job is to look at the evidence, see where it leads, and then bring that before you so that you can deliver a verdict that speaks the truth. That's my job. Mr. Cruz has tried to manufacture moments of doubt for you. He has the same evidence log that Agent Biggin put in her case file that indicates that there were envelopes in which hairs were put and sent to the GBI, and that there are slides containing hairs that were done for analysis. Okay? And so this theater of opening up envelopes and creating what could be seen in out of context as some kind of moment of missing evidence is just a complete fabrication. The very next question we asked Lieutenant Leadall was, well, I mean, those are the envelopes you packaged the hairs in. You got any idea what the GBI did with them when you sent them over there? No. Then, as soon as we called the GBI witness, what did they all tell you? They almost looked at myself and Mr. Bolden like we had three heads when we asked them, well, I mean, after you take the hairs out of the envelope, you put them on the plating slide, you analyze them, do you then deplate them, put them back in the envelopes that they came in and send them back to the police department? And all of them looked at us and said, no, we don't do that. They remain plated. Well, because of course they do, because hairs are biological evidence and they will degrade over time if you maintain them in an environment after they've been sent for analysis in which they are not controlled. And so they stay longer on the plating and the glass. I'm sorry the slides broke. I mean, I think you could all see me and my anxiety level in the courtroom when we started taking the slides out of the protective cases because I was terrified that they would break. But it's been 25 years since this happened. And this case was cold for over 2 decades. It's something that's unfortunate that they cracked, but as everybody testified to, they were not cracked when they were analyzed, and it did not affect the integrity of the evidence. Ultimately, with the technology that was available over 25 years ago, law enforcement and the crime lab did not have the technology and tools with adequate sensitivity to identify the biological evidence that had been collected and preserved in the oral, vaginal, and anal swabbings that were taken. And we had to wait on the tools and technology to catch up. Besides collecting the physical evidence in the case, the police also did a canvass of the neighborhood. They did a canvass to see if anyone had seen anything, and they recorded whatever anyone would say. But at the time, they didn't have any leads to go on that yielded anything fruitful. They looked at every person of interest they possibly could. And this idea that political pressure is the reason we're here right now, if the police had allowed political pressure to guide their decisions, they would have arrested someone 25 years ago, but they didn't. They followed the evidence. They followed the evidence in the case. What we would ultimately learn is that Mr. Faust lived less than 2 football fields from Miss Baker. He lived just 585 feet with a direct line of sight to her home. We've learned that the description given by several witnesses in the area was consistent with Mr. Faust. At the time, we did not have him as a person of interest because he appeared nowhere in this case file that has tens of thousands of pages in it and over 100 hours of interviews. We would learn eventually that the sketch created by renowned forensic sketch artist Marla Lawson, based on the descriptions that were given by the people who saw Mr. Faust walking around the neighborhood, were consistent with Mr. Faust's appearance as it was just 2 weeks or so after the crime was committed. And we would learn that there's no connection of any kind before the morning of January 19th of 2001 between Mr. Faust and Tara when he left his DNA inside of her home after he had killed her. We learned that Mr. Faust's DNA was present in Tara's mouth and vagina, even though he denied ever having spoken with her or had any contact of any kind with her or anyone who lived in Deer Park. We learned that when he was given an opportunity to explain why his DNA was present, an opportunity that the defense has repeatedly said he was not provided, Mr. Faust chose instead to end the interview by asking to be taken to jail. But unfortunately for the Baker family and for everyone who knew, cared for, and loved Tara, it would take us decades to know those things about Mr. Faust and to know that he had killed and sexually assaulted Tara Baker. Law enforcement began doing everything that they possibly could to catch a break in this case. They began constructing a timeline of Tara's whereabouts, a timeline that the defense doesn't want you to pay attention to. Police also talked to Tara's roommates, Ashley and Valerie, and they told the police that no one had a key to the home besides the 3 roommates. Ashley in particular was very close to Tara, going all the way back to when they were in the same sorority at Georgia College. I think Ashley would have considered Tara her best friend, and she would have thought that the same was true of Tara. Ashley told you that Tara and Chris had a good relationship with nothing other than normal ups and downs of any relationship, especially one that had lasted as long as Tara and Chris's had, and that they were trying to find ways, as many people do in their early 20s, coming out of college, stepping into an environment where your academic challenges are much more significant, both in the stress and also the long-term impacts of it, and also into the world of working and trying to build a business for yourself, to do something good for the future that you hope to share with someone. And that Chris's work demands and Tara's school demands had made it to where they weren't able to spend as much time as they'd like to together. And that's probably one of the reasons that Tara was so excited about seeing Chris that weekend for her birthday, something that Ashley told you and that Chris told you. Police knew from speaking with Katie Lonstein, who you heard from, someone who told you that her and Tara's friendship was one that started pretty much on the first day of law school and grew quickly through the crucible that is your first year. I mean, I remember my first year. I still have some of the best friends in my life from that time in law school because you're spending 11 or 12 hours going to class and studying, and you have this incredible pressure of performing in a very highly competitive environment in front of other people who are your peers, and it causes people to bond very quickly. You could see that in the pain that this still causes Katie 25 years later. And she told you that in all the time and experience that she had with Tara, the only impression that she got from Tara about her relationship with Chris is that it was a good, positive thing. She also told you, importantly for the timeline, that Tara was very committed that semester to her academic performance. She was going to be at the law library till 10 p.m. every night. Even when Katie left that night at about 9:15 or 9:30 to go home, Tara was staying, because Tara was a routine-oriented person and a detail-oriented person and an incredibly hard worker who said she was going to stay at the law library until 10 p.m. and who had class the next morning. Katie told you about the type of friend that Tara was. You know, every friend group, I feel like, has the mom or dad friend who kind of watches out for everybody. And that's who Tara was. When she didn't call Tara, when she got home, Tara called her. And we know that happened at 9:46 p.m. Tara also talked to you about the plans that they had for that Friday night and how Tara was excited about the weekend. As police investigated the case, as you've heard, they looked at Chris hard from the very beginning. That's where the police always looked first, is at the romantic relationship or someone in a close relationship with the victim. You've heard that. Chris cooperated fully with police. Mr. Cruz claims that he didn't talk to Miss Virginia, Tara's mother. Well, that's not true at all. The way he found out is he called Miss Virginia back while he was at Truck Customs, and she told him what happened, and his first instinct was to go to the last place that anyone knew Tara to be. And so he went. And on the way, he called her roommates, trying to find them, calling their families, trying to see whether this was Tara or someone else. Chris wanted to cooperate because he thought by cooperating and giving as much information as he possibly could, it would move this investigation towards finding the person who killed Tara. He didn't know at the time that it would take 23 years, but it did. Chris and Tara had met at Georgia College. They hadn't gotten really serious until they both moved home. They had worked through a long-distance relationship. They had found a way to be together, and Chris had to move closer to where his work was once he decided to take the step, once he had found his place in the world in plumbing, to be something more than just working for someone else. He wanted to be something more because he was inspired and motivated by the way that Tara lived her life. And, you know, to Ashley, she sat up on the stand and she told you, you know, to me, it kind of seemed like it was a relationship that seemed destined to end. And I could see that. I mean, I'm sure Tara's family may not have felt that Chris, without a college degree and as a plumber, wasn't good enough for this woman who, by all accounts, sprinted ahead of the field all the time. She was on a mission to do the things that she wanted to do. But in this world, it does not matter what people on the outside of a relationship see or what they feel or expect. What matters is how the two people feel about each other. And what we know about how Tara felt about Chris and what Chris felt for Tara was that they loved each other, regardless of whether the world thought that they were similarly yoked or mismatched or anything else. And am I telling you that two kids that were 23, 24 years old were definitely going to get married and go on to live, you know, together for the next 60 years until they pass away in bed next to each other? No, you don't know what people are going to do or how life is going to unfold. But what I'm telling you is there is not one shred of evidence, not one single shred of evidence that indicates that Chris Melton was angry with Tara, would hurt Tara, or wanted her dead. In fact, the exact opposite is what her best friend said. She said he was the sweetest guy in the world. I never saw him be anything but kind towards her. You know, I do think it's interesting that Mr. Cruz wants to tell you that a stamped, timed transaction from a bank that is over an hour from Athens, that blows a giant hole in the middle of his timeline, isn't relevant. Because to me, it is the most objective, relevant piece of evidence about Chris Melton's alibi. An alibi that is solid. An alibi that you can't call unconfirmed because Josh McCurdy confirms all parts of Chris's alibi for the morning of the murder. And Chris's father, who Mr. Cruz did not mention one single time in his closing argument, also told police that Chris was home that morning and he saw Chris get in the car with Josh McCurdy. Mr. Cruz knew that, which is why he needed to make this relationship between Josh and McCurdy and Chris Melton, who were work friends who never hung out outside of work, something more than it was. You'll recall in cross-examination, Mr. Cruz repeatedly asking David Griffith, the crime analyst with the Athens Clark County Police Department, well, they went to high school. You didn't know they went to high school together? They went to high school together. The words that the attorneys say are not evidence. The evidence in this case is that, in fact, they did not go to high school together and that they were just work friends who had known each other for a year. There's also this twisting of what people have said and what it means. Chris Melton said he had known Josh McCurdy for a year from working together in the same crew for someone else. And about a month before Tara was murdered, he had talked to Josh about coming to work for him. That's what the evidence is in the case, not some inconsistency between when Chris says he met Josh and when Josh says he met Chris. Josh picked him up. They go, and you've heard from Bill Ricketts, you've heard from David Griffith, that it is not unusual. People do not timestamp their lives for there to be some inconsistencies in when people went certain places or the order in which they went to certain places, or people to leave things out. If Chris was trying to manufacture an alibi, why in the world would he have not told the police about the bank until Sunday? It's because on Friday, when he was talking to the police and he's trying to recall everywhere that he was that morning in the middle of this tragedy, he forgot. That's a completely normal thing, and you've heard the investigators testify about that. They go around, the rain prevents them from doing all of the work they need to do. They go to truck customs before lunch. They go to truck customs again after lunch, may have stopped by quickly right before lunchtime as well. And that's the point at which Chris gets a page from Miss Virginia Baker, Tara Baker's mom, and he goes straight to Athens. The police ask him to go to the scene and identify the body. He tells them he does not want to. When asked, and Mr. Cruz, again, is trying to twist Mr. Melton's words, he did not say, I didn't want to see the damage I had caused. He said he didn't want to see the damage he had caused. So Chris goes to the scene to ID Tara, so that her family won't be forced to do it. After that, he goes to the police department because he wants to tell them whatever he can. He wants this crime to be solved more than he wants anything else in the world. Police listen to what Chris has to say, and the very next day start calling Bill Teeter and Josh McCurdy, who are the people that he identified, and they confirm the major points of his alibi. They later confirm his alibi further with his father, and even further with the objective evidence from the bank. The evidence about the time of travel that the defense doesn't want you to know, doesn't want you to consider, because it blows a giant hole in everything that they're saying. When he came back on January 21st of 2001, to give that blood sample and to be interviewed further, he was talking to the same police officer, Bill Ricketts, who he saw on the first day. The police officer that showed you how he would roll his hands by touching each and every finger on January 19th, the day that Tara was murdered, each and every one, something that's recorded in Bill Ricketts' police report 23 years before Edrick Faust ever shows up in this case. That's the other thing the defense is trying to do. They're trying to act like all of these facts existed in the same environment, in the same moment, and that is not true. Bill Ricketts' police report indicating that he fingerprinted Chris Melton is from the time that he fingerprinted Chris Melton. It's nothing manufactured. It is an accurate recording of exactly what he did. And what he told you is that he and no other police officer that testified or any police officer in the Athens-Clarke County Police Department or GBI or anywhere else saw any injuries to Chris's hands. The things they would have absolutely been looking for because they were looking at him as a person of interest. Unfortunately, nothing broke. They couldn't get anything, and the case went cold. But eventually we caught up. Through the determination of a family in the face of unimaginable tragedy, through the fierce and unwavering love of a mother, Tara would not be forgotten. And the long and difficult journey to find justice for her and accountability for her murderer, Mr. Faust, never ended. The GBI Cold Case Unit was created to bring in fresh eyes and to use modern technology and tools to investigate cases where all leads have been exhausted and no likely perpetrator has been identified. I want to back up because I left something out on Chris's interview with Bill Ricketts on January 21st. He tells Bill Ricketts on January 21st that he and Tara had sex for the last time Saturday night into Sunday morning. That's what he says 2 days after the murder. That's what Bill Ricketts testified to here. So this idea, this false idea that somehow the first time that Chris Melton ever said that he had had sex with Tara within roughly 5 days of her being killed by Mr. Faust was in 2024 because Agent Bigham put that idea in his mind is completely untrue. It is completely false. Agent Bigham was reminding someone, as they would do for any witness in any case that had taken 23 years for them to talk to them for the first time, of the fact that, hey, at the time you said this, okay? And if Mr. Melton was trying to make up a story in order to make things make sense, then he would have just followed their direction. But here's the really interesting part about that. They were wrong at the time, and they just didn't know it yet as far as where the DNA was found, okay? And Mr. Cruz, although he's saying to you that he doesn't want to follow any conspiracy theories and that conspiracy theories are about reasonable doubt, is also trying to tell you that the time that the police and the crime lab were able to determine that what they thought about where the DNA was came from Agent Bigham, that's not true at all. You heard Ashley Hinkle testify on May 10th, the day after they interviewed Mr. Faust. The day after, they go back and they get a known sample. They take the known sample to the crime lab and they run it. And then what did Ms. Hinkle tell you? She's got these two things that are both labeled as oral swabs, but they're showing different results on profile. So what does that indicate to her in the context? Context is important of what we know about the rest of the evidence. We know from the medical examiner's report that there were vaginal, oral, and anal swabs taken. So I've got these two oral swabs. They're showing different results. This says that there are oral, vaginal, and anal swabs, and I've got a vaginal smear. Well, then one of these is not an oral swab. It's actually the vaginal swab. Well, how do we figure that out? Agent Bigham did an expert shot. If there were evidence of that, then Mr. Cruz has the ability to present it. No obligation, but the ability to, but there's not. They want the specter of things that they know not to be true. And so Agent Bigham takes the direction of the crime lab that says you should go see these people at Pure Gold. They're good at what they do, and they do it for all sides. And she sent the samples to Pure Gold. So we've got the two oral samples, and we'll talk about, go to the next slide. No, you're fine. Oral swabbings A, which was 2J at the crime lab. The profiles identified the first fraction skin cells.
Yes, sir.
Kira Sims, she's a GBI crime lab scientist who testified that the first fraction skin cells, second fraction sperm, the first fraction matches Tara Baker. That makes sense. These are swabbings that are taken from the person of Tara Baker. Second fraction, Chris Melton, 1 in 8 octillion, Edrick Faust, 1 in 70 billion. So Mr. Melton's fraction longer, both, they're about, I believe, 7 or 8 billion people on the planet Earth. So just to put some context on that. Oral swabbing A when it gets to pure gold forensics. Okay. What does pure gold forensics do? They do a saliva test, a scientifically accepted test to determine where oral swabbings A came from. All right? It is positive for vaginal epithelial cells. So now it's negative for saliva and positive for vaginal epithelial cells. So now we know that oral swabbings A, which is item J, and this is the part where, we got to figure out a new way to label things, I think. But oral swabbings A, which is item J, is an item that is the vaginal swabbings. Science led us here. Science identified the issue, science clarified the issue, because science is always advancing and science is objective. Mr. Cruz says that you should follow the science, but then he's trying to distort for you what the science did and how we got here. As it relates to oral swabbing B, which is crime lab item 2I, profile first fraction skin cells, second fraction sperm, first fraction matches Tara Baker. That makes sense. It comes from Tara Baker's person. Second fraction is placed into CODIS. That's the National DNA Database. On April 30th of 2024, Mr. Faust is identified as the major contributor. 1 in 30 octillion. A number that it's really, it's hard to put a number that large into context, but a number so large as to, have a number of zeros behind it that I've never seen in any other context than DNA testing. Oral swabbing B, same thing, same process that they get put through pure gold. Even though we've already identified that oral swabbings A is vaginal, from the vaginal epithelial cells and from the non-presence of saliva, go through the same process with oral swabbing B. We're not going to make an assumption here. Positive for saliva, and then positive for human amylase, which is a compound primarily found in saliva and consistent with saliva. That's how we separated these two things. It has nothing to do with what needed to happen in order for an investigation to move forward or anything along those lines. Those are the types of conspiracy theories that Mr. Cruz himself has already told you is not reasonable doubt, but signaled the desperation of the defense to create and manufacture some doubt. Now, Mr. Cruz did ask Ms. Sims on cross-examination if she was aware that the GBI had done a test that showed that there was no sperm. What he failed to give her was the context that this was a test done in 2001 with completely different equipment than what they do use right now. And, Miss Sims is probably younger than I am. And so, I doubt that she has any familiarity besides reading in a textbook what the GBI was doing back in 2001. But we brought in Dr. Jennifer Coursey to testify. I was afraid for a minute I was going to mess up her last name there, but I think I got it right. To testify about the testing that they did do at the time. And yes, it was not positive at the time, but it was a less sensitive test than what they have available now. And that's what led to Mr. Faust. Not anyone trying to pin anything on anybody, but on April 30th, and I think it's important for you to keep this in mind, on April 30th, the GBI had an indication that they knew who had killed Tara Baker. But they didn't go arrest that person immediately. What they did is start to scour the case file again. Did we miss something that Edrick Faust and Tara Baker were connected in some kind of way? Did we miss something? Like, let's look through. And they spent 9 days before they arrested Mr. Faust, someone who had committed one of the most brutal murders in the history of Athens-Clarke County. They spent 9 days trying to run down any explanation they could possibly conceive of through the largest case file in one of the most thoroughly investigated cases in the history of the state of Georgia. And they couldn't. They couldn't establish one link between the two of them, because until the morning of January 19th of 2001, there was no link between Edrick Faust and Tara Baker, other than she lived close and he saw one car in the driveway. After that, they re-interviewed Ashley Hall. They re-interviewed Valerie Lowe. They re-interviewed Chris Melton, who was in the middle of watching his father, who was very close to die. His father passed away about 2 weeks after he was re-interviewed. They ended up, over the course of this investigation, as Agent Bingham testified to, re-interviewing about 30 witnesses, trying to make sure that they did as thorough a job as they possibly could. And then Mr. Faust was arrested, and he was given an opportunity to explain any connection he could have possibly had to Miss Baker. He denied initially knowing anything about a murder in that area. And think about this. This is a place where he had lived for 40 years. They've been talking about Deer Park throughout the interview. And then they're talking about a murder. And then all of a sudden, he says, oh, you're talking about that murder oh yeah, the law student at UGA who lived right over there. Oh yeah, now I know what you're talking about, but I don't know anything about her. I saw her in the newspaper, but I don't know anything about that or anything else. They asked her, you ever had any contact of any kind with her? No, none. And then came the moment when he was confronted with something that he knew he couldn't explain without telling the truth. And that's that his DNA was inside Miss Baker's body, inside of her home. And he was asked by Agent Howell, help me understand. I'm here to exonerate just as much as I am to hunt. Help me understand. And his response was, take me to jail. Because he knew at that point that he had finally been caught. The next day, we've already talked about Agent Howell and Agent Bingham took the sample of Mr. Faust's DNA pursuant to a search warrant. They submitted that to the GBI crime lab, and that's when this issue with oral swabbings being mislabeled as vaginal swabbings was identified. We've talked about this manufactured doubt, the hair envelope versus the slides, the keys and the locks, Josh and Chris being friends from high school, which was completely untrue, trying to distort the way in which the DNA was mislabeled and claiming that people somehow moved DNA around, which is just a red herring conspiracy theory, the mischaracterization of what hair was. Because in the mitochondrial DNA, Mr. Cruz specifically was asking questions about whether or not Mr. Melton could be excluded. He's completely leaving out the fact that Miss Hall, who was also a roommate of Miss Baker's, also couldn't be excluded. The bodies on Tara's hair, I think it's on Tara's body, the hairs on Tara's body. I got it out the last time. The hairs on Tara's body are really important here because I think they put Chris's hair on the power transformer box in context. Both of Tara's roommates were found to have hairs on Tara's body, okay? And I think that's important for context about the hair on the power transformer box because it gives you an idea of how prevalent hairs from people who are normally in and out of a residence are. Obviously Miss Hall and Miss Lowe had nothing to do with Tara's murder. And I think obviously once you look at all the evidence, Chris Melton couldn't possibly have committed the crime. And so it's important when you're looking at that single piece of evidence to look at the totality of the evidence. The defense wants you to pick little things and look at them in isolation rather than looking at all of the evidence together. Here's another thing about the evidence that I think is really, really important. It has to do with Ashley Hinkle's testimony, which is being mischaracterized by the defense. Mr. Melton's DNA is in Tara's vagina, okay? Only Mr. Faust's DNA is in the mouth. Mr. Melton and Mr. Faust's DNA is in the vagina. And then Mr. Melton's DNA is found at a rate, and I want you to think, again, totality of the circumstances, 1 in 60,000 as opposed to billions and octillions in the anal swabbing. What Ms. Hinkle testified is that that timer resets with penetration. She's not talking about penetration of the anal cavity by Chris Melton. What she's talking about is there's a 7-day detection timeline in the vagina. So when Mr. Faust rapes Miss Baker vaginally 5 days after Mr. Melton and Miss Baker have had sex at her parents' house, that is the point at which the timer starts, when Mr. Faust has committed the rape. That's when it resets to, not this point middle of the week or that Saturday before. That's not what she was testifying to. That's not what the evidence is. And I would submit to you that when you're talking about matches in the tens of billions, 70 billion and octillions, and then you're talking about a fragment or a sample of DNA so small that it reduces to 1 in 60,000, you're talking about the type of DNA sample that comes from transfer or from drainage after a rape has occurred by Mr. Faust. That's completely consistent with the physical evidence. Mr. Cruz has tried to make a big issue out of Mr. Melton's hands. We've already talked about Bill Ricketts said, no, those injuries were not there on the 19th. But also think about how what Mr. Cruz has told you about the manner in which those injuries arrived on Mr. Melton's hands is not accurate. The strangulation did not occur with Mr. Melton's hands. They occurred with a ligature that Mr. Faust was using. And what did Dr. Falzon tell you about where hands would be for a ligature strangulation? It was very quick. I saw a lot of people taking notes. A ligature strangulation, the hands would be on the sides because you were pulling the ligature tight. So this, which is what Mr. Cruz described for you, is wholly inconsistent with both the fact that she was stabbed from behind, likely the first injury when she was caught by surprise, had her head smashed against likely the bedpost, and then is on the ground semi-conscious being strangled. That's why there's no DNA except for her own underneath her fingernails, because she was largely incapacitated so early during this attack. That's why there aren't claw marks in Mr. Melton's face if she had been pulling at his hair wildly, as Mr. Cruz needs you to believe in order to show that his client didn't commit these crimes. He needs you to ignore the evidence. The reason that we asked y'all whether or not you believe that individuals, there's one right way to respond to trauma, is because, people respond to trauma in all kinds of different ways, okay? And I don't know if responding in a way that's different than what the majority of people would do is something that has really any evidentiary value that outweighs what the physical evidence and what other people are saying about the location of people tell us. Sorry, I took a lot of notes. There's been a lot made of the fact that we met with witnesses before trial. I mean, I'm unaware of any trial that's ever been conducted, certainly in a 25-year-old cold case homicide, where you wouldn't meet with the witnesses before you called them up to the witness stand. I mean, frankly, I'd fire anybody in my office who had a murder trial where they didn't meet with witnesses. So again, you can consider that in whatever capacity that you want, but it is a routine and expected practice, and it's basically malpractice not to talk to people before you call them as a witness in a trial. But again, that gets back to this, needing to throw these conspiracy theories out there. Mr. Melton's hands, why would you fingerprint him? The same reason that they collected hair samples from Valerie and Ashley and everybody else that's in and out of the house on the regular basis. It's so that if you have something, you have elimination samples. That was testified to during the course of the trial. Again, mischaracterizing the power transformer box as a murder weapon. It wasn't. I think all of these mischaracterizations, I think you should take in context of Mr. Cruz's own statement about if a person's not straight with you one time, then you're done with them forever. I mean, I think the defense has not been straight with you plenty of times during the course of this trial.
Okay, I'm going to overrule your objection. You may continue, Mr. Yellman-Chili.
And Mr. Cruz is absolutely correct that Mr. Faust has no obligation to explain his DNA. I mean, he doesn't have an obligation to do it. He can't without admitting that he committed this crime. I agree with him that the state has the burden, and, it doesn't ever shift to the defense, and they don't have to prove anything. But he was given an opportunity to explain his DNA in his interview. And what he told police, what he told the GBI is just take me to jail. And that's because there is no obligation. Will you cue up the video?
Which number is that, the last one?
Man, it's been a long time. We've made so many advancements and things. If you can help us understand why your DNA is in that house, help us. I don't want to put your finger. Help us. I'm here to exonerate just as much as I am to hunt.
Y'all come on, take a little DNA.
Ladies and gentlemen, we've done everything we can with this case. It's gone through generations of police officers. We've run down everything we can with modern technology, and we've given you everything that you need to find Mr. Faust guilty beyond a reasonable doubt for each and every one of the offenses in this indictment. But my time with this pen is over. I can't write the last chapter. That's yours to do. Tara Baker was the kind of person who tried to bring happiness and joy to everyone in her life, everyone that she interacted with. She was someone so driven that she graduated with 2 degrees in 3 years. She was someone that had her entire life ahead of her, a life that she wanted to dedicate to helping people and making this world just a little bit better, one client at a time. And her loss isn't just a tragedy for her family. Her loss isn't just a marker that changed their lives forever. It's a loss for all of us. It's a loss for everyone in this community. It's, if she had settled somewhere else after she finished law school, it's a loss for that place. It's a loss for the world. And there's no measure of justice that we can provide that will change that. But what we can do and what we must do is speak the truth. That's what the word verdict means. It means to speak the truth. And the truth here is that Edrick Faust committed this horrific crime, that there was no connection between the two of them. There is no evidence of that whatsoever. And I'm asking you not to manufacture evidence the way that the defense has attempted to manufacture evidence in this case. Trust what you heard in the evidence from the witness stand and return that verdict that speaks the truth. And the truth is that Mr. Faust is guilty of each and every offense in this indictment. Thank you.
All right, thank you, counsel, for both parties. Ladies and gentlemen, it is now the court's responsibility to give you the charge in this case, which is the law. And what I'm going to do is to read it to you, but I'm also going to give you a copy of the law. I'm going to ask Mr. Terrell to pass out the charges to each and every one of you. You don't have to follow it as I speak to you, but you certainly can. Counsel for both parties has the copy as well, and when you have it, I'm going to begin. Everybody have a copy? Everybody have a copy? We have a couple extras. I think everybody's ready. All right, very good. Thank you very much. This is the State of Georgia versus Edrick Lamont Faust, SU 24 CR 0547. These are the jury charges. You are considering the case of the State of Georgia versus Edrick Lamont Faust, Athens Clarke County criminal case number SU 24 CR 0547. The grand jury has indicted the defendant with the offenses of malice murder, felony murder, felony murder, felony murder, felony murder, burglary, aggravated sodomy, rape, aggravated assault, aggravated sodomy, arson in the first degree, and possession of a knife during the commission of a felony. The indictment reads as follows, count 1 of 12. In the name and behalf of the citizens of Georgia, do hereby charge and accuse Edrick Lamont Faust with the offense of malice murder, for that the said accused in the county of Clarke and state of Georgia, on or about the 19th day of January 2001, did unlawfully and with malice aforethought cause the death of Tara Baker, a human being, by strangling her with a cord and stabbing her, in violation of OCGA Section 16-5-1A, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2 of 12. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, do further charge and accuse Edrick Lamont Faust with the offense of felony murder for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did unlawfully, while in the commission of a felony, to wit, burglary to a dwelling, as alleged in count 6 of this indictment, cause the death of Tara Baker, a human being, by strangling her with a cord and stabbing her, in violation of OCGA Section 16-5-1C, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3 of 12. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Edrick Lamont Faust with the offense of felony murder for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did unlawfully, while in the commission of a felony, to wit, aggravated sodomy, as alleged in count 7 of this indictment, cause the death of Tara Baker, a human being, by strangling her with a cord and stabbing her, in violation of OCGA Section 16-5-1C, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4 of 12. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Edrick Lamont Faust with the offense of felony murder for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did unlawfully, while in the commission of a felony, to wit, rape, as alleged in count 8 of this indictment, cause the death of Tara Baker, a human being, by strangling her with a cord and stabbing her, in violation of OCGA Section 16-5-1C, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5 of 12. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Edrick Lamont Faust with the offense of felony murder for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did unlawfully, while in the commission of a felony, to wit, aggravated assault, as alleged in count 9 of this indictment, cause the death of Tara Baker, a human being, by strangling her with a cord and stabbing her, in violation of OCGA Section 16-5-1C, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 6 of 12. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Edrick Lamont Faust with the offense of burglary for that the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did unlawfully and without authority enter into and remain in the dwelling house of Tara Baker with the intent to commit a felony therein, to wit, aggravated sodomy and rape, in violation of OCGA Section 16-7-1, contrary to the laws of said state, the good order, peace, and dignity thereof. Further, as to count 6, the identity of Edrick Lamont Faust as the perpetrator of the crime alleged was unknown to the state of Georgia until April 30th, 2024. Count 7 of 12. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Edrick Lamont Faust with the offense of aggravated sodomy for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did perform a sexual act with the person of Tara Baker involving the sex organ of Edrick Lamont Faust and the mouth of Tara Baker, said act having been performed with force and against the will of Tara Baker in violation of OCGA Section 16-6-2, contrary to the laws of said state, the good order, peace, and dignity thereof. Further, as to count 7, the identity of Edrick Lamont Faust as the perpetrator of the crime alleged was unknown to the state of Georgia until April 30th, 2024. Count 8 of 12. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Edrick Lamont Faust with the offense of rape for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did have carnal knowledge of Tara Baker, a female, forcibly against her will, in violation of OCGA Section 16-6-1, contrary to the laws of said state, the good order, peace, and dignity thereof. Further, as to count 8, the identity of Edrick Lamont Faust as the perpetrator of the crime alleged was unknown to the state of Georgia until April 30th, 2024. Count 9 of 12, and the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, further charge and accuse Edrick Lamont Faust with the offense of aggravated assault for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did make an assault upon the person of Tara Baker with a deadly weapon, to wit, a knife, by stabbing her in violation of OCGA section 16-5-21A2, contrary to the laws of said state, the good order, peace, and dignity thereof. Further, as to count 9, the identity of Edrick Lamont Faust as the perpetrator of the crime alleged was unknown to the state of Georgia until April 30th, 2024. Count 10 of 12, and the grand jurors aforesaid in the name and behalf of the citizens of Georgia further charge and accuse Edrick Lamont Faust with the offense of aggravated sodomy for that the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did perform a sexual act with the person of Tara Baker involving the sex organ of Edrick Lamont Faust and the anus of Tara Baker. Said act having been performed with force and against the will of Tara Baker, in violation of OCGA section 16-6-2, contrary to the laws of said state, the good order, peace, and dignity thereof. Further, as to count 10, the identity of Edrick Lamont Faust as the perpetrator of the crime alleged was unknown to the state of Georgia until April 30th, 2024. Count 11 of 12, and the grand jurors aforesaid in the name and behalf of the citizens of Georgia further charge and accuse Edrick Lamont Faust with the offense of arson in the first degree for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did knowingly damage by means of fire the dwelling house of Tara Baker located at 160 Fawn Drive, Athens, Georgia without said owner's consent in violation of OCGA section 16-7-60A1, contrary to the laws of said state, the good order, peace, and dignity thereof. Further, as to count 11, the identity of Edrick Lamont Faust as the perpetrator of the crime alleged was unknown to the state of Georgia until April 30th, 2024. Count 12 of 12, and the grand jurors aforesaid in the name and behalf of the citizens of Georgia further charge and accuse Edrick Lamont Faust with the offense of possession of a knife during the commission of a felony for the said accused in the county of Clark and state of Georgia on or about the 19th day of January 2001 did unlawfully have on and within arm's reach of accused's person a knife having a blade of 3 or more inches in length during the commission of a felony against and involving the person of another, to wit, malice murder, in violation of OCGA section 16-11-106, contrary to the laws of said state, the good order, peace, and dignity thereof. Further, as to count 12, the identity of Edrick Lamont Faust as the perpetrator of the crime alleged was unknown to the state of Georgia until April 30th, 2024. Now, you'll have a copy of the indictment with you when you go out into the jury room, and you'll be able to read that indictment once you begin your deliberations. To this indictment, the defendant has entered a plea of not guilty, and this makes the issue which you have been empaneled and sworn to try. I caution you that the fact that this defendant has been accused is no evidence of his guilt. You should not consider the indictment as evidence or implication of guilt, and neither is the plea of not guilty to be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence which is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove his innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, a conflict in the evidence, or any combination of these factors. After giving consideration to all the facts and circumstances in this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. The law provides that criminal actions shall be tried in the county in which the alleged crime was committed. Venue, that is, that the crime was committed in Athens-Clarke County, is a jurisdictional fact that must be proven by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue may be proven by direct or circumstantial evidence or both. It is my duty and responsibility to ascertain the law that applies to the case and to instruct you on the law by which you are bound. It is your responsibility to ascertain the facts of the case from all of the evidence presented. It then becomes your duty and responsibility to apply the law that I give you in this charge to the facts as you find the facts of this case to be. The defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent. But you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any facts which are put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during the trial and stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. Evidence does not include the indictment, the plea of not guilty, opening or the closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into a stipulation that has been approved by the court about State's Exhibit 113, a photograph of defendant as he existed on February 8, 2001. Where parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Where parties stipulate exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence, from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on direct evidence, circumstantial evidence, or both, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence, nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Burglary to a dwelling, aggravated sodomy, rape, and aggravated assault are felonies, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of burglary to a dwelling, aggravated sodomy, rape, or aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For burglary in the first degree, the state must prove that the defendant, 1, entered into and remained in the dwelling of someone else, 2, without authority, and 3, with intent to commit a felony. Aggravated sodomy and rape are felonies, which I will define for you shortly. A dwelling includes a house or any building or structure that is designed or intended to be used as a residence. A dwelling also includes any part of that house, building, or structure. It doesn't matter if the dwelling was occupied, unoccupied, or vacant when the alleged burglary happened, but you may consider these factors in deciding if the dwelling was meant to be used as a residence. To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This, quote, breaking of the plane, end quote, must be done by the defendant. The state does not have to show there was an actual break-in to prove burglary. For rape, the state must prove that the defendant, 1, had carnal knowledge, 2, of a female, 3, forcibly, and 4, against her will. Carnal knowledge means sexual intercourse, which is any penetration, no matter how slight, of the female sex organ by the defendant's male sex organ. Force means acts of physical force, threats of harm, or intimidation. Against her will means without her consent. For aggravated sodomy as charged in count 7 of this indictment, the state must prove that the defendant, 1, forcibly, and 2, against the will of a person, 3, engaged in a sexual act, 4, involving the sex organs of one of them, and 5, the mouth of the other. Force means acts of physical force, threats of harm, or intimidation. Against the will means without the alleged victim's consent. For aggravated sodomy as charged in count 10 of the indictment, the state must prove that the defendant, 1, forcibly, and 2, against the will of a person, 3, engaged in a sexual act, 4, involving the sex organs of one of them, and 5, the anus of the other. Force means acts of physical force, threats of harm, or intimidation. Against the will means without the alleged victim's consent. The state must prove that the alleged victim did not consent to the aggravated sodomy. If you find that the victim submitted to this alleged act only because of fear or intimidation, or because of force the defendant used, then you may find that the act occurred without the victim's consent. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A knife is a deadly weapon. A person commits the offense of arson in the first degree when, by means of fire, he knowingly damages any dwelling house of another without his or her consent. The burden rests upon the state to prove beyond a reasonable doubt that 1, the building described in the indictment was damaged by fire, 2, the burning was caused by a criminal act, and 3, the accused was the person doing the burning. The law presumes every fire to be accidental or naturally caused until the state shall prove beyond a reasonable doubt that such fire was the result of a criminal act. A criminal act will not be presumed, and the burden is upon the state to overcome the presumption that the fire was accidentally or naturally caused by proof of the criminal act beyond a reasonable doubt. For possession of a knife during the commission of a felony, the state must prove that the defendant, 1, had a knife, 2, with a blade at least 3 inches long, 3, on his person, 4, while committing malice murder, which is a felony, which is a crime against another person. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his or her constitutional rights. To be voluntary, a state must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. The burden of proof is upon the state to establish that the statement was voluntary, The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1. The defendant had a right to remain silent. 2. If the defendant chose not to remain silent, anything he said could be used as evidence against the defendant in court. 3. The defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questions. And 4. If the defendant did not have money for a lawyer would have been provided for him/her to represent him before any questioning and to be present with him during any questioning. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility or believability and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for the offenses of malice murder, felony murder, felony murder, felony murder, felony murder, burglary, aggravated sodomy, rape, aggravated assault, aggravated sodomy, arson in the first degree, and possession of a knife during the commission of a felony. Under Georgia law, prosecution for the offenses of burglary, aggravated sodomy, rape, aggravated assault, aggravated sodomy, arson in the first degree, and possession of a knife must begin within 4 years after the offense has been committed. In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that the person committing the crime was unknown. The burden is on the state to prove that the offense occurred within the statute of limitations or occurred within an exception beyond a reasonable doubt. Now, ladies and gentlemen, as to each of the 12 counts of this indictment, after considering the testimony and evidence presented to you, together with the charge of the court, if you find and believe beyond a reasonable doubt that the defendant in Athens, Clarke County, Georgia, did on the date alleged commit any or all of the offenses alleged in this indictment, then you would be authorized to find the defendant guilty on each count. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty on that count. as to each of the 12 counts of this indictment. If you do not believe the defendant is guilty of any or all of the offenses charged, or if you have any reasonable doubt as to the defendant's guilt on that count, then it would be your duty to acquit the defendant as to that count, in which event the form of your verdict would be, we the jury find the defendant not guilty on that count. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. By no ruling or comment which the court has made during the progress of the trial has the court intended to express any opinion upon the facts of the case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of this defendant. Whatever your verdict is, it has to be unanimous, that is, agreed to by all 12 jurors. It must be signed by one of your members as foreperson, dated and returned to be read out loud in open court. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. So, ladies and gentlemen, in one moment, you may retire. You may now retire to the jury chambers. Go ahead and elect a foreperson. You may take your notes with you, but please do not begin your deliberations until you have received the copy of the indictment, the verdict form, and the evidence in this case. So if you'll go ahead and gather in the jury chambers, elect a foreperson, and we will give you all the evidence in one moment. And as for the alternates, if you will gather your belongings and meet the court at the front of the bench for further instruction. Mr. Bailiff, you may take the jury to the jury room. Thank you.